Seeking for grant of that land.
Yes, my lord. Already the honorable state has been granted the land, my lord, with respect to the petitioner's mother, my lord. We are in position from past 70 years in that particular
That
land.
was heard last time, isn't it?
Yes, my lord.
Yes, yes.
Yes, my lord.
The
The CDP was directed to issue demand notice, my lord, as per the order dated 13/2/2024, my lord, of this honorable court. 13/2/2024.
Between the temple and.
Yes, my lord. Yes, my lord.
It has been divided between the two of
So
you.
two
Yes, my
crores.
lord. Yes, my lord.
And your property should commence from, where's that sketch?
Sketch, my lord, we have prepared another sketch, my lord, recent.
Engineer ಬಂದಿದ್ದಾರೆ sir.
ಈ petition pending ಇದ್ರೆ ಇನ್ನು 4 sketch ಬರುತ್ತೆ ಇವಾಗ.
Lord, may I request, my lord.
Most ample submission,
Okay.
as far as the respondent number 5 is concerned. Is there a copy?
No, 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 petition.
Open it, one person.
Where is that allotment?
My lord, it is at
There is no allotment, it's a government order, my lord, annexure B.
Next year?
Annexure B, my lord. Sketch number 20.
This sketch that was there, annexure K.
Annexure
Yes, my
B,
lord.
page
Annexure
16.
K, my lord. It was the sketch which was produced at the time of allotment, my lord. Annexure K.
Hmm.
White memo dated 22/2024, my lord.
Seventeen into 8 feet 9 inches.
Yes, my lord.
That is allotted to.
Allocated to
Pushpama.
the petitioner in first petition, my lord. The mother of petitioner, my lord.
Lata's mother.
Lata or mother.
Then 15/22 in favor of Swaminathan.
Respondent number 5.
Respondent number 5 in the same petition.
His son is petitioner in the connected matter. Kannan.
ಈ sketch ಅಲ್ಲಿ ಯಾವ್ದದು?
His sketch, property C. Property A is is allotted to Lata, Pushpa. And she has encroached a portion of property of petitioner in
ಈ
connected.
ಸ್ವಾಮಿನಾಥನ್ ಪ್ರಾಪರ್ಟಿ ತೋರಿಸ್ತಿರಲ್ಲ.
Course,
15 into
That is
27.
property C ಅಂತ ಇರೋದು Swaminathan portion.
ಅದು allot ಮಾಡಿರೋದು.
Allotment,
No, no,
that has been
sale deed has been executed.
encroachment. Property B ಅನ್ನೋದು Lata has encroached that proportion.
No, if Swaminathan is already granted the property, executed a sale deed in favor of this, please, property C. So the government order insofar as he is concerned is completed.
No,
Complete.
there is shortage. We have executed sale deed in exit.
Exit ಇದು.
That is encroached portion, she has to leave, my lord.
Lord,
That is the problem.
The measurement mentioned, my lord, it is
No,
15
it
into
is
22.
stated as 15/22, right?
It is 19/19 model.
ನಿಮಿಷ ಇರ್ರಿ, I mean, asking him. Swaminathan was allotted 15/22.
Yes,
The sketch that you have now produced.
Yes.
Indicates that the property in his possession is 19 feet into 19 feet.
no, that includes a portion encroached by Lata.
The green
Aroma.
portion is the property.
Green portion that doesn't measure 19 feet 3 inches.
And what is the measurement that you have given? 19 feet.
ಇಲ್ಲಿಂದ
ಅಲ್ಲ.
1.9 inches ಆದ್ಮೇಲಿಂದ ಈ ಎಂಡ್ವರೆಗೂ ಬರುತ್ತೆ.
There's a small arrow marking below, my lord.
No, but he's entitled only by 15, isn't it? 15/22.
15 is east west. And north south is 22.
Then you shown in this sketch as 19 feet east west.
ಅದೇ ಶಾರ್ಟೇಜ್ ಇದೆ. 2
ಜಾಸ್ತಿ
feet
ಆಗತ್ತಲ್ವಾ?
ಅಲ್ಲ 2 feet ಶಾರ್ಟೇಜ್ ಬರುತ್ತೆ. North south it should be 22 feet. 19.3 ಇದೆ. ಇದರಲ್ಲೂ ಕೂಡ she has encroached a portion. Property B ಅನ್ನೋದು that also includes to Swaminathan.
So in to the, you're saying in the striped portion, 2 feet should be given.
No, that encroached portion complete should be given. Even then there will be shortage of 2 feet.
That's what I'm unable to understand. The government order indicates
Yes,
17 feet into 8 feet 9 inches, there's no difficulty, blue portion.
yes.
Apart from that particular position, Swaminathan will be entitled to 15/22.
15/20.
15 is northwest, not
East west.
then from the edge of this property, 22 feet.
22 feet should be there, but there is shortage of 2 feet, my lord. But on western side, there is additional 4 feet of place is there. We can use that property, my lord.
ಯಾರು?
Swaminathan can use, that will make up the 2 feet difference. my lord.
ಎಲ್ಲಿದೆ passage?
Passage, there is some space available behind this property. And we can't use that property now.
Beyond, where is that? for?
Western side, no. Yeah, western side.
That is
it measures-
behind his property.
Yes, that is, it measures 19 feet. and he is entitled for 15 feet only. There will be in excess of 4 feet there.
What has been done here in this encroached portion?
Encroachment, there is some vacant space and she has built up, I've produced the photograph also. She has covered it with sheet metal and she has put up a small compound in front. Page 4, kindly see that it shows both the properties. Vacant space is Swaminathan's portion.
Now, this vacant portion measures how much now?
Existing, it is less, that is, it is shortage by 5 feet more. That is encroached by Lata. She has put up,
Then where is the 4 feet extra that you are talking about?
that is behind the
Lane on compound is that?
compound is there, Kali is there. That entire depth is vacant. Up to that wall, you can use that. There will be some 4 feet space will be there, my lord, in excess. That is, it measures 19 feet. We can't use that property at all. There is no access to that portion.
I want to know what is the exact property remaining after this, this vacant site area,
Oh, God.
which is shown in this photograph.
Ah.
What is the exact extent available there?
It is 19 feet by then some, that is 4 feet is 5 feet over 14 feet 3 inches and above.
No, can't you give me the extent that is available?
The vacant humble submission. The
Is-
Engineer is here.
What is the exact extent of this vacant space shown in the photograph?
ಇದ್ರಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ.
ಖಾಲಿ ಜಾಗ ಎಷ್ಟು? ಜಾಗ ಎಷ್ಟಿದೆ? ಖಾಲಿ ಜಾಗ. ಏನ್ ಮಾಡಿ
ಸರ್ ಇದ್ದಿದೆ ನೋಡಿ 8 feet 7 feet ಇರ್ಬೇಕಿದ್ದು ಫಸ್ಟ್ ಇವ್ರದ್ದು
ಈ ಪೋರ್ಷನ್ ಎಷ್ಟು
ಈ-
ಮಾಡಿದ್ದೀರಾ
ಇದ್ರಲ್ಲಿ ಬರೋಲ್ಲ ಸರ್ ಇದು ವೇಕೆಂಟ್ ಸೈಟ್.
And is it that complicated for them to?
Yeah, it appears she has not measured the second portion.
No, because the sketch that you have now produced,
13 feet. 13 feet by 19 feet.
ಇದು
South.
ನೀವೇ ಹಾಕಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ ಫಸ್ಟ್.
North south it measures 13 feet, my lord. East west measures 19.
north south measures,
13 feet.
no, this I am not able to understand.
Yes,
In property A,
yes.
you have shown that there is some, there is an L-shaped vacant space available.
No, there is no vacant space.
This property B that is shown,
That is encroached by Lata. That is petitioner in the first petition. That
even the, no, even the portion in front she has encroached.
front is footpath, my lord, that is.
No,
she has
is it-
encroached.
In this particular sketch that you have shown,
Yes,
there is some space in front of this,
front portion shown encroachment is footpath, part of the footpath.
Now this property B,
Please, that is encroached
we'll
by.
forget about the L portion. Just that portion in between property A and property C. What is the width of the property? What is the length of the property?
7 feet, 19 feet.
7 feet, I know.
7 feet by 19 feet. North, south, 7 feet. The east, west is 19.
There's another memo filed before this court.
ಅಲ್ಲ,
but-
very
Okay. For reference, ಅವ್ರಿಗೇನ ಬೇಕು ಅಂದ್ರೆ.
And what is the property allotted to him? 15 by 22.
22 feet.
15 is north south, huh?
15, ಅಲ್ಲ, 22 feet is north, south. East, west is 15.
And this green portion, what is the extent that is actually available there?
Still available is 13 feet by 19 feet.
13 feet?
By 19 feet. It is north, south is 13 feet. East, west is 19.
East west is 19, huh? North south is 13, correct?
Correct.
He's entitled for 15 by 22.
Yes.
What about the front portion? There is on 4 feet 6 inches.
That is borewell is that belongs to corporation. It is part of footpath.
So the only thing is, instead of 13 feet, 2 feet, they have to demolish.
Oh, it is
Now
9
for
feet.
it-
9 feet has to be
For
demolished.
Swaminathan to get 15 feet.
Huh?
East to north to south.
North to south, 22 feet.
Okay, 22.
North side.
But actually, how much is he there in? 19, huh?
Now,
13.
actually, this 13 feet is there and remaining portion is encroached by Lata.
So 7 feet ಕೊಟ್ರು ಇನ್ನು ಕೊಡ್ಬೇಕಾ?
ಇನ್ನ 2 feet shortage ಬರ್ತಾರೆ. That can be compensated on western side of the property. Actually, there is no space at all.
ಬಟ್ ಲೆಂತ್ ಜಾಸ್ತಿ ಆಗುತ್ತಲ್ಲ ಇದಂದ್ರೆ ಈಸ್ಟ್ ವೆಸ್ಟ್ ಅವ್ರಿಗೆ
ಅದೇ ಜಾಸ್ತಿ ಆಗುತ್ತೆ, ಅದು ಕಾಂಪನ್ಸೇಟ್ ಆಗ್ಬೋದು ಅಂತ ಅಷ್ಟೇ.
ಈಸ್ಟ್ ವೆಸ್ಟ್ 19 ಇದೆಯಾ?
19 ಇದೆ, she is entitled for 15 feet.
How much is 13 into 90?
ಮಾಡಿದ್ರು ಬಿಡಿ. Two foot.
247 square feet.
Yes. Whether you like it or not, Swaminathan is entitled to 22 feet
Yes, my lord.
from your property.
Yes, my lord. But my lord, neighbors in the order, they have mentioned that is to north to south or east to west, my lord.
Then I'll direct,
If there is a, my lord, my suggestion, my lord.
you are in possession of 7 feet, 17 feet into 18 feet by 9 inches.
Yes, my lord.
You're entered only to that.
Yes, my lord.
Over your nexus by encroaching footpath also.
No, my lord.
Now you want to
My
go,
lord, there is a photograph, my lord. I have not enclosed a footpath, my lord. Footpath is there, my lord.
either way, even if this sketch is accepted. 17 feet you have length,
Yes, my lord.
8 feet 9 inches width you have.
Yes, my lord.
You cannot have anything more than that.
Yes, my lord. Yes, my lord. My lord, with respect to my lord, the order, my lord, if it is not, if the direction is changed, my lord, everybody will be entitled for the property, my lord. There will not be any excess or any shortage of property, my lord.
But you will be in possession of more than what was allotted to you.
Lord, my lord, the allotment is with respect to the state order, my lord, the copy of the.
My calculation is he is in possession of 13 feet into 9 feet. 19 feet, huh?
13 feet
No,
into
my lord,
19
14 feet,
feet.
actually, my lord, we are in position in 8.9 plus.
He is in possession of,
13
please
feet.
listen, he is in possession of 13 feet into 19 feet.
Yes, my
That works out to 247 square feet. Under the order, government order, he is entitled for 330 square feet. Your entitlement for how much?
lord. For 17 into 8.9.
You're entitled 148 square feet.
Yes, my lord. Yes, my lord.
How much are you in possession of?
But I am in position of 13 feet into 20 feet. my lord.
So roughly 110 square feet, you're an extra.
Yes, my lord.
And he is shortage of about 90 square feet.
Yes, my lord.
Then how can your property be increased and this property be decreased?
Lord, there is an additional property, my lord, in front of the, my lord.
Front of
Borewell
what?
ಜಾಗ ಅಂತ ಬಿಟ್ಟಿದ್ದಾರೆ ಗೊತ್ತಾ?
Huh?
Borewell ಜಾಗ ಅಂತ F street ಗೆ ರೋಡ್ ಕನೆಕ್ಟ್ ಆಗುತ್ತಲ್ಲ.
ಅಲ್ಲ ರೀ, ಯಾರ್ದೋ ಮನೆ ಆಸ್ತಿ ನೀವೇನ್ರಿ ದಾನ ಮಾಡ್ತೀರಾ?
Lord,
ಅಲ್ಲಿ ತಗೊಳ್ಳಿ ಇಲ್ಲಿ ತಗೊಳ್ಳಿ ಅಂತ ಎಷ್ಟು ನಿಮ್ ಜಾಗ ಬಿಟ್ಕೊಡೋಕ್ ರೆಡಿ ಇಲ್ಲ. ಅಲ್ಲಿ ಬೋರ್ವೆಲ್ ಇದೆ, ಅದ್ ತಗೊಳ್ಳಿ ಇದ್ ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ಏನು ನಿಮ್ ಜಾಗನ ಅದು? ಓಕೆ, ನೀವು
Lord, one small commission, my lord. If they are not allotted to 15 into 25 feet, my lord, as per the sketch, my lord, both of them will be in the peaceful position.
you are asking them to settle for a lower price.
No, my lord.
Then what is?
330 square feet ಏನಿದೆ ಅವೈಲಬಲ್ ಅವ್ರು ಕೊಟ್ಟ ಮೇಲೆ ನಾನು ಉಳಿದಿದ್ದು ಕೊಟ್ಟರು ಸಾಕು.
ಅದ್ ಕೊಡೋದಕ್ಕೆ ಅವ್ರು ಕಮ್ಮಿ ಇದೆಯಲ್ಲ ಇವಾಗ 13 ಅಡಿ ಅಷ್ಟೇ ಇರೋದು. 22 ಅಡಿ ಕೊಡೋ ಜಾಗದಲ್ಲಿ 13 ಅಡಿ ಇರೋದು ಅಷ್ಟೇ ಅವ್ರಿಗೆ.
My lord, 3 feet ಇದಲ್ಲ ಸ್ವಾಮಿ, ಫುಟ್ಪಾತ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದಾದ್ಮೇಲೆ ಫುಟ್ಪಾತ್ ಇದೆ.
ಅದ್ರ ಬಿಟ್ಬಿಡ್ರಿ, ಅಗ್ಲ ಹೇಳ್ರಿ. North to south, they are entitled for 22 feet. They are only in push of 13 feet. 9 inches, 9 feet shortage, which is in under your occupation.
Lord, that is the confusion, my lord. If it is 22 by 15, my lord, if the 22 is from west to east, my lord.
ಅದೇ ನೀವ್ ಹೇಳ್ತಿರೋದೇನೋ ರೈಟ್ ರಾಂಗ್ ನಾವ್ ಇದೀವಿ, ನಮ್ಗೆ ಬಿಡಿಸ್ಬೇಡಿ, ಅವ್ರ ಮಿಕ್ಕಿದಲ್ಲಿ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಿರೋದು ನೀವು.
No, my lord, let them occupy the 330 feet which they have already paid, my lord. Remaining extent may be left out, my lord.
ಅದೇ ಹೇಳ್ತಿರೋದು, ರೈಟ್ ರಾಂಗ್ ನ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದೀವಿ, ಬಿಟ್ಬಿಡಿ ನಮ್ನ, ಅವ್ರು ಕಮ್ಮಿ ಮಾಡಿ ಅಂತ.
But in fact, my lord, I was in position from way back from 60 years, my lord.
Both of you are getting this land free of cost.
No, not free of cost, my lord. We are paying the amount.
20%.
More than 20% of the market value.
Both of you committed illegality.
Yes, my lord.
And despite that illegality, BBMP was kind enough to grant it to you. Now you are saying, no, let him take the property there, let him take the property here.
No, my lord, not like that, my lord. My lord, initially I was in position of entire extent, my lord. After that, government said that I'll give you the half of the portion.
You have not challenged that order, that order has become final.
Because the
You
my
settle
notice
for
was-
this? Will you settle for this or shall I order demolition?
First case, my lord, what my learned friend arguing, my lord, he has not paid the amount also. Now he's come and
But
asking
the
for a
demand
demand
notice is
notice.
Dead person.
Illa kotte illa, he's not
100%
entitled for the
demand
title.
ಇದೀರಾ?
Illa, he's not entitled for the title. He's not a title holder at all, my lord. After the government order, my lord, we issued a demand notice. Now he's coming before this court saying that it has been
person
issued to a
is-
dead person. I am
Demand
there.
notice is not before-
It
on
should
the
issue
dead
to the
person.
Let the dead person come and claim, you're
No,
not,
my lord,
you're not.
my lord, I was in position, my lord. I got to the
How are
knowledge,
you
my
related
lord,
to the
and
dead person?
my lord,
How are you related to the dead person?
my mother, my lord.
ಅವ್ರು ಬಿಟ್ಬಿಟ್ಟಿದಲ್ಲ ಬಿಡಿ, ನೀವ್ ಯಾಕೆ
My lord,
ಗೊತ್ತಾಗ್ತದೆ?
my lord, just naming, my lord.
If you undertake to hand over possession
Yes, my lord.
in excess of 8 feet 10 inches
Yes, my lord.
to Swaminathan, I'll direct them to execute the conveyance deed in your favor after collecting the money. Or else I will say, remove you because you have not paid the money from the beginning.
Yes, I accept.
File an affidavit to undertake it.
But I already filed, my lord.
As to what?
On,
So will you demolish or you want the corporation to demolish?
but if they issue demand notice, my lord, I'll pay and register and I'll just
First
mark.
demolish, then I'll ask them to issue a demand notice.
My lord, if it demolished, my lord, will be put in nowhere, my lord. If they did not
Address
issue.
the matter is before this court.
Yes, my lord.
So this court will take care of your interest. Tell me when you will demolish.
But I need to take the,
Then I'll pass an order.
no, my lord, kindly have this matter on Monday, my lord. I'll just speak with the petitioners, my lord, and I'll just.
If you try to act smart,
No, my
you
lord,
will get no relief from me.
I'll inform them, how much time they need to vacate from that place, my lord.
No. How much time ಇದೆ HRC ಕೇಸ್ ಅಲ್ಲ ಇದು?
ಸ್ವಲ್ಪ ಟೈಮ್ ಆದ್ರೂ ಬೇಕು.
ಅವೆಲ್ಲ ಬೇಡ, ಒಂದ್ ವಾರ ಕೊಡ್ತೀನಿ, ಒಂದ್ ವಾರದಲ್ಲಿ ಎಲ್ಲ ಮುಗಿಸ್ಬಿಟ್ಟು ಸ್ವಾಧೀನ ಕೊಟ್ರೆ ಅವ್ರಿಗೆ I'll ask them to immediately execute a sale in your favor. Or else you lose everything. I'm warning you.
Yes, my lord.
Demand, my request for the current market value, my lord.
So ನೀವು
ಅಲ್ಲ.
ಶುರು ಮಾಡಿ ಇವಾಗ.
ಅಲ್ಲ, ನಂಗೆ ಯಾಕಂದ್ರೆ mother died, my lord, mother died, that has not been conveyed to us. Later, once I issue notice for possession,
If you sleep over your.
no, once I've issued notice for possession, then they come and approach before this
How
court.
many years after the order of the government?
My lord, government order, my lord, is at
2002.
2002. I've issued in 2015, my lord.
Where is the order of the government?
Lord, Annexure B, my lord.
Annexure
B, my lord.
2002. I'll ask him to pay interest on that amount. Interest on that amount. Monday, don't try to argue further.
Monday, I'll.
2005.
Monday.
Then ನಾನು ಹೇಳ್ತೀನಿ.
Till number 2, Shri Jagan Mohan.
Your Lordship,
Only ask them to measure the vacant space, exact extent. And the extent that she is in possession of separately and give me the figures.
I appear for petitioner.
Yeah, for the respondent.
Monday, PWD advocate government advocate has taken time to submit his version. I don't know whether he
Lordship,
has
I'm
filed.
filing
any
the
petition.
survey report where they've gone for an inspection. The road exists 40 years back itself. Really, produce the
Nami copy.
sketch also. Copy. ಕೊಟ್ಟಿದ್ದೀನಿ.
What is your claim?
Your lordship will kindly see 15 guntas was without acquiring the Gram Panchayat has formed the road. For widening the road.
What is there to show that you had purchased this?
I have produced the sealed it. Annexure.
Road ಅಂತ.
No, in that particular area, is there an extent of 1 acre 18 guntas? He has purchased 1 acre 18 guntas.
Yes.
Which is bounded on the east by road, west by road, north by Kalkere Krishnappanavara Jaminu, ದಕ್ಷಿಣಕ್ಕೆ ದಾರಿ ಅಂತ ಹೇಳುತ್ತೆ.
ಅದೇ ಆ ರಸ್ತೆನ ವೈಡನಿಂಗ್ ಮಾಡಕ್ಕೆ ನಮ್ ಜಾಗ
ಈ ಜಾಗ ನಿಮ್ ಪ್ರಕಾರ ರೋಡ್ ಇತ್ತು ಒಂದು ದಾರಿ ಇರೋ ರೋಡ್ ಅಂತಿರಲ್ಲ, ಅಲ್ಲಿಂದ ಲೆಕ್ಕ ಹಾಕಿದ್ರೆ 1 ಎಕರೆ 18 ಗುಂಟೆ ಇದೆಯಾ?
ಇಲ್ಲ, ಅದೇ ಅಕ್ವೈರ್ ವಿತೌಟ್ ಅಕ್ವೈರಿಂಗ್ ರೋಡ್.
I've produced a sale deed wherein his vendor had sold. ಅದರಲ್ಲಿ ರಸ್ತೆ ಅಂತ ತೋರಿಸ್ತಾರೆ.
ರಸ್ತೆ ಅಂತ ಒಪ್ಕೊಳ್ತೀನಿ. 205/1, you know the extent. If it is measuring 1 acre 18 guntas, if that was Iduli land, from that either dari or from the road, they are entitled for 1 acre 18 guntas. If there is a lessening of that particular extent, then it's obviously gone to the road.
No, but road exists almost from 40 years and the sketch also clearly shows, the village map also shows it's a road.
You have to pay damages till you acquire it, and from there afterwards you will have to pay compensation, if that is the argument.
No, I'll ascertain what is the extent, exact
Assuming
extent.
that there was a road, you had unlawfully formed the road.
No, the road was not unlawfully formed. It was existing earlier itself.
ದಾರಿ ಅಂದ್ರೆ ಕಾಲ್ ದಾರಿ, 4 ಅಡಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, village map shows road itself.
The sale deed itself, it shows, even if it's
No, they've wrongly mentioned in the sale deed. Sale deed ಅಲ್ಲಿ they have shown it as ದಾರಿ ಅಷ್ಟೇ.
where's the village map then?
ಅದ್ರಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ sir.
ಎಲ್ಲಿದೆ?
22 ಸ್ವಾಮಿ.
Page?
22.
This is, what is this?
One minute.
20s.
DRPP map ಅಂತ ಇದೆ. Village ಇಲ್ಲ, village map ಇಲ್ಲ. In this you won't know whether there is a road or not.
No, your lordship, I've produced the, no, annexure 26 clearly shows it's a road. Page 26, photograph.
Which is the road that you are referring to?
Middle ಸ್ವಾಮಿ.
Not 5 bar?
205/2 ಇದೆಯಲ್ಲ, ಅದ್ರ ಮುಂದೆ ಇರೋದು ಸ್ವಾಮಿ.
Now, where is 205/1?
205/1. No, 205/2 ಅದು.
There is some road existing between 205/2 and 205/5.
ಹೌದು ಸ್ವಾಮಿ.
5, 7, 8 ಅದೆಲ್ಲ.
ಹೌದು ಸ್ವಾಮಿ.
Where is 205/1?
Renumber ಆಗಿದೆ.
As what?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ರೋಡೇ ತೋರಿಸ್ತಾ ಇರೋದು 205/1 ಅಂತ. I'll get the village map, ಸ್ವಾಮಿ.
So if this can't be the road 205/1.
ಅದೇ, I'll seek further instructions on this.
Survey number is assigned to it. It obviously can't, there
ಅದೇ
can be a
ಅದಕ್ಕೆ
road inside that land.
205/1 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. I'll seek further instruction. Your lordship may have this matter on Tuesday. ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀನಿ.
Please.
Tuesday, ಸ್ವಾಮಿ.
21st. Bill number 3, Srimati Parvati Nair.
Appear for the petitioner, my lord. My lord, I request adjournment till Monday, my lord. Senior counsel is due to inconvenience is not up.
What is the matter about?
My lord, the matter is regarding, we have sought for quashing of 2 notifications, my lord.
Next, Q and R.
Annexure Q and P, Q and R, my lord. Annexure Q is, my lord, the fact, my lord, is the.
Take me to annex Q first.
Yes, my lord.
Page number. Enactment.
137. My lord, the annexure Q, my lord, is the,
Where is the order of the legal officer? One?
my lord, he has passed an order state.
What is WP 3831/2020?
My lord, 3831/2021, my lord, is annexure M, my lord, and it relates to mutation, my lord. So what has happened?
Page.
124, my lord.
This was filed by Tyagaraja Reddy. Who are you?
My lord, Tyagaraja Reddy. My lord, what has happened, my lord, is the suit schedule property, my lord, which is in question. Initially, there was we had filed a injunction suit against a third party, my lord, and it came to be a declaration suit which was held in our favor, my lord, claiming we are the owner. Subsequent to that, when we went to the panchayat office to mutate the records, the panchayat claimed the land to be theirs, my lord. For which a declaration suit was filed, my lord, before the trial court in Anekal, my lord, and it came to be held as as me being the owner, my lord.
The suit filed by the panchayat was dismissed. Then how is it that you can refuse Kata? He's got a declaratory decree in his favor. No. So can the EO or the PDO get over an order of the civil court? That is what has been done, isn't it? You register the Kata on the basis of the decree. Pass with the civil court. Yes. If you have any other remedy, go to what? Then all.
1 week's time, plus. See, for what reason we can.
Realist.
My lord, a date may be fixed, my lord, next week.
24th. Number 4. Mati, Sumangala is.
Paper petition. Regarding the. What, clean drinking water unit.
NH here.
It is not operating. Their duty to repair it. But one section of the people are not permitted to repair.
Section of the people,
One section of the people not permitted to repair. Problem.
there who's not allowing them to repair.
ಅದಕ್ಕೆ every time ಅವರು ಹೋದಾಗ ಆಗಬೇಕು. Let the court may direct the authority to repair it.
What do you mean by saying that you don't know who's opposing you?
Some busy.
Because if you were to repair it, they'll again do something.
ನೀವು ಮೊನ್ನೆ ಮಾತಾಡಿ ಮಾತಾಡಿದ ಅದಕ್ಕೆ ನಾನು directing the court, getting the party. But anyway, duty of the authority.
The funds also have been released to.
I need to, ನಿಜ ಏನು ಅಂತ ಅಪೋಸ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತಂದ್ರೆ ಕುಡಿ
ಯಾರು busy bodies, my lord, just they want to use that land for the car parking or something else. How can they do it? Is already installed this one, water unit is there.
It is the duty of the authority to repair it.
You have created this controversy by not repairing it for the past so many years.
All these years, they did not take any action.
If they are ready to repair it.
Either repair or
Repair of-
put in.
Human type of
The grievance of the petitioners is that in the village of Madanalli, there was a water dispensing unit
Muddanalli.
set up by the authorities. And this water dispensing unit was non-functional and was requiring repairs. As a result of which, they submitted a representation. And the same being unconsidered, the petitioner before this court. On the last occasion, this court called upon the council appearing for the panchayat to state as to why the water dispensing unit was not being repaired. So today learned council, Shri B.J. Somaji submits that there was some opposition to the repair of the water dispensing unit and hence the repairs were not conducted. He assures the court that the water dispensing unit would be repaired and made functional so as to enable the villagers to avail of a drinking water facility. In the light of the above, it is hereby directed, ಯಾರ್ ಮಾಡ್ಬೇಕು?
Second response may kindly be limited.
Second response.
Second response ಇಲ್ಲ.
ಇಲ್ಲ ಯಾರ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
I find local third response. Second response not limited.
Who will do the work now?
Gram Panchayat, directly to the
Gram Panchayat.
Video.
That the third respondent who represents the panchayat in such matters shall ensure that the water dispensing unit is repaired forthwith. If there is any opposition, the jurisdictional inspector is directed to ensure that the panchayat development officer is provided with adequate protection to ensure that the water dispensing unit is repaired. The jurisdictional inspector shall also ensure that the persons opposing the repair of the water dispensing unit are restrained from taking any action, and yet if they were to pose or cause impediments to the repair, necessary action be initiated against them. Read this the matter on to report complaints. You will report complaints and then you'll close it. When do you want it? Released on so and so. If the water dispensing unit is not rectified, repaired by then, the PDO should be personally present before the court. ಇರ್ಲಿ ಬಿಡಿ, ಅವ್ರು ಇಟ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಮಾಡೋಣ. ಪರ್ಲೆ ಬಿಡಿ, ಅದು I'll say it's infructuous. Direct the,
Date may be given.
ಕರೆಯಪ್ಪ,
17th February,
ಕರೆಯಪ್ಪ,
17th February,
direct that concerned inspector to. go there
17th
and
February.
ensure that-
19,
Right.
February.
Hello. 17th February.
ಇದು ಯಾವತ್ತೂ ಕೂಡ. ಅವತ್ತು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ PDO ಬರ್ಬೇಕಾಗತ್ತೆ.
Seal number 5, Sri Raja L.
It's appear for the petition. I am challenging the order of annexure K of Tara Panchayati Executive Officer,
Page number?
page number 63. ಇದು 1978 ಇಂದ ನಮ್ದು RTC mutation entry ನಮ್ಮಲ್ಲಿ ಹೊರಟಿದೆ. ಮನೆ ಕಟ್ಕೊಂಡಿದ್ದಾರೆ. ಪೌತಿ ಖಾತೆಯ 2017 ನಲ್ಲಿ ರತ್ನಂ ಹೆಸರು ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಆರ್ಡರ್ is 2022 ನಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
Cancellation of ಖಾತಾ.
ಖಾತವ 17 ನಲ್ಲಿ ಅದು ಪೌತಿ
ಯಾರಿದಾರೆ? ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಗೊತ್ತ ಲಾಯರ್.
ಸೋಮೇಜಿ 1 2 ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1.
ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಮಲವಳ್ಳಿ.
ಎರಡು ಅವರು
Somaji accepts notice for R1 and R2. Issue notice to R3 and R4. Petition is also permitted to take out notice on R3 and R4 personally. In the meantime, there should be an interim stay of next year.
ಕೆ ಮಾಡಿ.
Seal number 6, R.B. Sadashiv.
Let me first submit, my lord, there is nothing more here. Khata has been in my name since 1972. No, they want to change it, against which, my lord, I have come up. All that I have sought is the change of Khata may be straight, that's all.
Next year G.
How's next article. May I take my lord's kind attention to relevant portion here. On page, my lord, 41. They admit it is in my name, now they in order to change it. ಮೂರನೇ ಮತ್ತು ನಾಲ್ಕು ಪ್ರತಿವಾದಿ ತಂದೆ ರಾಣೋಜಿ ರಾವ್ ಮತ್ತು ಮುನಿಸ್ವಾಮಿ ರಾವ್ ಹೆಸರನ್ನು ರದ್ದುಪಡಿಸಿ. The present petitioners are the LRs of Mr. Ranoji Rao, son of Mr. Muniswami Rao. ವಿವಾದಿತ ಸ್ವತ್ತಿನ ಮೂಲ
What was passed on 26/11?
ಹ್ಮ್.
ಏನ್ ಮಾಡಿ, ಇದ್ರಿಗೆ ಏನ್ ಮಾಡಿಲ್ಲ ತಾನೆ?
ಏನು ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ.
ನೀವ್ ಯಾರಿಗೆ? ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಇವತ್ತೇ ಇಲ್ಲ? ಏನ್ ಖಾತೆ ಚೇಂಜ್ ಮಾಡ್ತೀರಾ? ಮಂಡೇವರೆಗೂ ಚೇಂಜ್ ಮಾಡ್ತೀರಾ? Will you cancel the ಖಾತಾ by Monday? ಪಂಚಾಯತಿಗೆ ತಾನೆ ನೀವು?
ಹೌದು ಸರ್.
ಏನ್ ಮಾಡ್ತೀರಾ ನೀವು?
Secure.
Then I'll grant an interim order.
ಇನ್ನೊಂದು
If not already done ಅಂತ ಹೇಳ್ತೀನಿ. ಅವ್ರು ಹೇಳ್ತಿಲ್ವಲ್ಲ?
authorities. ಇನ್ನೊಂದೇನು ಅಂದ್ರೆ they have filed a suit for injunction, my lord, in which they sought for interim order. I have produced that also before the court. Interim, just 1 minute, sir.
Make it the 6
Interim order is also rejected.
Secure instruction.
No appeal is filed.
File his objections. ನೀವ್ ಯಾರಿಗೆ? She so and so accepts notice for Pradeep. Respond 1 and 2. Pradeep. In the filing of objections, there should be interim stay of annexure.
Gmail.
He is not making any statement. He does not have any instructions. ಸುಮ್ನೆ ಯಾಕೆ ಬೇಕು? Till you file your objections ಅಷ್ಟೇ.
ಅವು ಇನ್ನು ಅರ್ಜಿನೂ ಇದನ್ನ ಮಾಡಿಲ್ಲ, ಪ್ರೋಸೆಸ್ ಮಾಡಿಲ್ಲ.
ಅದೇನ ಏನ್ ತೊಂದ್ರೆ ಆಗಲ್ಲ ಬಿಡಿ.
ಮಂಡೆಗೆ ಹಾಕೊಳ್ಳಿ, ಅಕಸ್ಮಾತ್ ಮಂಡೆ
ನನ್ ಮುಂದೆನೆ ಬರುತ್ತೆ ಫ್ರೈಡೆ. ನೀವು ಫ್ರೈಡೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ.
ಮಂಡೆಗೆ ಹಾಕ್ಬಿಡ್ತೀನಿ. ಮಂಡೆಗೆ ಹಾಕ್ಬಿಟ್ಟು
Tuesday, till Tuesday.
ಇಲ್ಲ, my lord, kindly have done Friday, my lord. Inconvenience. That's fine.
ಅದಕ್ಕೆ ಫ್ರೈಡೆ ಬರ್ಲಿ ಬನ್ನಿ.
ಎಂಟ್ರಿ ಮಾಡೋದ್ರ
Interim order.
ಇದನ್ನ ಪ್ರೋಸೆಸ್ ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
ನನ್ ಮುಂದೆನೆ ಇರುತ್ತೆ ತಾನೆ ಫ್ರೈಡೆ.
ಇನ್ನೊಂದ್ಸತಿ ಹೇಳಿ.
ಆಯ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇನ್ನೊಂದ್ಸತಿ. Number 7.
ಮಂಡೆಗೆ
Interim order. Interim order stay. Great.
Next Friday.
Challenging my lord, chief commissioner out of BBMP units, deviation 248(3).
ಎಷ್ಟಿದೆ deviation?
My lords, front and back side ಇದೆ, my lords, only my lords, balcony is a deviation, my lords. The ground level is not deviated, my lords, only front and back for the ground.
ಕರೆಕ್ಟ್ ಆಗಿ ಬಿಟ್ಟಿದ್ದಾರೆ.
Yella, ground level is perfectly fine, my lords. Only deviation ಅಲ್ಲಿ balcony, my lords. Kindly see the photograph I have produced. Page number 42, my lords. Front side ಅಲ್ಲಿ balcony ಬಂದ್ಬಿಟ್ಟಿದೆ. Back side, my lords, there were grill. They have put on grill. So they have said, my lords, it's also deviation.
Respondents. Objections within 12 weeks. The interim stay of next year,
K, my lords. Annexure H,
next year.
Seal number 8,
please.
Shri Rupesh Abhi. Appear for petitioner, my lord.
Void annexure E commissioner order is challenged before the December court, my lord. Issued under section 248(1), 2, 3, my lord.
Which is the deviation, no?
ಮುಂದೆ ಹಿಂದೆ ಪೂರ್ತಿ ಇದೆ, ರೈಟ್ ಟು ಲೆಫ್ಟ್ ಕಮ್ಮಿ ಇದೆ.
ಮತ್ತೆ ರೆಕ್ಟಿಫೈ ಮಾಡ್ಕೊಳಕ್ ಆಗಲ್ಲತ್ತೇನೆ.
ಅದ್ ಟೋಟಲ್ ಇದಕ್ಕೆ ರೆಕ್ಟಿಫೈ ಮಾಡ್ಬೋದು. ಎರಡು ಫ್ಲೋರ್ ಜಾಸ್ತಿ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದೊಂದು
How will you get over it?
ಅಲ್ಲ, ಒಂದ್ ಫ್ಲೋರ್ ನ ಅವರು
ಆಗ್ತೀರಾ?
ಅಲ್ಲ, ಒಂದ್ ಫ್ಲೋರ್ ನ ರೆಗ್ಯುಲೈಸ್ ಮಾಡ್ಬೋದು. ಇನ್ನೊಂದು ಫ್ಲೋರ್ಗೆ
ಏನ್ ಮಾಡ್ತೀವಿ?
ಒಂದು 8 months ಕೊಟ್ರೆ ವಿಲ್ ಸಿ ದಟ್.
Record your submission.
ಈಗ ಬೇಡ, ಅದಕ್ಕೆ ಒಂದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ. ಅಲ್ಲಿ ತನಕ ಈಗ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಡೆಮೊಲಿಷನ್.
ಏನ್ ಮಾಡ್ಬೋದಾ ಒಂದು ಫ್ಲೋರ್? ಯಾರ್ ನೇಬರ್ ಗಲಾಟೆ ಇಲ್ಲ?
ಸೆಕೆಂಡು ಟೆರೆಸ್ ಫ್ಲೋರ್
ನೇಬರ್ದೇ ಆದ ಗಲಾಟೆ ಇಲ್ವಾ?
ಇಲ್ಲ, ಅದೇನಿಲ್ಲ.
Next Friday we'll make a statement. Won't come out to take notice. And give respondents. Objections if any. The next week. This interim stay for next year.
ಇ
Ina,
ಇ
till then.
ಇ ಅಂಡ್ ಎಫ್ ಮೇಲೆ.
Till then, till
24th.
We should make a positive statement.
Seal number 9, Shri Varun R.
For petitioner,
I am for respond number 2 and 3, my lord. Housing board.
seeking,
sir.
seeking for writ of mandamus, my lord.
What?
For all-
Representation consideration.
Alternative side. Give for alternative side.
Yes,
Will consider representation, my lord.
The petitioners filed seek for direction. To be issued
In
to
accordance with
the
law.
Second respondent. Consider representation 12/8/2024 by which the petitioner is seeking for allotment of an alternative site in lieu of the site that has already been allotted to him. In my view, since the petitioner is asking for allotment of an alternative site, it would be appropriate to direct second respondent to the same in accordance with law and pass appropriate orders within a period of 2 months from date of the coordinate. So
Great.
council accepts notice. Respondents 2, 3. AJ accepts notice for
Grateful, my lord.
Seal number 10,
The petitioner, it's the petitioner millers have challenged the demand notice millers which is issued by the BBMP for issuing a modified plan sanction millers. And it is demanded on various heads, including ground rent millers, a coordinate bench of this honorable court millers. In a similar matter, millers has a granted stay millers with the demand notice, which millers I have produced
Ground
at
rent
annexure
stays are-
W.
LBSA only of the ground rent or what is the demand?
All the heads millets I'm challenging millets. And a similar matter millets at annexure W millets, page number 107. Page number 107. Next page millets 108 is the order millets, the interim order.
I'll say in terms of this order.
Please, millets. I will deposit millets as to whatever the amount is mentioned in the similar matter.
Vijay takes notice for R1. Kumar takes notice for R2 and R3. There shall be an interim stay In terms of the interim order granted in WP 3250/2024. Post along with WP 3250.
Matter may be connected with the similar, please.
Bill number 11. Shri Varun RR.
For petitioner, my lord.
Yes, ma'am.
The matter is writ of mandamus.
What is the next area?
Next,
Representation of the
submitted representation to my lord, consider the case, my lord, under category 9B of the my lord allotment regulations, housing board allotment regulations.
Marginal.
Not marginal, my lord, quota, the one, the category 9B is my lord, like a DQ quota, discretionary quota, my lord, allotment under they made representation, my lord.
ಮಾಡ್ತೀರಾ?
Considered in accordance in 3 months.
So also accepts notice for HL Pradeep Kumar. Respond number 2, AG accepts notice for her. The variance petition is for a direction to consider representation 10/6/2024, for which the petitioner is seeking for allotment of a site under category 9B of another
Karnataka Housing Board allotment regulations.
Karnataka Housing Board allotment regulations. And my view is the petitioner has made an application for allotment of site under a particular category. The appropriate to direct the petitioner respondent,
Respond number 2, my lords.
the second respondent to consider the same. Pass appropriate orders in accordance with the period of 3 months.
Bill number 12. Shri Girish Balbare. Request for petition.
Challenging the no confidence motion as per section L, my lordship. In this case, my lordship, the earlier, the petitioner is elected as a president on 8/8/2023. Thereafter, his resignation was tendered and same was accepted on 21/10/2024. By that time,
80/20
Your
election.
Your Lordship, one submission. Copy has not been served. This matter was earlier, they had filed, they had referred a writ petition. Now, as per instructions, proper notice has been issued, Your Lordship.
I'm not on that point, my lordship. The
Copy
earlier
serve ಮಾಡಿಲ್ಲ ನಮ್ಗೆ.
resignation was tendered on 8/10/2024 and same has been accepted on 21/10/2024.
ಯಾವತ್ತು ಎಲೆಕ್ಷನ್ ಆಗಿದೆ? ರೆಸಿಗ್ನೇಷನ್ ಯಾರು ಕೊಟ್ಟಿದ್ದು?
ಅಲ್ಲ, elected as a president 8/8/23 and resignation was accepted on 21/10/2024.
15 months. They are
2024. By that time, he has not completed for 15 months. That is 14 months,
First signed in the previous petition.
23 days,
Yes.
the 33 days.
Yeah.
Thereafter, by virtue of the interim order passed by this Honorable Court, stay has been granted. And he has continued in the office of the president.
ನೀವು ರೆಸಿಗ್ನೇಷನ್ ಕೊಟ್ಟು ಆಮೇಲೆ ರಿಟ್ ಯಾಕೆ ಹಾಕಿದ್ರಿ?
I mean, resignation is accepted. Meanwhile, I make an application for withdrawal of the resignation.
ಅದು ಯಾವತ್ತು ಕೊಟ್ರಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್?
The interim order was granted on
disposed-
29/10/2023. 29/10/2023, my lord.
ವಿತ್ಡ್ರಾ ಅಲ್ಲ?
The IO is granted, interim order is granted for the acceptance of the resignation. That was challenged by before this Honorable Court.
When did you give the application withdrawal?
Withdrawn on
16/10.
16/10/2024.
You gave a withdrawal for resignation.
Yes, my lord.
Then that
By
was
ignoring my withdrawal resignation was accepted on 21/10/2024.
21/10/2024.
That was been challenged before this Honorable Court in writ petition 28926 about 2023, 24.
28,
28, which is in page number 40, my lord.
ನಂಬರ್ ಹೇಳಿ ಸರ್.
28926 about 24.
ಯಾವತ್ತು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದು?
Interim order was granted on 29/10/2023. And matter was 29/10/2023.
23 and 24.
Sorry, 24, my lord. Sorry, 24.
ಸರಿ. This petition is disposed of.
Petition is disposed by squashing the
28 November.
dismissal of the acceptance of the resignation has been squashed and it was continued as the,
Was that order passed?
that order was passed on 28 November.
28th
24.
November to 24.
28,
November 2024.
Annexure J, my lord.
WP allowed. So you remained as president from 8/8/23 up to 29/11/2024.
Yes.
My submission is, meanwhile, I have terminated from the office. By that time, I have not completed 15 months. Again,
Okay. By virtue of the stay order that you got,
yes, my lordship.
by virtue of the stay order that you got in this WP,
Yes.
Yes, ma'am.
continued as a president uninterrupted from.
Meanwhile, I am not continued as a president for over a period of time. Thereafter, by virtue of the interim order, I have continued, my
No,
lord.
you said 21/10/2024, it was accepted.
Resignation is accepted, I am not continued as an president of the Gram Panchayat.
You said there was an interim order granted within 8 days thereafterwards.
9 days thereafter, my lord.
So, or you have virtually continued uninterrupted,
Yes.
except for the period of 8 days.
Yes, my lord.
So, ಪೂರ್ತಿ ಆದ 15
15 month ಆಗುತ್ತೆ sir.
ಇನ್ನೇನು?
My submission is,
One
I have
ತಿಂಗ್ಳು
discontinued,
ಹಂಗೆ-
thereafter I continued, so the months has to be calculated from the, when I am second time is elected, continued as the president, that is my submission.
Elect ಎಲ್ಲ ಆಗಿದ್ದಾರೆ.
ಅಲ್ಲ, submit,
Elect ಆಗಿ
continued.
1.5 months ಆದ್ಮೇಲೆ ಮೂವ್ ಮಾಡಿದ್ರು.
Immediately after the disposal of the writ petition, they have moved within the span of 1 month, my lordship,
1.5 months.
1.5 month.
So according to you, the allowing of the writ petition is a re-election for you.
Re-election, re-continued.
What you are saying. Challenging. A special meeting convened on. ಯಾವತ್ತು?
Special
It was
meeting.
on, scheduled on 21/1/2025, notice was issued on 31/12/2024.
To consider the motion of no confidence moved by the members of the council. It is a contention of the petitioner that this notice is, this convening of special meeting is illegal because the petitioner is entitled to continue for a period of 15 months from 29/10/2024. That is the date on which, that 29/11/2024, that is the date on which WP 28926 of 24 filed by him was allowed. According to the petitioner, by virtue of the order passed in the writ petition, you would be entitled to a fresh tenure from the date of the order of this court. These facts are not in dispute. On 8/8/23, the petitioner was elected as the Adhyaksha. However, he chose to submit his resignation on 21/10/2024.
ಅಲ್ಲ, resignation on
Immediately thereafter, the ಯಾವತ್ತು withdrawal ಕೊಟ್ಟಿದ್ದು ನೀವು? 29th.
16/10/2024. And resignation was accepted on 21/10/2024.
However, he chose to submit his resignation to the said post on 16/10/2024.
No, madam.
But within
Withdrawal.
a period of 5 days, he sought to withdraw his resignation on 21/10/2024.
Sorry, correct ಆಯ್ತಾ?
However,
ತಪ್ಪಾಯ್ತು ಅದು.
the authorities,
I'm sorry, my lord.
Sorry, my
The
lord.
date of
Resignation, ನಾನು
resignation is
ಹೇಳ್ತೀನಿ,
8/10/2024.
Resignation tendered on 8/10/2024. Resignation withdrawn on
One is dated 16/10/2024.
16/10/2024. Accepted on 21/10/2024.
That was challenged.
Accepted.
however, he chose to resign, submit his resignation on 8/10/2024. But within 8 days thereafter, he submitted a letter withdrawing his resignation. However, the authorities chose to accept his resignation on 21/10/2024, which was the reason for him to file WP 28926 for 2024, in which this court granted him an interim order on 29/10/2024. Next part. This court, by an order dated 29/11/2024, allowed the writ petition and set aside the order which had accepted his resignation. It is therefore clear that from 8/8/23, the petitioner has been in the office of Adhyaksha continuously. The argument that by virtue of the order of this court, it is in law, it is deemed that he was elected on 29/11/2024 cannot be accepted at all. It is to be stated here that the petitioner's office, the term of the office started on 8/8/2023 and continued uninterruptedly, notwithstanding the resignation that the petitioner had given. The mere fact that the petitioner had resigned and he thereafter withdrew his resignation, which was upheld by this court, will not entail to him a fresh term from the date of the order. In this case, it is not in dispute that the requisite number of members have given a motion expressing no confidence and for convening a special meeting. And since this meeting has been accepted and a special meeting is convened, no infirmity can be found in the procedure by the second petition. Petition is therefore dismissed.
Obliged.
Bless.
Number 2, for orders. Bill number one, Shri Chandrasekhar.
In this case, they have challenged the annexure, yes, my lords. Annexure S has been challenged before this court. my lords. That is at page number 127. Lords, in this notice,
Copy ಕೊಟ್ಟಿದ್ರ ಪವನ್ಗೆ?
yes, sir. Lords, in this notice, they have not mentioned why the building was completed in the year 2017, my lords. And we have taken the permission from the town planning for construction of the building in the year 2016. And Nirmana, kindly your lordship may see the second para.
It is only saying that be present on that day for inspection.
Yes, my lords. My case is that, my lords, when the building has been completed in the year 2017, my lords, and there are many properties which has been sold, there are 12 flats are there in this property. And without issuing notice to the other owners of the property, only with respect to site is concerned,
Will be satisfied if they are also undergoing the same problem.
they have not issued any notice for them.
ಅವ್ರು ಕೊಟ್ರೆ ನಿಮ್ಗೆ ಸಮಾಧಾನ ಆಗತ್ತೆ.
ಅಲ್ಲ ಹಂಗಲ್ಲ. But by my case is that, my lords, there is a properties existing since from the year 2017.
The illegality in the issuance of this notice.
There is no,
They only called upon you to be present for conducting a spot inspection. Let them conduct a spot inspection. Let us see what will happen.
only
There's
to
no threat
harass
of-
this petitioners, my lord, this type of, there is a blackmailer who has one of the person, the Chandrappa has given a complaint against these persons with respect to other properties is also concerned. And we have also filed a PCR against that person, stating that he is blackmailing these petitioners and all those things. With respect to the job where they are doing there,
Now, what is this ಉಲ್ಲೇಖ? ತಾವು ಅನುಮತಿ ಕೋರಿ ನೀಡಿರುವ ಪತ್ರ ದಿನಾಂಕ?
ಅದು ಇದರಲ್ಲಿ ಒಂದು 2-1ಕ್ಕೆ ಒಂದು ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ, ಸೇಮ್ ಇದೇ ಟೈಪ್ ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ.
No, yours.
3-1ಕ್ಕೆ ನಾವು ರಿಪ್ಲೈ ಕೊಡ್ತೀವಿ.
Where is that letter?
ಲೆಟರ್ ಮಲರ್ಸ್ ಇದನ್ನ ಮಾಡೋದ್ ಮಾತ್ರ ಅಂತ ಹೇಳಿದ್ವಿ ನಾವು, ಇದನ್ನ ಅಷ್ಟೇ ಅಂತ ಹೇಳಿದ್ವಿ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ.
ಇಲ್ಲಿ ಬರೆದಿರೋದು ತಾವು ಅನುಮತಿ ಕೋರಿ ನೀಡಿರುವ ಪತ್ರ ದಿನಾಂಕ 3/1/25. What permission did you seek from them?
ಪರ್ಮಿಷನ್ಗೆ ನಾವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅವ್ರಿಗೆ ಹೇಳಿತ್ತು ಅಷ್ಟೇ ಸಮ. ಕಾಪಿನೂ ಡೈರೆಕ್ಟ್ ಆಗಿ ಅವ್ರು ಏನ್ ಬಂದಾರ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ವಿ. ಕಾಪಿ ಇಸ್ ನಾಟ್ ದೇರ್ ವಿತ್ ಅಸ್.
Letter indicates that you had sought for some permission. Therefore, they are conducting a spot inspection with reference to your letter. And if
No,
you
no,
got that
earlier,
response,
my lords, on 2/1/2025, they have given a letter. Same letter, it has been given by them.
that what is your letter dated 3/1/25?
ಲೆಟರ್ ಅಲ್ಲೇನೆ ಅವ್ರ ಮುಂದೆನೆ ಬರೆದು ಅಲ್ಲೇ ಕೊಟ್ಬಿಟ್ಟು ಸ್ವಾಮಿ. ಆ ಕಾಪಿ ಇರ್ಲಿಲ್ಲ ನಮ್ಮ ಹತ್ರ. ಆ ಕಾಪಿ ಇರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್
Let
ಆಗ್ಲಿಲ್ಲ.
the inspection go on. There is no harm in the inspection going on. Let us see what they will do.
What has happened, my instruction is earlier some complaint was filed and 248 proceedings were initiated. Then it was challenged and it got dismissed. Now the power for demolition is the zonal commissioner. So zonal commissioner has said it's an old complaint. You go again and inspect the property, whether deviations are there and what is the deviation at present. So they are doing the inspection only, so that further demolition order when will be issued.
No,
When
ಅಲ್ಲಿ
they will-
ಹಿಂದ್ಗಡೆ ಯಾವ್ದು ಕನ್ಫರ್ಮೇಶನ್ ಆರ್ಡರ್ ಏನು ಆಗಿಲ್ಲ ಹಿಂದ್ಗಡೆ.
ಅವ್ರೇನೋ ಹೇಳ್ತಿದ್ರೆ ಆಗಿತ್ತು ಅಂತ. ನಿಮ್ಗೆ ಅದು ಗೊತ್ತಿದೆಯೋ ಗೊತ್ತಿಲ್ಲ.
ಇಲ್ಲ, ಅಪೀಲ್ ನಾವು ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ.
He has different instructions.
As if now we are inspecting only, my lordship, nothing else.
The inspection gone. I don't think there's any need to stop the inspection. Or as it is ಕೆಲಸ ಮಾಡೋದೇ ಕಷ್ಟ. ಅವ್ರು ಕೆಲಸ ಮಾಡಿದ್ರು ನೀವು ಬಂದು ನಿಲ್ಸಿ ಅಂತ ಅಂದ್ರೆ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಈ ಬಿಲ್ಡಿಂಗ್ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಆಸ್ ಆನ್ ಡೇಟ್ ಆಫ್ ದಿ ಬಿಲ್ಡಿಂಗ್ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಫೋಟೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು.
ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮೇಲೆ ನೋಟಿಸ್ ಕೊಟ್ಟರೆ ಅದೇನು ಉತ್ತರ ಕೊಡ್ತಾರೆ ಕೊಟ್ಟಿದ್ದಾನೆ. I ask him to consider it. I can't stop this inspection.
ಈ 2016 ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಬಿಲ್ಡಿಂಗ್. ಇದು ಬಿಲ್ಡಿಂಗ್ ಫೋಟೋಸ್ ಎಲ್ಲ ಹಾಕಿದೀವಿ.
ಇದನ್ನ ಕ್ವಾಶ್ ಮಾಡಿ ಕನ್ಫರ್ಮೇಟರಿ ಆರ್ಡರ್ ಇದ್ರು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ ನಾನು.
ಅಲ್ಲಿ ಕನ್ಫರ್ಮೇಟಿವ್ ಆರ್ಡರ್ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ಕೊಟ್ಟಿದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ. ನಮಗೆ ಅದ್ರ ಬಗ್ಗೆ ಇಂಟಿಮೇಶನ್ ಇಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ.
ಏನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಲಾ ಇವಾಗ?
Let them file objection, till then stay may be granted, because what they are saying, we are not aware of that matter.
On behalf of respondents 1 to 3 and secure instructions regarding annexure C. It is our made clear that the inspection proposed in annexure C shall go on. Pre-list and preliminary hearing on. Just find out what is there.
Yes, ma'am.
Till next date it must.
I have said it can go on.
24th. List number 1 for orders. Number 13, Shri Sampath Anand Shetty.
For the petitioner.
Kindly pass.
Order of eviction. And in fact,
up in another court. Kindly pass over.
Pass it over. Pass over.
Seal number 14.
Matter appear for the petitioner, lordship disposed of the petition. Or subsequently they entered into compromise, or in view of that compromise, it may be disposed of. 10 days time may be given, lords, I will keep them present, lord, that is the only equity. Lords, I had challenged them, lords, the sale permission. Lords, these petitioner, lords, had filed a restoration application before the, lords, the assistant.
What is the prayer here?
Prayer is, lords, only review for, lords, them.
What was the prayer in WP 2282?
Lord, the sale, cancellation of sale permission issued by the, lord, the government to the respondent of private respondent.
You are the grantee, na?
I am the, lord, the grantee. Lord, they had initiated, lord, restoration proceedings before the AC. And again, lord, they have challenged the, lord, sale permission before this honorable court. In view of pendency of, lord, the case before the AC, lord, I withdrawn this case to, lord, anyhow, lord, they have settled the matter, lord, so I will report, lord, of that.
No, if they have settled the matter, then what is there to be reported?
Only, lord,
Sale permission was granted.
sale permission was granted.
So they will now sell the property.
Yes, lord.
Then what is the,
But the only grievance is they have settled the matter in terms of, not that compromise, let that be come on record equity.
if I bring that on record, I'll be modifying the order of sale permission.
No, lord.
Yes.
Only, not simply saying that they have compromised in terms of, not the money, some money, not they have received, it seems. Let it be come on record. That is the only thing.
No, I don't seem to understand. If there's a settlement, there's a settlement. I'll say that,
Out of court antane nan barastene, at least not, I will keep them present, at least say order sheet.
I will make that order right now. I don't need to issue notice. to
At least our order sheet alli sign madli anta. Yakandre party we can't believe, not these
ಯಾರ್
petitioners
ಯಾರ್
and
ಮಾಡಿ?
petitioner and the respondents.
ನೀವ್ ಯಾರ್ ಪರ ನೀವು ಬ್ರಿಟಿಷ್ ಪರ
ನಾವು petitioners for us settle ಆಗಿದೆ, ಅದಕ್ಕಾಗಿ one date ಕೊಟ್ರೆ, not I will keep them both present before this honorable court and not the disposal of this.
You do one thing, I'll dismiss the review petition, file an application for recalling in that writ petition. Because review, I can't do anything in the review. I can't find any error in this.
At least not 10 days time, not meantime, not I will make application and not
You tell me in the review, can I set a recall this order?
not I will withdraw this review, not kindly 10 days time, not meantime I will file my application.
List. 31st.
A review le joint memo haki, idralle joint memo haki, on that basis I'll say.
Till number 15, Shri Robert D'Souza.
For the petitioner.
Third respondent.
For the seventh respondent.
Yes.
Lordship, there's a direction to file affidavit. It inadvertently it was mentioned as Secretary RDPR. It has to be by the Revenue Department, you know. Monday itself we'll file the affidavit if there's a change. In on the last date,
The affidavit ready,
an affidavit,
the revenue secretary.
only draft is ready, we'll have to file the affidavit. ಇವತ್ತು ಅದನ್ನ correction ಮಾಡಿಸಿ ಇದು ಮಾಡುವಂತಷ್ಟೇ.
The order was you should be present in the court, isn't it?
No, but it was inadvertently mentioned, it was not,
But I made a mention.
ಅಲ್ಲ ಇವಾಗ ಅದು ಗೊತ್ತಾಗಿತ್ತು ಸಮಯ.
VGA submits that. The order dated 8/1/2025 required the affidavit of the principal secretary, rural development and panchayat raj. But in reality, it was the principal secretary, revenue department
Revenue Department.
was to file the affidavit. And hence, though the draft of it was ready, the same could not be filed. We request for time till Monday to file the affidavit of the principal secretary, revenue department, as ordered on 8/1/25, pre-list on
Monday, 20. Seal number 16, B. Ramesh.
Yesterday's matters. Sorry, my lord.
yes.
My lord, say, mandamus has been sought to consider my representation and also conduct this survey. My lord, this honorable court has directed the officials to conduct this survey.
My lords, they have submitted a report. My lords, out of this, they specifically state in that report that they cannot identify 12 guntas of land since the boundaries are not there.
Your prayer in the petition is over.
My lords, not, my lords, 12 no, my lords, because they specifically says that 12 guntas of land cannot be identified since boundaries are not there. My lords, for this reason, my lords, 2 acres, 2 guntas, my lords, in their report, they specifically says that who are in possession of this. My lords, only 1 acre, the 38 guntas, which are being granted in favor of the respondents, father of respondents number 8, 7 to 9, was 1 acre 38 guntas. In 1 acre 38 guntas, my lords, 1 acre 31 guntas has been allotted, acquired for KDB. Remaining 7 guntas, respondent number 9,
What is the total extent?
total extent is 2 acres, 1 gunta, my lords. 2 acres, my lords, 2 acres, 10 guntas. Out of survey number 2/1.
Total extent is?
2 acres, 12 guntas, 10 gunta, 2 guntas is Karab.
2 acres, 10 guntas.
Yes, my lords. Out of the 1 acre, 38 guntas has been allotted in favor of the father of respondents 7 to 9.
1 acre?
1 acre, 38 guntas. And remaining 12 guntas has been retained.
Under what act?
My lords, Inam Abolition Act, my lords, by the order passed by the Special Deputy Commissioner, my lord. While passing an order, 12 guntas of land was reserved for community purpose, that is for public purpose, my lords. It is not disputed. They have also accepted that order, my lords. Now, out of this 1 acre 38 guntas,
Into 12 guntas is reserved.
reserved.
Where is that order reserving 12
My lords,
guntas?
Annexure A,
Next year?
Annexure A, page 21. My lords, where the landlord has conceded that he has no objection for granting 1 acre 38 guntas, reserving this 12 guntas in for community purpose.
Immediately 12 guntas anta.
Idrali first parallel. My lords, so the petitioner's claim, third line, my lords. The petitioner claim only in to an extent of 1 acre 38 guntas from out of this survey number, in as much as he has relinquished his claim for balance 12 guntas for community use. My lords, now 1 acre 30, out of 1 acre 38 guntas, 1 acre 31 guntas has been acquired by KADB. My lords, remaining is 7 guntas, apart from 12 guntas. In 7 guntas, the respondents had entered into a joint development agreement. An apartment has been has been completed. In respect of this 12 guntas, once again, my lord, this respondent number 8 and 9 has put up a construction of a building. They are residing that. Apart from that, my lords,
This 1 acre 31 guntas and 7 guntas is identified in the survey.
my lords, they have identified it.
Let us read the survey report.
My lords, so serial number 2. ಸರ್ವೆ ನಂಬರ್ 2/1 15 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ಹಾಲಿ ಜಮೀನಲ್ಲಿ ಸ್ಥಿತಿಯಂತೆ ಅನುಭವದಲ್ಲಿ ಪ್ರತಿವಾದಿ 7 ಮತ್ತು 8ರ ಅನುಭವದಲ್ಲಿ ಇರುತ್ತದೆ. ಸ್ಥಳದಲ್ಲಿ 2 RCC ಶೆಡ್ಡುಗಳು ಮತ್ತು ಬಾಡಿಗೆಯ ಶೆಡ್ಡುಗಳು, ಮನೆಗಳು, ಅಂಗಡಿಗಳು ನಿರ್ಮಾಣ ಮಾಡಿರುತ್ತಾರೆ.
R8 and R9.
R9,
R7 and 8.
R7 and 8.
They are in possession of 15 guntas.
15 guntas. Next, my lords. Next, my lords. Serial number 3.
7 guntas. ಇದ್ರಲ್ಲಿ ಯಾರು ಇರೋದು? 9.
ಇದರಲ್ಲಿ 7 ಗುಂಟೆಯಲ್ಲಿ 9.
The 7 guntas has been converted and it is in possession
But
of.
I am not disputing it. I am not disputing it.
Then?
Next, my lords. Next is 2 guntas has been Kaludari Karab Seri.
1 acre 27 guntas is with KD.
Yes, my lords. Because 1 acre 31 guntas is the actual possession.
Much period happened. 15 plus 7, 22. Yes. So 2 acre 20 guntas at 9 guntas is accounted for.
Accounted for. My lords, now
Address number is accounted for now. 2/1 is accounted for.
illa.
They are in possession of 15 acres, 15 gunta, 15.08 guntas.
Yes, my lords.
Respondent 7 and 8. Respondent 9.
Is 7 guntas.
So together they are in possession of about 22 guntas.
Yes, my lords. My lords, they are in excess, my lords. What, the 12 guntas, let them identify. My lords, I have no,
Who are you?
my lords, I have made a representation. My lords, I have requested the authorities to,
No, who are you?
my lords, I am the villager. My lords, we have
If you want to enforce the order of that particular authority next area, take steps in accordance with law.
my lords,
You
they
can't
are-
ask somebody else to do your work for you.
my lords, the authorities are not taking steps, my lord, for,
Unless there's specific order assigning this 12 guntas under any of the Provincial Land Revenue Act, you cannot demand all this.
my lords, because what has happened, my lords, once it has been reserved for a community purpose, my lords, there is an order passed by the authorities.
I can act upon reservation, which is statutorily done.
Yes, my lord.
I cannot act upon a voluntary relinquishment to say that there should be a community hall there now.
Because, my lords, he has not claimed it. My lords, he has not claimed it.
You think that you can implement that order in a manner known to law, go ahead and implement it. But I cannot use the writ petition code to ensure that he builds a community hall in 12 guntas. I cannot do the work of identifying the 12 guntas and then say, yeah, this is reserved for community purpose.
My lords, because the authority says that, my lords, it was reserved for community purpose, my lords, while surveying the land.
Now, you tell me under which authority can somebody reserve the land for a particular purpose?
My lords, the owner itself has come forward to reserve the land and grant.
That's why I said if you can enforce the order of the, which is the authority annexed area?
My lords, annexed, Special Deputy Commissioner Idams, now
You can
the,
enforce the order of the special deputy commissioner, go ahead and do it. All that the special DC has said is owner's relinquishing.
yes, my lords.
So he has not reserved it.
Lords, they are, but it was an understanding, my lords, where he has
ಆಗಲ್ಲ
himself has.
ಇಡೀ ಅವ್ರ ಜಾಮೀನ್ ಯಾರು ಬಿಟ್ಕೊಡಲ್ಲ, ಒಂದ್ ಗುಂಟನೆ
ಅಲ್ಲ
ಬಿಟ್ಕೊಡಲ್ಲ.
ಅಲ್ಲ ಅಲ್ಲ, ಅವ್ರಿಲ್ಲ, my lords, the owner is not there. My lords, owner is not there.
Whoever is in possession, you cannot use the writ petition to dispose it. Now the record is 15 guntas, they are in possession. ಯಾರು R7.
ಅಲ್ಲ ಅಲ್ಲ, ಅದ್ರಲ್ಲೂ my lords, they are not in possession. My lords, they are,
You ask for a survey report, the survey report has
my
come.
lords, survey report, my lords,
3 respondents, R7 and R8, R9, all of them are in possession of 22 guntas. The remaining land is with KADB. So you know now who's in possession. You go and enforce the order of deputy commission in any manner that you choose. This petition will not survive.
my lords, with that observations, my lords, I may be reserve liberty.
The prayer in this petition was to direct the respondents to consider the representation next H1 to H3 and also for direction to conduct a survey in survey number 2/1 and identify the 12 guntas of land which was reserved for a community purpose way back in the year 62 in the order passed with the District Commissioner pronounced opposition in case number 39 and 40. When was the order, the survey
What?
ordered?
Lords, this order was passed.
31/5/2024 was the order. Plus the report was submitted before this honorable court dated
30th
plus
of
18/7/2024.
This court, an interim order directing the ADLR to conduct this survey, identify Velgunta Surveillance number 12/1 situated at Sonenhalli village, Kerpuram Obli. Pursuant to the said order, a survey report has been filed in which it is stated that out of the total extent of 2 acres, 12 guntas bracketed pathway of 2 guntas, correct, that is in all 2 acres, 10 guntas. 15.08 guntas was in the possession of respondent number 7 and 8. And 7 guntas was in possession of respondent number 9. It is also stated that 1 acre, 27 guntas,
My lords, that is 1 acre, 31 guntas is acquired, my lords. Notification is
whatever
there.
he is saying, I have said.
Yes, my lord.
1 acre 27 guntas is in the possession of KADB. Who have erected a compound wall over the said land.
For the
And-
2.8 guntas.
And of 2.08 guntas, a road has been formed.
BBMP has formed a road.
The 2 guntas of Tarap indicated in the RTC as a pathway. In my view, the prayer sought for by the petitioner has been answered by the conduct of this survey. As far as the content of the petitioner, that the ADLR was required to identify 12 guntas, which according to the petitioner, he has stated, the ADL has stated was unascertainable, the petitioner would be at liberty to take such steps as are permissible in law to ensure that the alleged reservation made for community purpose is implemented. It is made clear that nothing said in this order shall be construed as rendering an opinion on the merits of the claim of the petitioner. And if the petitioner is entitled to seek for implementation of the order of the special case coordination, in case number 39 and 40, he is at liberty to do so. WP is according to this.
Much on. Bill number 17.
Here for the petitioner, my lordship, needful done agide process pay ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
Who's R6?
I am permitted to take 2 to 4 ಸರ್ವ್ ಆಗಿಲ್ಲ, ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
R6 ಯಾರು?
R6 private party ಅಶ್ವಥ್ ನಾರಾಯಣ.
ಏನಿದೆ ಇಂಟ್ರೆಸ್ಟ್ ಇದೆಯಾ ಇಲ್ವಾ? What is the next ref?
Passed by the UMN. Duty hours.
ಸರಿ ಯಾರು?
lordship ಪಾಸ್ ಓವರ್ ಆಗಲಿ ಸ್ವಾಮಿ.
ನಿಮ್ಮ ಹೆಸರು ಅಶ್ವಥ್ ನಾರಾಯಣ.
Petitioner. Six is Ashwath Narayan by name.
ಇಬ್ರು ಅಶ್ವಥ್ ನಾರಾಯಣ ಅಂತಾನೆ ಇದ್ದಾರೆ.
ನಾರಾಯಣನ್ ಅಂತ ಇದೆ ಸ್ವಾಮಿ ಅದು. 6.
6 ನಾರಾಯಣ್ ಅಂತ ಇದೆ.
Ashwath Narayan, son of Ratnam. Petitioner is Ashwath Narayana, son of Chikkapaya.
Stated the need for has been done, office to verify. The petition is also permitted to take out notice on R6 personally. He so and so accepts notice for respondents.
2 to 3. 2 to 4, son.
2 to 4. Pradeep. Here the AJ accepts notice for R1. R5 here. OPS for R5. Shriyari.
Bill number 18. Gautam.
Filing the report, copies served.
Hearing for the plaintiff's lawyers.
There was a direction to conduct inspection and to find out the setback deviations.
Just now received the report, my lords. I look into it and file the objection for the same.
The report as ordered on 3/12/2024 is filed today. It is 106 for a week's time. Previous one.
Bill number 19.
It's appearing for the petitioner. My lord, this matter is pertaining to the construction of compound wall around the petitioner's property by Mysore Water Board and Mysore Corporation. On the last day,
Please.
Right.
Lord, as regards construction of the compound wall,
My lord, I am for
19.
I'm sorry.
My instructions are that, Lord, when the property was handed over to the Mysore City Corporation, there was already an existence of a wire fence, my lord.
There was a
Wire fence, my lord, boundary, which was already created by the Karnataka Water Supply and Sewage Board. Lord, in 2018, my lord, there is a work order, my lord, to put up construction of a concrete wall. My lord. A copy of the
work order and pictures of the pre-existing wire fencing, my lord, across the boundary. But,
So nobody has surveyed the land.
it was, my lord, subsequently, my lord, there are two surveys, my lord, which are conducted, which is placed along with the writ petition.
What is the extent of land that you own?
25 gunta.
Totally, my lord, as regards that document, my lord, there is some delay, my lord, in procuring because the land was handed over to the
What is
Mysore
the survey number?
220/6.
You have no idea as to what is the extent.
Total extent is about 30 acres odd.
That is
Out of
two
which the
survey
pet,
Get information.
out of which, my lord, the petitioners claim that their land, private land, which falls within the boundary of these walls is about 25 guntas, my lord. That is shown even as per the survey. There is one joint with survey, my lord, which is conducted, which is placed on record as annexure L by the petitioners. However, my lord, there is a
You do
discrepancy.
one thing.
And
You remove the compound wall for now.
please,
Then thereafter conduct a survey or go to the civil court and establish your right over that particular land.
Lord, as regard, Lord, the portion of the land, my lord, is admitted by the petitioner, which is in custody of the Mysore City Corporation. There is no access, my lord, which is enjoyed by the petitioners from the road, my lord. That is forthcoming from the survey, the joint survey
What is
conducted.
the order of conversion?
Lord, the order of conversion, my lord, is at annexure,
G, man.
annexure
E.
G, my lord, page 35. When as per the boundary shown in the conversion order, my lord, there is no road shown.
Then how will they go and build an apartment there? If you admit that it forms within your 30 acres and you enclose it all around,
Please.
then how do they have access to it? You don't dispute the fact that the land is situated
That is a
within your.
private, please, my lord, I do not dispute that, but that is a different.
At least they had an island. Now you've made it part of your holding.
But the boundary wall was always in existence since
But you have
nineteen
basically disposed
seventy-three.
us there.
1973, my lord,
You want to do it voluntarily or you want me to pass an order?
Lord, yesterday, my lord, there is a requisition for a fresh joint survey, my lord, to ascertain where there was access, my lord, because as of now, my lord, there is no access. Which portion, ಯಾಕಡೆಯಿಂದ access ಇತ್ತು, which if at all it existed, ಅನ್ನೋದನ್ನ ನಾನು ನೋಡಕ್ಕೆ.
ಏನ್ ಮಾಡ್ಲಿ? You want me to pass an order or you want to do it on your own?
But some time may be granted, my lord,
For
2
what?
weeks' time, my lord, to ascertain what action can be taken.
That means you'll continue this blockage for forever.
No, not some time, my lord,
I'll pass an order. You will go to the civil court and establish.
please, my lord.
Where is that sketch?
But sketch at
Annexure L,
annexure L, my lord.
page number 41.
This is the joint survey sketch. The sketch at annexure N, my lord,
The prayer in the writ petition to direct the third respondent
Demolish the compound.
demolish the illegal compound wall which is constructed, which blocks the entrance from the main road to the property of the petitioner, which is admittedly the property bearing survey number 220/6, which measures 25 guntas. The petitioner places reliance on a joint survey sketch, annexure L, which indicates that the holding of the petitioner of an extent of 25 guntas, that is the aforementioned land, falls within the larger area of survey number 222/6. In fact, in annexure L, it is stated as follows. Mark ಮಾಡಿದನು. The case of the petitioner is also that as per the survey sketch which is produced annexure N, indicating the possession to the south of 220/6, which belongs to the petitioner, a road is indicated. But the petitioner contends, despite this position, the third respondent has erected a new compound wall by removing the gate that was in existence, thereby cutting off the access completely to the 25 acres land of the petitioner. The petitioner places reliance on the photographs, the annexure P to P3, which also indicates that there is a freshly put up compound wall and which covers the area between the earlier elected compound wall. This would therefore clearly establish that the third respondent, right, by putting up the compound wall, completely block the access of to the petitioner's land. In the light of the fact that the survey records indicates that 222/6 measuring 25 guntas belongs to the petitioner and falls within a larger area which belongs to the third respondent. It is obvious that the petitioner would have a right of access to this particular land, and he did have access until the compound wall was constructed. Therefore, of the view, that it would be necessary to direct the third respondent to dismantle the compound wall which has been erected as indicated in annexure P3 photographs and permit the petitioner to have access to his property. If the third respondent is of the view that they own the property between the petitioner's property and the road, they are entitled to initiate appropriate proceedings before the appropriate forum and establish this right. Subject to the above, the petition is low.
Till number 20.
But
Lakshmi.
one submission, but a time limit may be fixed for demolition.
Immediately dismantled within a period of 2 weeks. 2 weeks.
Till number 20.
Corresponding 2 to 5 BBMP in this matter.
Hearing for
This
petition.
matter pertains to compensation for road widening purpose, my lord. I'll have to seek instruction and must file my statement of objections in this matter. I pray 2 weeks of time to file my statement of objection. Deeply obliged.
31st. Till number 21.
But I prefer. But the respondents, we want to pay the property tax from 2017-18 onward. The previous years is some dispute and writ appeal is pending in respect of that. They have blocked the online payment method. And if we tender, they are not accepting in, they have to pay, they want entire thing to be paid at once.
My lord, they haven't, claimed the ownership for that property. They haven't produced any document stating that they are the owners.
No, the Kata was in his name, we had collected the taxes from him earlier.
No, they haven't produced any documents such for the earlier
Did you
tax
or did you
payment.
not collect taxes earlier from him?
That is, we haven't got, we have asked for instruction from the BBMP. They haven't reverted
There to
also.
show that you had paid taxes earlier.
But
Haven't given any-
it is in the computer, my lord, it is blocked to say that I have produced the annexure here is my Kata certificate and
But they haven't produced any such documents
Rittal
to prove
produced,
the
but
earlier.
it is available in the, if you go to the Kata number, it is
Sir, here is the possession certificate.
possession certificate, that is the land.
That to show that the Kata was standing in your name.
But Kata certificate, my lord, I have not produced, but it is available. Only thing is, in the website, my lord, it is blocked.
Really the block ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ?
ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ಅವ್ರು, ನಾವು DD ಕೊಡ್ತೀವಿ 1 year ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ತಗೊಳ್ಳೋದಿಲ್ಲ.
My lord, they have to produce any tax receipt,
If
correct?
the Kata was already standing in his name,
Okay.
you will have to accept taxes in it. If somebody is coming and paying you money, you're saying, no, I don't want your money. You accept it subject to whatever rights you have.
And we haven't received any further instruction from the BBMP.
We'll list.
24th. 24th.
Insist by then.
24. Seal number 22. Okay, Kumar M. Kumar M.
Response in this case, my lord.
This is a issue endorsement, affecting the e-Khata matters covered by the judgment of coordinate bench of these two. I have placed on record. They have no objection to allow the writ petition matters.
Set aside the endorsement, annexure C.
Land was converted and later they have sold the sites. I have placed the judgment also on that matters.
Who's opposing you?
But
Mr.
response not
Person-
appearing.
Yeah.
The para number 6 of the writ petition says, my lords, there is a covered judgment, not in which, my lords, the Honorable High Court was pleased to allow the writ petition directing the respondent to consider the application for e-Khata. But however, my lord, issuance of e-Khata will not, my lords, provide any rights to the petitioner to get construction, my lord.
To get to?
Construction.
Develop
Hence
the
a
land.
separate plan that is altogether different. Affecting the Khata, he has no objection, but it does not give rise to a
Unless, my lords, he obtains the sanctioned plan. My lords,
that
from
is a separate
planning
separate
authority.
issue.
The prayer in this writ petition to set aside the endorsement dated 24/5/2024. The Crown the layout has been formed without obtaining any permission. And then counsel for the petitioner places reliance on the judgment rendered in WP 19538/2022 and contends that a similar endorsement issued
By the very same respondent.
by the respondent herein was washed by this court. And this court had directed the municipalities that they are bound to register the Khata in the light of section 113 of the act. And accordingly directed them to register the Khata. In the said order, it is also stated that the registration of Khata in favor of the petitioner would not confer any additional right on him when developing the property. And the petitioner would have to obtain necessary permission from the planning authority under the provisions of the KTCP Act and the applicable municipal laws when he intended to develop the property. And counsel for the respondent does not dispute this position of law. In light of the above, this writ petition is disposed of in terms of the order passed WP 19538/2022. And the municipalities had Khata in favor of the petitioner. But it is made clear that this region of Khata would not confer a right on the petitioner to develop the property without securing necessary permissions from the planning authority or under the relevant municipal laws. The petition accordingly disposed.
Endorsement request, quashed.
The endorsement as a consequence.
Annexure
endorsement, Annexure C shall stand quashed.
Apply.
Apply.
Some
Number
time
23.
frame may be, correct. Some time frame may fix for us for that.
8
The
weeks, my lords,
taxes
maybe.
as aforesaid shall be completed within a period of 2 months.
Apply.
Seal number 23, Sri Srikant Patil.
I appear for the petitioner in this case, my
Yes,
lord.
I appear for the first respondent.
The last
My lord, I
occasion, my
filed
lord.
power on 7th of this month.
What is the direction to file?
My lord, on the last occasion, liberty was reserved to the my lord petitioner to apply for the trade license with the respondent, my lord. The case where, my lord, that
What is this non-filing report on 18/12/24? What is the order?
my lord, the in 1812, my lord, since there was no representation on the part of the respondent corporation, my lord.
ಯಾವ್ದು ಹೇಳ್ತಿದ್ರು? 28787.
ಹೌದು.
Wakala, my lord, we filed the wakalat only on 7th, my lord.
Yes.
ಅದು last time ಬಂದಿತ್ತು.
1812.
1812.
Now that the corporation is represented, my lord, that does no direction.
ಕಾಪಿ ಕೊಡಿ, ಕಾಪಿ.
So you are directed to, you are permitted to do the internal work.
Please, my lord, and also to apply for the trade license, my lord, according they have applied for the trade license and the corporation has issued the trade license. Therefore, only thing is, my lord, they may be directed to issue the, my lord, sanction approval, my lord, on the basis of, my lord, the deemed sanction, my lord. Because a deemed sanction, they don't have to grant you a deemed sanction order. Yes, my lord, that may be declared, my lord, and I may permitted to occupy the premises, my lord. What is annexure A? Annexure A is the order passed under section 321, my lord.
And there is an appeal provision and 321(3) ನಲ್ಲಿ ಹಾಕಿರೋದು 444 ಒಳಗೆ they have to go before the district judge.
No, but if they have given an application for modification of the plan, and if you not taken any action, then obviously this becomes unenforceable, isn't it? Yes.
Yes. I leave it to your last.
But you accept this as a deemed approval,
Beg your pardon, my lord. 321(3) we have passed the order, my lord.
except that he has given a. fresh
That I have to verify, my lord, because I have filed my power only on 7th of this month. That's the reason why, my lord,
Why did the authority not engage you to appear?
lord, I have no idea.
What is the report that is to be filed? Yaar ಮಾಡ್ಬೇಕು report?
That is the commissioner, I think there is a direction, no? Commissioner,
No, Secretary Urban Development Department to
urban development.
call for a report.
Seek instructions, because
On 18/12/24, there's an order asking of the Secretary Urban Development Department to file a report as to why there is no representation being made on behalf of the local bodies.
please, my lord, there was a direction, there was no representation on that day, my
Hey, therefore, Secretary Urban Development Department was asked to file a report. Where is the report?
lord. I'll ascertain, my lord. Monday I will.
The report as directed by this court on 18/12/2024 has not been filed. Then AGS seeks for a week's time to file the report. If the report as directed earlier is not filed, the Secretary Urban Development Department shall be personally present before the court. Then calls for the petitioner submits that the petitioner had applied for grant of a trade license and the respondents have issued a trade license on 2/1/2025, thereby signifying their approval for the petitioner to occupy the premises. Land Council appearing for the respondent name,
First respondent, sir.
fix time to secure instructions. Relist on next Friday.
24th.
Please.
Number 24, Shri A. Mahesh Chaudhary.
Appear for the petitioner in this matter, your lordship. Your lordship, in this case, they are not processing my application to change of land use from industrial purpose to residential purpose. On the ground that there may be a potential acquisition of my survey number by the government. On that ground, your lordship, this issue is squarely covered by the judgment of the coordinate bench in WP number 19174 of 2022.
Annexure A.
Annexure A, yes, your lordship.
Annexure A says that they will not process your application.
No, they say it is kept in abeyance. First, they cite a government order to say that it can't be processed. And then they say until they have further clarification from the government, they'll keep it in abeyance. They will not process it.
Annexure A was withdrawn, my lord. The annexure, my lord, page 22, annexure B. B, my lord, the
Lordship,
second page
it may be-
23, my lord, the.
It may be recorded that it's withdrawn because we've not received anything from their side to say that it is withdrawn.
My lord, page 23, my lord, it was, my lord, the referring the judgment, my lord, similar, may I read, my lord. ಪ್ರಶ್ನಿತ ಜಮೀನುಗಳನ್ನು ಪ್ರಾಧಿಕಾರದ ಉದ್ದೇಶಿತ ಮುಂದುವರಿತ ಅರ್ಕಾವತಿ ಬಡಾವಣೆ ಯೋಜನೆಯಲ್ಲಿ ಒಳಗೊಂಡಿರುವುದು ಹಾಗೂ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ವಿವಿಧ ಪ್ರಕರಣಗಳು ಸೊ ಅಂಡ್ ಸೊ ದಿನಾಂಕ 24 ತೀರ್ಪುಗಳಲ್ಲಿ ಪ್ರಶ್ನಿತ ಜಮೀನುಗಳು ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ಉದ್ದೇಶಿತ ಮುಂದುವರಿದ ಅರ್ಕಾವತಿ ಬಡಾವಣೆ ಯೋಜನೆಗೆ ಒಳಗೊಂಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ನಗರ ಮತ್ತು ಗ್ರಾಮೀಣ ಸೊ ಅಂಡ್ ಸೊ 14A ಅಡಿಯಲ್ಲಿ ಉಪಯೋಗ ಬದಲಾವಣೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಗಣಿಸುವುದಿಲ್ಲ ಎಂದು ನೀಡಲಾಗಿರುವ ಹಿಮ್ಮರವನ್ನು ರದ್ದುಗೊಳಿಸಿ ನಿಗದಿತ ಕಾಲಾವಧಿಯಲ್ಲಿ ಕರ್ನಾಟಕ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನಾ ಕಾಯ್ದೆ 1961 ಅಡಿಯಲ್ಲಿ ಕ್ರಮ ಜರುಗಿಸಲು ಆದೇಶಿಸಲಾಗಿದ್ದು, ಈ ತೀರ್ಪುಗಳ ಅನುಸಾರ ಅರ್ಜಿದಾರರು ಈ ಪ್ರಕರಣವನ್ನು ಪರಿಗಣಿಸಲು ಮನವಿ ಸಲ್ಲಿಸಿರುವುದನ್ನು ಸಭೆಯ ಗಮನಕ್ಕೆ ತರಲಾಯಿತು. ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಯಲಹಂಕ ಗ್ರಾಮ ಸೊ ವಿಸ್ತೀರ್ಣ ಜಮೀನನ್ನು ಕೈಗಾರಿಕಾ ವಲಯದಿಂದ ವಸತಿ ಉಪಯೋಗಕ್ಕೆ ಕರ್ನಾಟಕ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನಾ ಕಾಯ್ದೆ 61 ಕಲಾಂ 14(7) ಅಡಿಯಲ್ಲಿ ಉಪಯೋಗ ಬದಲಾವಣೆ ಕೋರಿರುವ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಸಂಬಂಧಿಸಿದ ಹೆಚ್ಚಿನ ಮಾಹಿತಿ ಅವಶ್ಯಕತೆ ಇರುವುದನ್ನು Immediately they,
Annexure A is, can withdrawn.
immediately they filed the writ
For
petition.
further information,
They've not, your lordship, they have not asked any further information from us. They've simply
not
mentioned.
from you. They want some information. As soon as it's secured, they will pass an order.
23,
lordship,
this order was part
can't-
23, 29 they filed the writ petition.
Your lordship, it can't be open-ended because a similar issue came up before a coordinated bench and the coordinated bench had fixed a timeline.
This communication addressed to you,
Yes.
in
No,
which they have stated that the endorsements issued have been cancelled. In order to consider the application, they require some more information. Therefore,
So your lordship, in which case, I just request your lordship to see one judgment of the coordinated bench where a timeline of 3 months was fixed in a similar matter where it was kept abeyance for want of more information. A timeline of 3 months was fixed.
I think your prayer is misconceived. You're honestly asking for quashing of an order which no
Because-
longer survives. What is annexure B?
B is
Annexure
the
B is
matter,
what
the-
was just read out, your lordship.
Annexure A is what you read out.
We've sought for quashing of annexure B. Will not press for annexure A, your lordship, in which case, only thing, your lordship, I'm submitting a memo of citation. It's already been placed. A 3 months timeline may be fixed.
Annexure B, if you want them to, if you want annexure B to be quashed. That means.
No, I'm rephrasing it, your lordship. It need not be cost. All that I'm seeking is let them take any decision that they want to take as per law, but let it be in some timeline, your lordship. Let it be in 3 months.
The prayer in the petition is to quash annexure A, which is dated 6/3/2024, and annexure B dated 23/10/2024. A perusal of the said annexures reveals that the planning authority was initially of the view that applications for change of land use would not be considered since the lands of the petitioner could be required for future acquisition. So however, annexure B clearly indicates that such endorsements have been cancelled. And since further information was required for processing the application, the petitioner was sent a communication enlightening her about the circumstances leading up to the issuance of annexure B. Since in annexure B, the planning authority has stated that they are awaiting further information to process the request of the information for a change of land use. It would be unnecessary to entertain the prayers A and B, and would be sufficient to direct the planning authority to consider the application of the petitioner for change of land use within a period of.
My lord, it has been forwarded to the government.
Early time and is.
Yes, my lord.
Much time?
We will, my lord, within 3 months, we will forward it to the government.
Within a period of 3 months from the date of receipt of a copy of this note.
My lord, to forward the government because ultimately approved
your
by the
lordship.
government, my lord. We have-
Within 3 months.
Within 3 months, yes, your lordship.
within 3 months, we will consider and forward it to the recommend.
What
to
is the party here?
Government is party, ma'am. Because the ultimately approval has to be given by the government.
Forward the proposal for change of land use to the government within a period of 2 months, and the state of, and the government shall within a month thereafter pass appropriate orders.
Yes.
On the said proposal.
Number 25, Shri B.S. Nagaraj.
Steps
Who's
to
the
R7, steps to R7 ಮೇಲೆ
Seven ಯಾರು?
R7 party ಮೇಲೆ GS Pratibha.
What is their interest?
Writ of mandamus ಮೇಲೆ
ಯಾರಿಗೆ?
for R6 video.
Weeks time is going to be made.
Bill number 26.
This is a matter where on an earlier occasion when the petitioners had approached this honorable court, challenging the Nagarasabha of Kollegala having directly claimed the property. On a writ petition, the direction was issued that we should first exhaust the remedy of an appeal before, as per annexure A. That the appeal was registered after direction previous writ petition, my lord, in
What was
to-
the appeal about?
the appeal is pertaining to give a finding of the property on the ownership rights claimed by the petitioners. Instead, my lord, the deputy commissioner proceeds to hold with on the basis of a unanimous decision taken up by the in the meeting of the Purasabha, placing it on his record, comes to the conclusion that the property belongs to, though he records the fact that the sale deeds of the parties are produced. It's a private land, my lord, private sites.
The order is only saying that he does not have jurisdiction, the matter is referred to some other authority.
I'm referring to annexure A, my lord.
Page 38.
But he says that it should be taken, possession is to be taken on.
Please read ಮೇಲ್ಮನವಿ
last-
ವಜಾಗೊಳಿಸಲಾಗಿದೆ.
Just dismiss the petition. Last sentence in the previous para, just before the last ಆದೇಶವನ್ನು ದಿನಾಂಕ 8/8/24 ಅಂತ ಇದೆ.
Notice for respondents 1 and 2. Who appears for this municipality?
ಕೊಳ್ಳೇಗಾಲ,
Who appeared on the last occasion?
MS Dev.
MS Devaraj director's notice for R3. Same list in B group. The meantime of subjection be completed.
Spread for in,
ಯಾರು ಬರ್ತಾರೆ? Who appeared for the municipality earlier?
who appeared last time? Order really, WP. Earlier order. Next.
Where is the earlier order?
Earlier order.
I think that is.
Vakil.
Split ಆಗಿದೆ.
I'll verify and submit to the official.
Petitioner
Interim stay I have sought. Let them not.
of the appeal, what can I stay?
No, but they are trying to take possession of the property which we are in occupation. Not, let them not disturb our possession.
Where is the?
Based on the finding, they are trying to take possession now. I have prayed in the interim order portion.
Did you have an interim order in the appeal?
My lord, yes, my lord.
It is discretion of special direction ಕೊಟ್ರಲ್ಲ.
The interim prayer I am seeking is that they'll let them not dispossess me. Stay of dispossession is what I am seeking.
Status quo as on today be maintained. Petitioner will take out notice personally. Take out notice personally on R3.
Yes, please.
Officer.
Seal number 27, Shiv Kumar N.
Lord, my lord, the petition is filed seeking, challenging the validity of section 27A of BBMP Act 2020, my lord, which gives for definition of building, which includes telecommunication towers, my lord. The same is ultra-vires the constitution, my lord, as entry 52 list 1 of the union list in schedule 7 provides for the parliament to enact laws, my lord. And in lieu of the same, the central government has passed the Telecommunications Act 2023, my lord. Section 14(3) of the Communication Act specifically provides that in page number, just a minute. Page number 202, my lord. 201, Annexure D Telecommunication Act, my lord. In page number 207, section 14, subclause 3, my lord, provides specifically for specifically, my lord, the telecommunication network installed on any property shall not be considered as part of such property, including for the purposes of any transaction related to that property or any property tax, levies, cess, fees, or duties as may be applicable on that property, my lord. Now, my lord, the BBMP has issued, my lord, annexure demand notices, my lord, seeking the landowners to pay tax on the telecommunication towers which are installed in their property. Annexure E to E42 are the annexures which have been sought to be stayed, my lord. This court has already, in another writ petition, my lord, WP 28017 of 2024, has passed an interim order, my lord.
staying the demand notices, my lord.
The parliament has the competence to pass a law regarding property tax to be levied by the state government.
My lord, that is the entire issue, my lord. The union government has laws to make, has powers to make laws with regard to such industries, my lord.
Make this, the first part of 14.3 I accept. Saying that the telecommunication network installed on any property shall not be considered as part of such property. That is fine.
Yes,
They
my lord.
can make the declaration. Including for the purpose of any transaction related to property or any property tax. Property tax is independent of.
No, my lord, only with regard to the telecommunication towers, my lord.
If that telecommunication tower is a part of a property, if they consider that to also to be a property for the purpose of taxation. How
They
can
are telling, my lord, section 278 provides for the definition of building, my lord. They say that telecommunication is also a building.
That is their definition, but
Yes.
until you challenge that particular provision,
Yes, my lord.
have you challenged that provision?
Yes, my lord.
Which is that provision?
Section 27A, my lord. One second, my lord. Annexure C, page number 71, my lord. In the end, my lord. Last, my lord, subsection 7, building includes a house, outhouse, table, privy shed, hut, wall, veranda, fixed platform, flat doorstep, and any other structure, including telecommunication.
This is a definition of a building for the purpose of taxes.
Yes, my lord.
This is not nothing to do with 14.3. 14.3 only says it won't be a part of that property. But it can always be a building which can be taxed.
That is the entire issue, my lord. The court has already passed interim orders.
Then Pawan, ಬೇರೆ matter ಇದೆಯಾ ಹತ್ರ?
Yes, my
The
lord.
matter was there, but I don't remember the case number. Similar issue was. I believe Udayawala sir appeared.
Bhushan. Is there take notice for R1? AGA is there take notice for R2 and R3. Kumar accepts notice for respondents 4 to 21. It is stated that the issues raised in these matters are similar to the issues raised in WP 28017/2024 and also WP 35883-88 of 2016 and 26290/2024. Hence, post these repetitions along with the said repetitions. There should also be an interim order in terms of the order plan, the above repetitions. Liberties are over granted to the respondents to seek qualification.
We are filing objection, my lord. Kindly
Sorry.
grant. Union of India.
Hakidara,
Illa, we are filing. Kindly granted 2 weeks time.
file it.
So what, 28, Sri Radhanandan BS?
The Assistant Commissioner has filed the report.
Sorry, my lord, yesterday I am not.
ನೋಡಿದ್ರ affidavit ನೋಡಿದ್ರ?
Please, my lord, in respect of my submission, my lord, para number 18, my lord, in the affidavit, they say that, my lord, they rectify the rectification of the made by the, sorry, they will made, my lord. Then after, my lord, we'll consider. And also, my lord, Ratnama give complaint to the authority not to release. On that regard, my lord,
No, if this is resolved,
please,
can you take cognizance of Ratnamba's complaint?
No, I'm not concerned, my lord. Let them, my lord, after rectification, my lord, we will consider, my lord. Otherwise, we can't. Because records are hange ide adu.
This affidavit is not sufficient for you, that they accept there's a mistake.
No, that is the reason, my lord, lordship, my lord, say in the order, my lord, to regarding after rectification, my lord, consider, they will submit the report and will consider. This is my submission, my lord.
An affidavit is filed by the assistant commissioner.
One submission by.
Filed by the assistant commissioner. In which he has stated as follows, para 18. Learned counsel for the planning authority submits that as soon as the assistant commissioner rectifies the error, the authority would proceed to consider the application of the petitioner. In the light of the above, the Assistant Commissioner is directed to rectify the error which he has acknowledged in para 18 of his affidavit and report the same to this court on or before 2 weeks time.
My
Within
lords,
2 weeks,
three-
let him do it.
My lords, 3 months, because we have to issue the notice, my lords, notice issue ಮಾಡಬೇಕು.
ಏನ್ ಮಾಡ್ತಾರೆ 2 weeks ಅಲ್ಲಿ ಮಾಡಿ?
My lords, 2 weeks is not sufficient, at
Or
least,
else you're holding up somebody's right to enjoy the property.
at least 8.
Relist on.
31st.
Please.
Seal number 29, Pawan JK.
My lords, I'm appearing for the petitioners. There are minor objections, my lords. I will comply in a week's time, my lords. My lords, I approached this court to consider the representation, my lords, and also to execute the order, my lords, which has been passed by respondent number 2, my lords.
What is Annexure G?
My lords,
What is Annexure G?
my lords, Annexure G is the order passed by the respondent number 2, my lords.
ನೀವು neighbor,
My lords,
you're a neighbor. You're asking for implementation of an order of
yes, my
confirmation.
lords, yes, my lords.
You're the neighbor.
Yes, my lords, I am the neighbor, my lords. My lords, my adjacent landowner, my lords, he has encroached my property and he has constructed a building, my lords.
Then go file a suit.
My lords, this order has been already upheld by the BBMP Commissioner, my lords, respondent number 3, my lords. And in the previous round of litigation, my lords, this very honorable court has also directed and they have also undertaken to implement the order, my lords.
ನಿಮ್ಮನೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ?
Yes, my lords.
No deviation.
No, my lords.
Sure.
Yes, my lords. My lords, because they did not implement the order, my lords.
2 and 3, AJ to take notice for R1. We'll list for 2 weeks on date court. In the meantime, officer should be considered.
31st. Seal number 30, Suresh Babu.
Pursuant to the order, my lord, on Annexure C, I preferred an appeal, my lord, at Annexure E is the order which has been passed, my lord. Pursuant to the order of the Annexure C confirmation order, I have made some changes, my lord. It is a complaint by the neighboring property owner who has not at all left any setbacks, who say that I have left, my lord, my setbacks are as against 1.5 meters, I have left 1 meter. It's not that I have not left any setbacks, my lord. I had the benefit of interim order in the proceedings before the appellate authority.
The Pawan Kumar to take notice for respondents. 1 to 4. Issue notice to R5. Petitions of permit take out notice on R5 person. In next date of hearing, there should be an interim stay of annexures.
See, my lord, confirmation order. I may be permitted to correct it, my lord. There's 2 errors which are there, which is the opposite.
One of these days, let me know in which case we'll decide that you can't go against the building until you go against engineering. Because until that is rectified, this will go on forever. Go on. ನೀವು ಯಾವತ್ತು ಹೇಳ್ತೀರಿ, ನೀವು ಯಾವತ್ತು ರೆಡಿ ಆಗ್ತೀರಿ ಹೇಳಿ, ಒಂದು ಕೇಸಲ್ಲಿ ವಿಲ್ ಪಾಸ್ ಅನ್ ಆರ್ಡರ್. I think Nayanthara's case yesterday.
Yes.
That particular case, you come and argue on that day, will pass an order.
In fact, this honorable court has already held that the ADTP has no right to, has no authority to.
ಏನೋ stay ಆಗಿದೆಯಾ?
The stay has not been set aside. And also there are directions by this honorable court in the writ appeal that they should specify what are the deviations, everything, their guidelines has been formed and notices are issued in contrary to the guidelines.
ಇದೆಲ್ಲ rectify ಮಾಡಕ್ಕಾಗಲ್ಲ. Monday get ready.
Monday will be too short. I will need to take instruction.
How long will it take to get ready? You just need to find out whether the rules are framed or not. I've been telling you for 2 weeks, but now you should
Yes, sir.
get ready on Monday.
Seal for hearing on seal number 31, Shri Bharat Muralidhar.
Lord, I was here for temporary injunction, my lord, but my instructions are that despite there being an interim order, the BBMP has gone ahead with the construction of the Nala. With regard, I have asked for a restraining order not to construct the Nala, my lord, on my property. They have.
There is to prevent them from excavating in the scheduled property.
Yes, my lord.
It's already excavated.
My instructions are that despite there being an interim order, now they have, so I've asked for a photographs of the property.
What can be done here?
No, my lord, I don't want to, I have asked for the photographs. I'll produce that along with, it can be decided finally, my lord. The
My
ma-
lord,
the
there
writ-
are two reports being filed by the different
Correct.
authorities. They have sought for mandatory injunction as against the corporation, not to farm the drain in such. I have placed a record to show that, my lord, there is already existing drain.
I have filed
To
detailed
dispute that,
objections
they
to
have
the
once again requested the Honorable Court to appoint one more commission.
Prayer of this kind in writ petition is untenable.
My lord, this was.
Not ask for an injunction in the writ petition.
Correct, my lord. This was filed in 2016, my lord. When we filed the 2000 writ petition in 2016, there was an undertaking from the respondent side that they are, because at that point in time, they were only marking the scheduled property, my lord. From 2016 to 2023, based on their undertaking, there was no construction that they had also taken up. Only in 2023, they started excavating. That's when, which prompted me to file this IM, my lord. And after considering the contentions in 2023 on 5/4/2023, this court passed an interim order and also directed for a survey. Survey has been conducted thrice, and I filed my objections to that survey report also.
5/4.
2023, my lord.
By 4 or 10/4.
Five four, my lord. May I read out the order?
Report ಹಾಕಿದಾರಾ?
Either report, there are three reports being filed, my lord.
There were reports called for, my lord, and basically.
Where is the
All the reports says that, my lord, there is already existing a drain.
6/11/23, government has filed. 6/11/23.
One is 6/11 and another one 15/12/23, my lord. Madam, date ನೋಡಿ, date of filing.
So the drain is already constructed.
My lord, it
This
was
photograph-
not until recently, my lord. That is my instruct, because since there was an order continuing in this matter.
It's not a new construction, my lord. Your lordship may kindly find out the photo. You can see the existing drain, my lord. It's old structure.
Lord, I've filed all the Google Maps, Google Earth
Google map
pictures
does not
from
describe what exactly the situation as it
2002
is.
to 2024. It clearly indicates there was no construction whatsoever. I have produced documents.
You
May I
dispute
request this?
You dispute this photograph? Filed
No,
along
my
with,
lord.
the memo dated 6/11/23.
Not with regard to that, there is a concern, but I am not sure whether that particular photo, what they have produced is passing on the scheduled property. That is my, let me ascertain that, my lord, and also there is an instruction from.
If you don't dispute this,
Yes,
and if this happens to be
my lord, the photographs pertaining to, I am not sure what photographs.
6/11/23.
6/11.
23, the memo that is filed on 6/11/23. The remedy would be elsewhere.
Exactly, my lord.
If they've already formed the
Drain.
drain,
Yes, ma'am.
then the prayer that you have sought for
Correct, my lord.
is
I
gone.
very well agree, my lord. Let a date be fixed next week, my lord. This writ petition can be disposed of finally.
The thing is, it will become infructuous.
Yes, ma'am. Yes, I will have to file a separate alternate petition.
List. 24.
Till number 32. Timothy Bina.
Page number 142 and 145. Annexure T and U. Both are the
Yes,
representations given to
The last
BBMP.
occasion, my lords had
Correct, the
asked the BDA.
BDA to verify whether this, the owner's portion of the land and the authority, whether it is included in the survey. It is included and the FAR was also given, my lord. In the map itself, my lord, the page 63 itself shows the calculation, it was mentioned, my lord. Page 63 of the map. This portion of the land is included and it is meant for the rain harvest and the STP. If they want to change, my lord, they have to seek the modification. Without the modification of this plan, my lord, they cannot shift the STP some other place. Now, since it is the area, my lord,
What is the meaning of owner's reserved space?
my lord, that portion is reserved for the STP and the,
Then why did you use the term owners used, on a reserve for it?
since they have to construct the STP and the rain harvest in that place, that was mentioned, well, because,
If you're sanctioning a plan
yes,
for
ma'am.
an entire plot, they have to have that STP and that rainwater.
That,
But
for
if
that,
you demarcate a particular land being reserved for the owner's use,
that is only they mentioned it is, because entire area, my lord, for the STP and the water harvesting.
so long as they provide for that,
Yes,
then what remains?
my lord, now they want to shift that area for some other, the other place. That they can do only after obtain the modified plan, my lord, and obtain the consent of
Done.
2/3 of the occupants. As per the RERA Act, they have to seek the modification, then,
If it is relation to the building, you're right.
yes,
But even in respect of the STP and the
Yes.
rainwater harvesting
yes,
system,
my
they
lord,
have
it
to
was,
seek-
even shifting, my lord, to other place, it is the amount to modification of the building plan, my lord. Because this area is also included in the approved modified, the building plan. If any changes to that, my lord, they want to shift to some other place, they have to seek the modification of that building plan. For seeking of the modification, my lord, they now, since the building is constructed, occupants are occupied, that as per the RERA Act, my lord, 2/3 of the occupants consent is required, minimum
Let us
2/3.
see that RERA.
RERA is not applicable.
My lords,
Your lordship.
RERA is not applicable. What has
But in
happened,
RERA
this was
project-
shifted way back in the year 2010. And it was modified by way of an modified plan as well as which is approved and ratified, my lords, both by the KSPCB as well as by the BBMP, which became the plan sanctioning authority at that point in time in the year 2010. I have already produced the detailed notes during the occupancy certificate, my lords, where they have allowed me and regularized this deviation after collecting the fees. And at that point in time, my lords, I had not even sold all the flats, because at that point in time, before the occupancy certificate was obtained, I could not have given the possession to the residents of the flats. Only after the occupancy certificate is obtained do those residents have taken. In fact, my lords, for this very STP, they have taken, the Residents Association has taken a sum of 9 lakhs in the year 2014, and they say that we will not claim against you. This very aspect I have produced, my lords, as part of my statement of objection, because there is a road cutting through right in between. Kindly see my statement of objections for a
How do you get
photograph.
over that FAR, if you use this particular land?
My lords, the FAR, my lords, also I will come through. The FAR, my lords, as approved, only I had taken, although I had the approval for, although I was allowed for 2.25 FAR, my lords, because this falls within ring 3. And there is a 50 feet road that abuts on both the sides. I am allowed 2.25 FAR. I had taken only 1.25 FAR, my lords. I utilized 1.29, which is within the permissible limits of deviation. Now, my lords, in this 2018 impugned sanction plan also, it makes it very clear. Even if I add on to the plan, I will not exceed more than 1.52, which is far lesser than the 2.25 FAR that I am allowed under the zoning regulations.
2.25 you're allowed when you got the plan approved?
My lords,
2.25 FAR.
as per the zoning regulations, I
Original-
have taken approval only for 1.25.
The original zonal regulations, when you got approval,
Howdo?
what was the FAR permissible, 1.25 or 2.5?
2.25, my lords. That is the standard in the zoning regulations. If your lordship sees, zoning regulations clearly specify and mandate, I am allowed 2.25. It is at chapter 7, table 20, my lords. Road width above 12 and up to 18 meters.
Apply for the plan,
Plan is applied, my lords, in the year 2007.
by the exact date,
The exact date I'll just provide. my lords. Petition.
when was it approved?
2006, my lord.
1 second, my lords. I'll just.
petition.
But it is approved from 29/3/2007 to the
63.
validity, my lord, 29/3/2007 to 28/3/2009.
29th of March 2007, my lords. Then subsequently,
By BDA.
Yes, first plan is approved by the BD.
and then in November 2007 is the
The FIR is for,
My lord, FAR
approval
including
I have
this-
taken for 1.25, my lords.
then when was the OC given?
OC in the year 2010, my lords. By that time, zoning regulations had already come, the zoning regulations insofar as the master plan. New master plan was issued in the year 2007, RMP
Where is the
2015.
date of the OC? You said something about
My lord, the
modification.
date of the OC is 11/10/2010, my lord. 11/10/2010 is the date on which the OC has been issued by the BBM. By that time, my lord, may I just make a submission, my lord? 2007, my lord, 2006 or 2007, my lord, I'm not very particular about the date. The BDA had issued a sanction plan in respect of this project. Subsequently, this area fell within the jurisdiction of the BBM. They applied for a modification plan, modification of the sanction plan as on 12/5/2010, my lord. And when an application was made, my lord, the STP and the rainwater harvesting, my lord, it was at a separate place, my lord. Wherein, my lord, for the issuance of the rainwater harvesting as
When
well
you-
as
when
the
you-
pollution,
When you gave the OC,
please, my lord.
did you notice that the STP was in the first notified place or
No, no, no. When this was issued, when the modified sanction plan was
who issued
issued,
the OC?
the BBMP, I issued the,
So when you issued the OC,
please, my lord.
it presupposes that you had inspected the area
Please,
and
yes,
found that the building was constructed in accordance with the sanction plan.
please, yes,
Correct.
yes.
So then, where was your STP at that point of time?
STP, my lord, as per the initial plan, my lord, issued by the BDA, it was at a distinct place.
When you
Now subsequently, my lord, when they make an application for the issuance of a modified plan, I then ask them,
asking, I'm going one step behind that, beyond that. When you granted the OC,
please, my lord.
what is your finding regarding the location of the STP?
STP, my lord, it is within the area as it is situated as on date, my lord. That is, it is not,
It was already located in a different place.
yes,
And yet you
yes.
gave an OC.
Subsequently, I gave the OC.
You accepted the location, shifting the
Yes,
location.
yes,
And yet gave an OC.
yes,
Why did you do that?
your
my lord,
Why did you do that?
my lord, when they make an application for the modification of,
Modifications after they gave the OC, right?
no, 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 no. Prior to No, the my OC, lord, my no. lords, prior to the OC. The prior to the application for occupancy certificate. modification of the sanction plan, my lord, was issued on 12.
We need to grant the modification.
My lord, the application was filed on 12/5/2010.
When was it granted?
The modified sanction plan, one moment. It was
2001.
21/9/2010, my lord. And then the occupancy certificate is
And
dated,
thereafter it is given.
occupancy certificate is dated 11/10/2010. In the interregnum, my lord, between these two dates, as to when an application for modification of the sanction plan was filed and the date on which the modified sanction plan was approved by the BDM, my lord, I had asked them to get a certificate from the Pollution Control Board as regarding the consent for discharge. That is mandate. They had obtained that. Subsequent to the owners or the builder,
The effect of you approving the modified plan,
please, my lord,
which modifies the original plan,
please, my lord,
which pinpointed the location of the STP and rainwater harvesting.
as per the old one, my lord.
When you modify it,
Please, my lord.
that means you are permitting the shifting of that
Yes,
particular
yes,
STP.
yes, yes.
Then you had no objection.
No, no. I had, in fact, my lord, this was a condition, my lord, that they will have to shift this here. Because when they gave an application for modification plan, they wanted that STP to be shifted from that particular area to area close by.
So you permitted the shifting for consideration of the modification.
Please, yes.
So therefore, it's a legal shifting.
No, it is
You
legal
permit them to
shifting.
shift.
Sorry, it is legal shifting. Yes, my lord. Yes, I permitted that. Now this, my lord, the modified sanction plan, my lord, having been approved in the year 21/9/2010, my lord. Subsequently, occupancy certificates are given.
Correct.
Once subsequently occupancy certificates are given, my lord, I perceive that all the sale deeds which had taken place subsequent to the date of issuance of the occupancy plan. Now, when I had issued the occupancy certificate as in the year 2010, till the year 2018, my lord, nobody raises an objection as regarding the occupancy certificate, which is based on the modified sanction plan. This being the situation, my lord, as in 2018, the owner or the developer, as the case may be, my lord, they had filed an application stating that we want a sanction plan in respect of the area which is in dispute, my lord, stating which is in dispute, my lord.
This 2010 modification was for what?
My lord,
2010 modification plan.
please, my lord.
What was it for?
My lord, they had applied stating that this STP is being shifted from that particular area to this particular area.
No request was made for putting up a fresh construction.
No, my lord, no.
My lords, what had happened in the modified plan, if I may explain, my lords?
In the modified plan, my understanding is correct. They permit the shifting of the STP.
STP and RWH both.
What was this area shown as in the modified plan?
In the modified plan, it is shown as vacant land only, my lords. Owner's reserved area antane heli torsutte. That plan,
The modified plan.
my lords, that if your lordship sees,
That they have submitted, state has submitted, your lord.
Yes.
I've submitted, my lords, as well.
This I don't think is taken, that is the owners, this, my lord, I don't think this had been taken into consideration while issuing the modified.
Yakanta helidre, that area was separated. By that time, the road had already come up, my lords. This area was not even shown, my lords, in that plan because that area was separated.
No, Samit, this 21/9/2010
Howdu,
is the modified approved plan.
howdu.
That only, if what he says is correct, only permitted you to shift the STP.
STP.
In that modified plan, whatever was reserved for that, in that particular area, where STP was earlier situated, that will prevail.
Yes, yes.
My lords, no, what happened is STP and RWH was given one. May I just kindly point out one photograph, my lords? It makes it very, very clear to your lordships what has happened and what is the situation. May I just point out one photograph in my statement of objections? If your lordships kindly sees the statement of objections at paragraph number, page 24, my lords. My statement of R1 statement of objections, page 24, I have produced a photograph.
In 124.
Is that? Photograph, 18, none objection.
Get me the modified plan.
My lord,
21/9/2010.
modified plan 14, so that is the big plan.
The big plan. My lords, may kindly see page 24. The area in dispute is what is shown in green, future development anta. At the time of the plan sanction, my lords, this road area, what is shown in blue, was never in existence. What had happened is, at that point in time, the CDP was about to come. When I applied for the plan, the CDP was about to come. They stated that ee road barbohudu anta heli. Adakage, although I had shown as an STP and RWH at that point in time when I was obtaining the plan, therefore, my lords, I had not relinquished it. It is a subsequent relinquishment when the BBMP actually came to form the road subsequent to the issuance of the revised master plan 2015. I got to know that it is impractical and, my lords, it is not at all possible to have a sewage treatment plant and a rainwater harvesting across the road right now. Thereafter, my lords, I was forced to shift this entire STP and RWH inside the apartment complex where I constructed. That, my lords, for that, I applied for a modified sanction plan and I have taken the permission. I have also taken the permission from the KSPCB at that point in time in the year 2010. Now, my lords, I had asked a relevant pertinent question on the aspect of FAR. Whether, my lords, I have...
Stop there for a minute. If the modified plan of 2010, 21/9/2010 subsists, according to that, there should be a road and there should also be vacant space across the road, correct?
Yes, correct, my lords.
Now, if that is correct, the modified plan contemplates the entire plot to be one plot, separated by a road.
Yes,
separated by a road.
It's reserved for
future
which is
development.
reserved as a vacant property. No purpose is assigned in the modified layout plan. How can you go and make a fresh application as if it's an independent plot and ask for further construction?
No, my lords, I have not asked for independent plot. Kindly see the impugned plan, my lords. For a moment, if your lordship sees the impugned plan also.
Will this particular plan that is approved, will it not modify the modified plan or granted 29/2000?
ಇಲ್ಲ ಆಗೋದಿಲ್ಲ ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ All that it is giving me, my lords, is a further modification to my existing, already what was approved was only to the extent of this land being a vacant. Any land, my lords, in a larger land parcel, if I may just give an example, how it works in the BDA is above, over and above 5 acres, I need to apply for a
It's
development.
considered this third plan that you gave
Third plan in the year 2018.
as an independent.
Illa.
application.
If your lordship sees, they have not considered it as an independent plan, my
That
lord.
is the application that you gave.
This is the sanction, my lords. If your lordship,
That you gave. Did you seek for modification of this 21/9/2010 or was it an independent application?
Illa, I have sought for modification only. If your lordships kindly
That is
see,
the application.
it is part of this sanction plan itself, my lords. Adರಲ್ಲಿ ಹೇಗೆ ಅಂತ ಹೇಳಿದ್ರೆ, we give it as a plan, drawn up plan itself we give. If your lordship sees the plan that is approved, ನಮ್ಮ plan ಮೇಲೆ ಅವ್ರು seal ಹೊಡೆದು ಕೊಡುವಂಥದ್ದು. They do not, my lords, issue a fresh plan. Whatever plan I give, my lords, if it is in accordance with the regulations, building bylaws, zonal regulations, then they give their stamp of approval to that particular plan. Now, my lords, the impugned plan demonstrates all these answers, my lords. Kindly.
Page.
Impugned plan, my lords, is that annexure page
B.
31, annexure B. page
Annexure
31.
D, your lordship.
Sorry. Annexure D.
B.
Alla, Annexure B is the impugned plan.
Annexure B, your lordship.
B is the impugned plan. If your lordship sees,
Next B.
can you see the middle table, my lords?
No, this plan appears to be a plan considering this entire property as an independent property.
Illa.
This can't be a modification of the entire.
And therefore, I'm just demonstrating to your lordships, it shows the earlier plan also, existing apartment building area as per the occupancy certificate. In the middle of the page, my lords will get it. In the middle of the page, my lords, existing apartment building area as per occupancy certificate. In the middle,
What was the kata number for the original plot? Which is modified on 21/9/2010? Because this contemplates a different kata number.
I will just ascertain this. Kata number. Look, it is 391/392.
391/1 and 391 bar.
391/392. There is no bar 1 and bar.
So initially the land actually, your lordship,
My lords will see the middle, in the middle, my lords.
Is that kata number 391/392
Adu,
and 392/393?
yes, my lords.
Let us see the plan for the original project. What does the kata number say?
391 and 392.
391 and 392, but
This-
annexure D, my lords.
And 392/393 is new kata number.
Yes.
I am not, my lords will kindly see, there are two katas existing in the area of the property.
The modified plan, Samit, what is the kata number shown?
Kata numbers 391/392 and 392/393.
This is the modified one now, which is impugned. I'm asking the first one that you obtained in 2007 and
That amalgamated khata is there, your lordship.
93. 92 and 90.
That also says 392 and 392.
Page 63. ma'am.
However, BDA kata, so subsequently I got a.
what is the BDA kata? And
392 and 393. ma'am.
Page number
Survey
126.
number ಅಷ್ಟೇ. Kata number ಇರ್ಲಿಲ್ಲ. Like your lordship sees the.
Right, when it was modified? It was modified on 21/9/2010.
I just. Here also, my lords, it is just showing the survey numbers 392 and 393. The kata numbers are not. shown. The kata numbers
Which
are
is the
shown only in the
document,
modified. plan, the
amalgamated
kata
one is
numbers.
this.
It is for both the survey numbers,
Survey number is shown as 392 and 393.
392 and 392. Both survey numbers it is. Here also, my lords, it shows the existing apartment area, then only proceeds to compute the FAR. If your lordship sees in the middle of the page, my lords, for a moment, if your lordship sees the middle of the page, section schedule of joinery ಅಂತ ಹೇಳೋದು ಪಕ್ಕದಲ್ಲಿ ಒಂದು ಟೇಬಲ್ ಇದೆ. Existing apartment building area as per the occupancy certificate issued from the BBMP, which my lords gets it. As per that, FAR deviation 4.95 itto. Now, if your lordships comes to the right hand side table, combined area statement.
What do you mean by FAR deviation? You had utilized excess?
There is some excess construction, some small construction about.
Because you were all along arguing that you had utilized the lesser FAR.
Lesser FAR, my lords, the FAR.
What is this first one? Existing apartment.
Existing
Excess
apartment.
FAR.
Existing apartment, my lords, now the computation is made for 20,829, which is apart from the 21,819. Your lordship, there are 3 tables in this aspect. All the 3 tables have to be seen, and the combined area statement now shows, my lords, there is no deviation. If your lordship kindly sees the combined
Then
area.
what is the meaning of this FAR deviation?
Because it was shown as 20,829.32. ಅದಕ್ಕೆ deviation ಬರುತ್ತೆ ಅಂತ ಹೇಳಿ ತೋರಿಸ್ಕೊಂಡಿದ್ದಾರೆ.
That area remained the same, isn't it, throughout?
ಇಲ್ಲ ಅದು because my lords, originally this area was not split, my lords. This area was 21,800, 5 acres, 16 guntas was considered as a whole at that point in time. Because now we are choosing to go for a sanction plan in respect of that additional vacant land. Now they have split that entire area into 2 aspects. One is the vacant land, which is about 990.54 square meters. And one is the area that is the area on which the apartment complex was built, which is 20,829.32.
So if that particular existing apartment block is concerned, is only considered, then there is an FAR deviation.
Then that is an FAR deviation for 1.25 minutes. That becomes 1.29. That is noted in the OC notes, noting sheet. All of this is considered in the noting.
The OC was granted despite an FAR deviation.
It is less than 5% minutes. Less than 5%.
Compoundable.
It is compoundable. It is compoundable.
Yes, it is compoundable. Within 5%, my lord, it is compoundable.
It is compoundable. Then my lords will see the right hand combined area statement, which makes it crystal clear, my lords. The FAR, even after adding this entire area, is just 1.52. It is lesser than 2.25. Even after I add this particular area. And the second leg of argument, my lords, is that they say that I have conveyed this area. In fact, my lords, I'm very sorry to state this. The deed of declaration that has been prepared by the very advocate on record, my lords, which demonstrate that the total conveyed undivided share is only 19,830 square meters. Sorry, 19,038 square meters. Whereas the total site area was 21,851. Now, what I'm seeking after relinquishment of road, my lords, is 1,886 has gone for relinquishment of the road area. Now, what plan I have sought for is only in respect of 990.54 square meters, which, my lords, is never being conveyed to them, has never been conveyed to them in the guise of this particular.
So they did not get an undivided interest in the entire 392 and 393, only in a portion of 392 to 393.
We have limited it to only 19,038 square meters, my lords.
Your lordship.
And it is clear, crystal clear from the same deed also. I have just demonstrated from.
Now, let her answer this point, because if she does not have right over this, if she has an interest only to that particular 95 square meters, then she can't have any objection for
The
this.
deed of declaration has been drafted by my learned friend there.
Your lordship.
That is, we.
The annexure D, your lordship, that is the initial plan.
No.
2 points, your lordship.
No, first answer the question. What was the deed of declaration in respect of, what was conveyed to an apartment owner in that particular existing building
The
area?
deed of declaration, actually, the builder has to draft it because the association formation
You're
is
not
the
answering the
builder's
question.
response.
In the sale deed of the apartment owners,
Yes.
what was the extent of undivided interest conveyed?
Undivided interest is calculated on 5 acres, 16 gundas. That is the entire land area.
Please show me the sale.
Sale deed, your lordship.
Any of the apartment owners saying that
Sale deed.
you
I
have
have
an undivided interest in the entire.
Yes, your lordship, I have submitted sale deed. Deed of sale in page number 70.
Page number?
70. of my writ petition.
Seven zero.
7-0. And this sale deed is executed in 2010. And your lordship, in page number 80, Schedule A, Schedule B and Schedule C is there. Schedule
For the
A,
entire
entire land,
page number 80.
Flat 35,224 square meters.
Square feet.
Translate.
Now, if your lordship.
Schedule B, if your lordship goes through,
Sees the next page at Schedule C, the subject
Note-
matter conveyed is limited. It is very crystal clear, my lords. The subject matter conveyed is limited to the share of the undivided interest aforesaid. Now, my lords, this undivided interest also, we have crystallized it into per square feet.
Where are you reading?
your,
Schedule C, below Schedule C, my lords, the second paragraph, the subject matter at the head should up to there. The subject matter conveyed is limited to the share of the undivided interest aforesaid. The undivided interest, my lords, will find at Schedule B property. 0.318% equivalent to 750.24 square feet. All of these, my lords.
in the Schedule
each
A
of these
property.
square feet, which has, it's been recorded in the deed of declaration, I have added
Read
it.
about the deed of declaration.
Yes,
What was conveyed to the apartment owners? Was it an undivided interest on the entire 5 acres and not?
yes, your
Or
lordship.
was it on this 21,000 square
It
meters?
is on that 19,000 square meters.
No, your lordship,
The
that is
total-
absolutely wrong.
Let him show, why are you,
Yes, your, sorry.
show me from the sale deed that it is only confined to that 19,000 square meters and not for the entire area.
No, that conveys, my lords, that is why I read out this particular limitation.
Now read from Schedule A.
Schedule A is just all the piece and parcel of property of converted survey numbers 392 and 393 situated at so and so.
Please read clause C. They shall be responsible and liable to indemnify the owners of the areas of undivided interest in Schedule A against loss claims so and so. So they were the owners of undivided interest in Schedule A also. Schedule A was the entire extent. The extent of
Schedule
the extent of undivided share is indicated in Schedule B as
Schedule
0.318.
Schedule C makes it.
0.318 is of this entire extent of 235,000.
No, my lords, that 750.24 square feet, what is computed, my lords. Otherwise, we have made crystal clear in Schedule C. It has to be read along with Schedule C. Schedule B could not be read in isolation, my lords. Schedule C would have to be read for, because actual conveyed area is the Schedule C.
What
The
does
subject
this-
matter conveyed is limited to the share of undivided interest aforesaid, and the flat is not the subject matter of conveyance by the vendors. That particular aspect your lordships may kindly take note of. My lord,
Read clause 9.
the original title deeds of the Schedule A property are with the vendors and the same will be delivered to the president as and when the same is formed. Your lordships are.
So if, yes, the same thing. So if the original titles of this are to be delivered to the association to be formed later. What is the meaning of that if you read Schedule A and Schedule B?
Therefore, I'm just requesting your lordships to also see Schedule C, which makes it very clear. What is conveyed, my lords, will kindly see the subject matter of conveyance as per the sale deed itself.
Yes.
For a moment, my lords will kindly see.
Schedule B talks about 0.318% in Schedule A property. Schedule A property is the whole extent.
Yes, my lords. Thereafter,
So,
kindly see that last.
Schedule C is of no consequence by virtue of Schedule B. Undivided interest is declared in Schedule B.
How though? Arjun could not clarify my.
You can't clarify it because Schedule B will have to prevail.
There cannot be an individual schedule that prevails over one another because all of these, my lords, in
Then
terms
why
of
did
an
you-
apartment.
Then why do you have a Schedule B then? Why do you declare an
Undivided share ನ ನಾವು ಕೊಡ್ಬೇಕು.
ಕೊಡ್ಬೇಕು ಯಾವ್ದ್ರಲ್ಲಿ ನೀವ್ ಹೇಳೋ ಪ್ರಕಾರ ಓನರ್ ಶೇರ್ ಬಿಟ್ಟು ಮಿಕ್ಕಿದಲ್ಲಿ ಮಾತ್ರ ಕೊಟ್ಟಿದ್ರೆ ನೀವ್ ಹೇಳದ್ ಸರಿ. ನೀವ್ ಇಡೀ ಆಸ್ತಿಗೆ ಅನ್ಡಿವೈಡೆಡ್ ಶೇರ್ ಕೊಟ್ಬಿಟ್ಟು ಈಗ ಇಲ್ಲ ಆಸ್ತಿಯಲ್ಲಿ ನಿಮ್ದಿಲ್ಲ ನಂದು ಉಳ್ಕೊಂಡಿದೀನಿ ಅಂತ.
It also includes the road area relinquished for the road, my lords. They cannot claim over that road also.
So if that is acquired, they also have a right over that particular acquisition compensation. That will be the legal position.
That was relinquished much before, my lords, they took possession of the property.
If they have given up the claim, they have given up the claim. But if they are the owners of the entire property, to the extent mentioned in the sale deed,
To the extent mentioned, my lords, that is why I am requesting your lordships to kindly see that last clause, my lords, makes it very, very crystal clear. The subject matter conveyed is limited to the share of the undivided interest aforesaid.
aforesaid is 0.318%
Yes, you.
of the.
We have crystallized that. We have crystallized that.
You read this once again for your satisfaction. The subject matter conveyed is limited to share of undivided interest aforesaid, and the flat is not the subject of conveyance by the owners. So you have already described above that they are entitled for 0.318% of the entire issued property.
Even then,
So-
even then, if my lords were to add on to all this 2,35,000 square feet, only, even if I have conveyed for a moment, I have conveyed 750.24 square feet for one of the association, and the total conveyance area also has to be seen. Because only after the total conveyed area can be seen.
I can only go by whatever is mentioned in the sale deed. I can't interpret it.
I think I need to interpret, my lords. I'm only trying to convince your lordships on the aspect that what is conveyed in the very next document, annexure J, Khata document, and our Akiranta Khata document, at page 83.
That is of no consequence. This conveyance deed you would indicate.
Alla,
that-
it will show the exact amount of area that is conveyed to them. Now, my lords, I cannot convey an area which is not at all present with me also. Once I have relinquished it to the BBMP, that road area I have relinquished to the BBMP, I could not have conveyed that area.
You don't seem to appreciate the fact. We will assume that the road was given away by you unilaterally to the BBMP.
Yes.
And they have acquiesced to that. But the remaining property does not become your absolute property. Your argument, if I accept, would nullify this particular schedule B.
It will not, my lords.
Yes,
because
your lord.
It will not, my lords. My humble submission is it will never, because of the fact that I have crystallized this particular, say this 0.318% of all the purchases, even if we add this 0.318%, 0.21%, 0.5%, whatever is conveyed to each of these people, it will not make up to 100% because of the fact that the total area conveyed continue to remain within 19,000 square meters.
That is not what is indicated in your conveyance deed.
Because
This is
made it
your,
very crystal clear in this sale deed, my lords, that subject matter that is limited.
you're limiting it to 2,35,244 or 224 square feet. You want to
Even
get,
then, my lords, even then, they will not acquire title because they do not have that entire area to themselves.
you're right. Nobody individually owns it. Collectively, every apartment owner will own a share in this particular entire extent. The owner retains no share independently because it is vacant. So if I accept your argument and take it to the logical conclusion, the setback areas that are left in an apartment complex, like a tennis court or whatever, will become the property of the owner.
It will never become the property of
Therefore,
the owner.
the apartment owners also have an undivided interest in that particular property. So that nobody individually owns anything.
Correct.
Collectively, they own that.
Collectively, they.
Nobody
own
can dispose it off by themselves.
it. We are not trying to dispose it off by ourselves or anything.
You are now utilizing it to the exclusion of them.
No, my lords, this does not belong to the owners association. One is the. The second aspect. my
Your
lords,
conveyance deed indicates that it does belong to them collectively.
my lords, my humble submission is because I have made it very clear in the conveyance deed itself that the subject matter is limited to the area of the undivided interest. Now they cannot seek in the form of a writ petition, my lords, to state their title claim. If they have already instituted a suit for bare injunction, they should have instituted a suit for declaration. They sought, my lords.
I'm not going to that. The BPMP could not have considered application when this property was collectively owned by all the apartment owners. That's it.
My lords may kindly see one aspect. Please appreciate it. The deed of declaration that has been entered into by the very owners, my lords, that is not for this entire extent of 2,35,000 square feet. The deed of declaration, my lord, is under the.
Will the deed of declaration prevail or the conveyance by you?
My lords, will
the owner.
see that the deed of apartment as per the Karnataka.
You're digressing. I'm ignoring the deed of declaration. Because what is conveyed by the builder, by the owner, is the sale deed. So I'm going by the sale deed. If the sale deed says every apartment owner collectively owns a particular percentage of the entire property, the owner cannot go and apply for an apartment to be built in the vacant portion as if it is his property. Now that is what you have done. Your argument is there, I was entitled to use XFIR. I have not used it. There's a vacant land now. Therefore, I will go use it. The moment you convey this particular property to the apartment owners, you are no longer the owner.
I request you, Lord, to kindly see section 11 of the Karnataka apartment.
And with the deed of declaration executed. 2019.
What is the exact nomenclature?
Clause 11 of Karnataka.
What is the nomenclature or title of that act? What is it?
Karnataka Apartment Ownership Act 1972.
Clause?
Clause, section 11, members, section 11, subsection 1, clause 11. What to kindly see clause 11.
Yes.
Clause will say, the declaration shall contain the following particulars, namely, the value of the property and of each apartment, and the percentage of undivided interest in the common areas and facilities appertaining to each apartment and its owner for all purposes. My lords may kindly now refer to the deed of declaration that they themselves have executed for a moment. May I just point it out from their very own deed of declaration?
Read the definition of common areas and facilities. The land on which the building is located. The foundations, cornerstones, the basement, cellar, the premises for lodging storage. So the moment they say the land on which the building is located, that's it.
My lords, kindly see for a moment. The deed of declaration also contains the value of each of these apartments that they themselves have produced, my lords.
That is a requirement of this act, but the fact remains that they are the owners of an undivided interest on the entire land on which the apartment building is located.
They cannot stake claim over the land which has never been
Then you
conveyed to
should,
them.
then your conveyance deed should have been to the effect that whatever you had, that owner's future development
Clause it's to the limited extent that the area.
conveyed aforesaid is annex A and B.
That addition itself would clearly demonstrate that, my lords.
What?
That this entire 990 square meters, rather actually 1,104 square meters is left.
Samit, you have declared as aforesaid, meaning in schedule B, you are giving them 0.38% of schedule A. Schedule A is the entire extent.
But schedule.
That is all that you have done. You should have been careful when you got the sale deed done.
Thereafter, in that very schedule C itself, my lords, below schedule C, which is the general definition, it is not a part of schedule C. Below schedule C, I have clarified that it is only limited to that area. My lords, if I had an intent, my lords, that I conveyed the entire extent, I would not have put that clause. I have made it clear in that clause that it should be subject to the
I can't
limitation.
interpret this sale deed now.
I am not trying to interpret at all.
When
my
was
lords.
this last plan approved?
In the year 2018, they filed this writ petition, my lords, in the year 2020. Kindly appreciate, my lords. 2018 is the impugned plan. 2020, they
What is the
filed.
date of the impugned plan?
Impugned plan, my lords, is dated
8/8/2018.
8/8/2018. The date of filing this particular writ petition, my lords, is 27th of February 2020. For 3 long years, my lords, they keep the matter in office objections. For 3 long years, my lords.
Your lordship, there was,
They
that's
obtained
the,
the interim order of stay, my lords, only on 15th of September 2023, because it was kept in office objections for 3 long years. They do not act upon it at all.
your lordship,
Now, my lords, the other aspect they were also stating is they have already filed before the trial court, my lords, a suit for bare injunction, declare, saying that they are the owners of the property. If that is the case, my lords, all these additions, they would have to be necessarily relegated to the trial court to actually determine whether, my lords, they have actually a right over this particular property. at all.
Until then, the plan can't be acted upon.
Now, my lords,
Until then, the plan can't be acted upon.
now what has happened is the
If
trial, court-
if there's a civil dispute,
there is a civil dispute.
this is the land in question for which plan is approved. How can the authorities sanction a plan?
The trial court, my lords, after considering their arguments, my lords, although they had sought for an injunction as against construction or development of the property, it does not grant it. Rather, my lords, it restricts itself to only non-alienation. Therefore, my lords, I will abide by the trial court order. I will not, my lords, even if I put up construction on the basis of this, I will not claim any equity tomorrow. If the trial court were to hold against me, lords, I will abide by the trial court's order. Let them agitate this claim before the trial court. They cannot make this honorable court, my lords, a forum for adjudicating their title because they do not want to pay that court.
They are using this forum to attack your plan.
Yes, yeah.
The ground that the plan is obtained instead of a land which I own.
Now, my lords, for that, they had to actually prove it before the trial court. At least they had to seek a declaration before the trial court.
What proof do you require in the light of your sale deed?
Because, my lords, my sale deed makes it very clear that it is limited to only to the area that is conveyed under this particular sale deed.
Schedule A, Schedule B, Schedule C.
Schedule B, Schedule C, all these three schedules would have to be read in conjunction, my lords. It has to be read.
That is a problem.
holistically.
If it's read in conjunction, you are in trouble.
And there are, my lords, my only submission is, if it was read only Schedule A, Schedule B, Schedule C in isolation of that clause which subsequently is there, which says that it is only limited to that extent, my lords,
The
I
only,
would have.
the only glimmer of hope that I see for you is, what is the meaning of that reserved for owner's purpose or something?
Your lordship.
Mean that it is the owner's property or continues to be the property of the entire project?
That, my lords, the trial court may have to take a call because
Yeah.
they have already filed a suit before the trial court.
One submission, your lordship.
What exactly is the meaning of that owner's?
My lord, my instructions, my lord, it is included in the, that rainwater harvest and the STP, my lord, that.
Wait, put it. Owners reserved ಅಂದ್ರೆ ಏನ್ ಅರ್ಥ? ಯಾವ
ಅದರ-
ರೆಗ್ಯುಲೇಷನ್ ಕೆಳಗಡೆ ನೀವು ಆತರ ಓನರ್ಸ್ ರಿಸರ್ವ್ಡ್ ಅಂತ
ಇಲ್ಲ
ಮಾಡ್ತೀರಾ?
ನಮ್ಮದರಲ್ಲಿ
JDA.
ನಮ್ಗೆ ಇದು ಕೊಟ್ಟದಲ್ಲಿ ಅದು ಏನ್ ಹೇಳಿದೆ, ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಏರಿಯಾ ಇಸ್ ಇನ್ಕ್ಲೂಡೆಡ್ ಫಾರ್ ದಿ FAR and site.
ಅದೆಲ್ಲ ಬಿಡಿ
Hence the word remaining area of the owner is a mismanner manner. ಅಂತ.
ಅದೆಲ್ಲ ಬಿಡಿ ಅವರು ನಿಮ್ ಅವರ ಪ್ಲಾನ್ ಅಲ್ಲಿ ಅದೇನೋ ವಾಟ್ ಇಸ್ ದ ಎಕ್ಸಾಕ್ಟ್ ಟರ್ಮ್ ಯೂಸ್ಡ್? ಓನರ್ಸ್?
Area reserved.
Owners.
No, no, honors reserved, honors area reserved for. But actually in the plan, it is not shown also.
My lord, my instruction, my lord, it is included in the entire.
ಅದೆಲ್ಲ ನಂಗೆ ಅರ್ಥ ಆಗೈತೆ. ಓನರ್ಸ್ ಏರಿಯಾ ಅಂತ ಯಾಕೆ ಬರ್ದ್ರ ಹಂಗಾರೆ? Why did they do that? If they say it's the owner's area.
Yes.
That means it does not belong to the apartment association. What is the meaning of that?
My instructions are only this, they said, my lord, it is the.
Now let them file an affidavit as to what exactly is the meaning of the owner's reserved
Owners.
area. Because you given the hope that it is the owner's area, notwithstanding you granted approval for the entire project.
Yes.
That is the cases, that is why they're before this court.
After my approval, my lord, it was modified by the.
They granted approval because of your reservation of that particular area for
Yes.
owner's use.
Yes.
What is the need? What was the need for you to say that? And you include that for the purpose of computing the FAR.
It was included.
But your lordship, one submission, your lordship, if your lordships goes to annexure D, the original plan, 2007 plan, it is not mentioned that it is honors reserved areas. Here exactly it is mentioned.
2010.
2007, the first plan I'm talking about, the first plan where my project is constructed.
Clearly mentioned.
No, your lordship, my
Let me open
submission, your lordship, it is mentioned, it is clearly
Where is the plan? Annexure.
annexure D.
Annexure?
Statement is there, I do agree, but in the plan, if your lordships go through, the plan is drawn with rainwater harvesting.
Is it stated it's owner's reserved area?
That is a statement down, it is mentioned, but in the plan, you're not, let me submit your lordship. No, your lordship goes through the plan.
Reserved for ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
That's it down, they have given us small sentence in this.
And I.
What is the meaning of this? Reserved for remaining area of owner. Reserved for.
But in the actual plan, it is actually it is drawn saying that it is STP. It is STP, and in the statement, they have just given a note saying that area reserved for. And your lordship, if your lordship read this through the amended plan which they had submitted,
Your apartment is not being touched.
constructed.
Yes, there is a block of land which became available because of the road.
No,
Had the road not been formed, it would have been a part of the project. Because of the road being formed, there's a new plot of parcel of land which became available. You
No, your
cannot,
lordship.
as an apartment owners, you cannot cross the road and have a.
No, that is not the reality, your lordship. They had given the relinquishment deed. They had executed the relinquishment deed in 2007 itself. And even in the plan also, that particular road is there. Because of
What will the apartment owners do with that land?
which land, your lordship?
No,
My
land-
borewell is there in that area now.
So if the borewell is shifted, then
No,
your
your
claimants
lordship,
then.
that- No, see, from the JDA, sale agreement, sale deed, all the
What
documents.
is the use that the apartment owners can do with that particular plot of
This
property?
is my undivided right, your lordship, my,
That I understood. I told you that argument. What is that you will use?
that area, the
consider-
association can decide it for, because otherwise, your lordship.
Want to make a commercial activity?
No, your lordship,
Then-
it is a residential property
Then what
and
is it?
my portion
Then
three.
what is it that you will gain?
Lordship,
You cannot have access to that property because you have to cross
I
the
can
road.
access, I can access, it is just in
So you
front
have
of
to
me.
cross the road. So you have an apartment here, a common area facility across the road.
No, your lordship, what happens, it's a very 15-meter wide road. And just before me, and I am using my
You will allow your-
borewell is also there.
You will allow your children to walk across the road and
I can shift the STP to there, your lordship. Now the STP, they have put it in,
that's why I'm not very.
but it is my land, your lordship. That is the most important thing. They have,
Let me see how they can compensate you for that undivided interest.
no, your lordship, that is not the reality. It is in front of me. I was using that land. It was in possession of me. I am the one who is paying the borewell, and I have also submitted the documents showing that I was in possession of that land.
That 10,000 square meters of land, whatever that is available, 998.
10,000 square feet.
ಅದು ಎಷ್ಟಾಗತ್ತೆ value?
Your lordship, one submission, your lordship.
The 10,000 square feet.
10,000 square feet.
So-
It's located in Talkere.
No, your lordship, it's a prime area.
That value of that particular 10,000 square feet, are you prepared to give it to the association?
They have already taken.
I-
Are you prepared?
Your lordship, more than 10,000, it is closer to
Put it,
Indira
let me know
Nagar.
by tomorrow. By that time, you will tell me what is the meaning of owner's area reserve.
My lord, in the map itself, my lord, that entire area is, my lord, marked as including the rain harvest and STP, entire.
To use the word owner's area reserve. Does it mean that it is the owner's independent area and not the project area?
Yes.
Then they may have a case, or else they're in a difficulty.
Your lordship,
Consider this seriously.
your lordship, one submission.
The percentage of ownership of every apartment owners, that is all that they have in respect of this particular land also. And that value,
I will seek instruction.
so then their right will come to an end.
I will seek.
My lord, one submission.
May I request my lords to have it on Monday? Monday, 2:30 tomorrow.
You want 4:30?
Interim order may be extended, your lordship.
Monday.
Monday, 4:30.
ಅಲ್ಲ ಮಂಡೇಗೆ ನಾನು
Wednesday.
ವೆಡ್ನೆಸ್ಡೇ
Wednesday.
Kindly extend the interim order, your lordship.
Lord, submission.
I'll have it on Tuesday.
Tuesday may be a bit.
Tuesday.
Wednesday, my lord. Wednesday, my lord.
Wednesday, I have 2 matters at 4:30. I'll have this Tuesday at 4:30, come at 4:30. Which year? ಮಧ್ಯಾಹ್ನ ಕಲಬುರಗಿ ಮಾಡಿ. Forty? Date ಕೊಡ್ತಾರೆ. ಅವ್ರು ಕೇಳಿ ಡೇಟ್ ಕೊಡ್ತಾರ.
My lord, serial number 50, my lords.
38 previous.
My lord, serial number 37.4, my lord.
Yes.
The respondent number 6 has expired, my lord. 37.4.
ನೋಡ್ರಿ ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ.
Much.
My lord, serial number 50, my lords.
ನೋಡಿ.
Serial number 65, my lord.
My lord, serial number 50, my lords.
Serial number 65, my lord, serial number 65, my lord, Tuesday, my lord. Inform others, sir.
My lord, serial number 50.
Who wants time? Ask him.
Court officer.
ಯಾವಾಗ ಸರ್?
Court officer.
ಎಲ್ಲ ಕೊಡಲ್ಲ.
49, 22.
ಸರ್
22.
Court officer, serial number 50.
ಹಾ? Court officer,
Next Friday.
court officer,
Court officer, serial number 50, note down, Madi.
court officer. Court officer. 60.
Wednesday, Thursday ಅಷ್ಟೇ. B group.
Court officer, serial number 50.
Court officer. 65 court officer. 65 ಆಚಾರ್ಯ. 65.
23.
23.
Excuse me, court officer, serial number 50.
24, 24 ಎಲ್ಲ 6th February. ನೀವ್ಯಾರಿಗೆ? ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ, ಅದರ್ ಸೈಡ್.
Court officer. Excuse me, court officer, serial number 50.
ಇದೆಯಾ ಬೇರೆ ಕೋರ್ಟ್ ಇರ್ಬೇಕು ನೋಡಿ.
ಇಲ್ಲಿ ಬರೋದೇ
ಹಾ,
ಸೈನಿಕ ಕೊಟ್ಟಿದ್ರಾ?
55.
Serial number 50, court officer.
50.
50 for the petitioner seeking for an adjournment.
23rd.
23rd, okay.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 73 ಅಲ್ಲಿ
ಹೇಳಿ
ಪಿಟಿಷನ್ ಟೈಮ್ ಬೇಕಂತೆ ನನಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು, ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ಇಲ್ವಾ ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ಟೈಮ್ ಬೇಕು ಮೇಡಮ್, ನನ್ನ ಸೇಲೋ ಇದಾಗ್ಬಿಟ್ಟಿದೀನಿ, ನಂಗೆ ಒಂಚೂರು ಕೇಳ್ತೀರಾ ಅಂತ.
ಯಾರು ಕೇಳಿಲ್ಲ ಮೇಡಮ್.
ಕೇಳಲಿಲ್ಲ. 73
ಅದೇ ಕೇಳಿಲ್ಲ ಯಾರು.
ಕೇಳಲಿಲ್ವಾ? ಹಂಗೊಂದು ಮೋಸ್ಟ್ಲಿ ಇವಾಗ ಬಂದ್ ಕೇಳ್ಬೋದು. ನಾನು ಹೇಳ್ದೆ ನೀವು ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಹೇಳಿದ್ರೆ ಟೈಮ್ ಕೊಡ್ತಾರೆ. ಹಂಗೇನಾದ್ರು ಬಂದ್ ಕೇಳಿದ್ರೆ ಕೊಡಿ ಸರ್, ನಂದು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ.
ಆಯ್ತು ಆಯ್ತು.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ನಾನು ಕೊಡ್ತೀನಿ ರೀ.
ಇದೆ.
ಕೊಡಿ ಮೆಮೊ ಬುಕ್. ಯಾವುದು? 36 ಫರ್ದರ್ ಕನ್ಸಿಡರೇಷನ್ ಹೇಳ್ಬಿಡಿ. ಇಲ್ಲ ತಗೊಂಡಿಲ್ಲ. 39 ಇಲ್ಲ ಇದೆ ಇದೆ ಕೊಟ್ಟೆ 40 ಇದೆ. ಅದು ಮೆಮೊ. ಹೌದು.
ತೊಳಿ.
ಹೌದು ಇದೆ. ಇಲ್ಲಿ ಬಂದ ಅದು adjournment ಎಲ್ಲ
ನಲವತ್ತೈದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಡ್ಲಿಲ್ಲ ಅದು ಸಾಹೇಬ್ರು. ಇದೆ 2 ಸತಿ ಕೇಳಿದ್ರು ಕೊಡ್ಲಿಲ್ಲ.
Court officer? Court officer?
Court officer?
Court officer. Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ಸರ್ ಫಸ್ಟ್ ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಕರಿತಾ ಇದ್ದೀರಾ ಸರ್?
ಹೌದೌದು.
ಓಕೆ ಸರ್, ಓಕೆ.
Madam.
What is the order that you have challenged here? Next, Rich. Next, Rich, Allah. Sale warrant. What is the order that you're challenging for a court sale and order? When was the sale? When was the sale conducted? What is the amount that you're paying now? ಇದನ್ನ ಕೊಟ್ಟಿದ್ದಾರಾ? ಚೆಕ್ ಮಾಡ್ಬೇಕಲ್ಲ, ನೀವು ನೋಡಿದ್ದೀರಾ? This petition is filed challenging the issuance of a sale certificate. As for property to was sold to a court of law. Not consider the parties. In the presence of their respective parties, submit that the matter has been settled between the parties and the petitioners are handing over possession of the property purchased by the contesting respondent, subject to the legal suit item number 1 on receipt of rupees 10 lakhs by way of a demand draft. The keys of the property are also handed over to the purchaser, and the purchaser in turn hands over a demand draft rupees 10 lakhs to the petitioners. In view of the above, the prayer in the writ petition would not survive consideration. ಆಗಿದೆ ಅಂದ್ರೆ since it is not in dispute that the sale certificate issued by the court has been registered, it is obvious that the registry would also have to hand over the original documents pertaining to item number 1, which has been purchased by Niveshna respondent, purchased by the proposed respondent. The executing court, the trial court is directed to disperse the sale consideration in terms of the decree. Reading number accommodate.
Received, is it not? Forward bench matter. Serial number 1, Shri S.L. Matti.
Today is going to approve the project, my lord. And after that, my lord, they want 6 months time to complete the project. Formation of the layout.
ಇಲ್ಲ ಲೋನ್ ಅಪ್ರೂವ್ ಆಯ್ತು ಏನಾಯ್ತು?
ಅಲ್ಲ ಇವತ್ತು ಕೊಡ್ತಾ ಇದ್ವಿ ಅಪ್ರೂವಲ್, ಸ್ವಲ್ಪ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಪ್ರೂವಲ್ ಆಗ್ಲಿಲ್ಲ, ಮತ್ತೆ ಬೇರೆ ಪ್ರಾಜೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಅಪ್ರೂವಲ್ ಕೊಡ್ತಾ ಇದ್ವಿ.
ಈಗ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ತೀನಿ ರಿಪೋರ್ಟ್ ಕರೆಕ್ಟ್ಲಿ.
ಪ್ಲೀಸ್ ಟುಡೇ ಇಸ್ ಗೋಯಿಂಗ್ ಟು ಅಪ್ರೂವ್ ದಿ.
ಇದು ಈ ಕೇಸ್ ನಾನು ತುಂಬಾ ಬೇಜಾರಾಗಿದೆ. ಇವತ್ತು ನಾಳೆ
ಅದೇ ಇಲ್ಲ ಮಾಡ್ತಾ ಇದ್ ತರ್ತಾ ಇದ್ದಾರೆ ಇವಾಗ. ಪಾಸ್ ಔಟ್ ಮಾಡಿದ್ರೆ
ಪಾಸ್ ಔಟ್ ಮಾಡ್ಲಾ?
ಪಾಸ್ ಔಟ್ ತರ್ತೀನಿ.
Serial number 2, Shri Ravi Hegde.
Appearing for petitioner.
I appear for the respondent, lords.
Writ appeal was dismissed, my lord, in the month of November 2024.
Lords, the dismissal of the writ appeal was not, my lord, sir. Again, the order passed by my lords, a writ appeal was filed. Lords, the writ appeal is, I'm told, my lords, by my friend that it has, writ appeal is dismissed.
My lord, after dismissal of writ appeal, we have submitted a representation to comply the lordship order. Despite that, my lord, they have not complied with the same.
I'll get instructions, my lords, I'll see if it is complied. I am, my lord, sir.
My lord, 2 months is already lapsed.
No, I was not aware of the, my lord.
They have not even prepared SLP. As on today, it attains penalty.
ನೀವು ಗಲಾಟೆ ಮಾಡಿರೋ ಇವಾಗ they file an SLP now. ಸುಮ್ಮನೆ ಎತ್ಬಿಡೋದು ವ್ಯಾಸಲ್.
Did not have the instructions of my lord to dispose of the writ appeal. It is my friend, my lord, who informed me that
Yes.
the writ appeal is disposed of.
By 2 weeks, do whatever you want by then.
Please, grateful, my lord. Great.
Date may be given.
31st.
Please, much of.
For admission, serial number 3, Shri Vatakurki.
My lord, appearing for respondent in this case, my lord. Lord, pray for a 3-week completion, my lord, to file objections, my lord, to the petition. I am a complainant, my lord.
Serial number 4.
And I appear for
24. Serial number 5, Shri Gulla Reddy.
Please, my lord. It's a KP Act, my lord, offense under section KP Act, my lord. Hello?
Who appears for the state?
My lord. My lord, in respect of this, my lord, already lordship has quashed the entire proceeding in respect of accused number, my lord, 40 and 41, my lord. Kindly we see the page number 232.
Notice ಇದ್ರೆ ಮಾಡಕ್ಕಾಗಲ್ವಲ್ಲ, ಟೇಕ್ ಔಟ್ ನೋಟಿಸ್ ಆನ್ ದೆಮ್.
Please,
Respondents.
31st.
Please, man, please.
Kalburgi bench matters. For further consideration, serial number 1, Shri R.J. Busare.
Lord, appearing for petitioner.
Where is Mallarao? Madam.
Lord, I have filed a memo along with calculation, my lord. The government is also filed a memo along with calculation. How much, my lord, the salary is due.
ಎಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದಿರಾ?
Now, Gulbargadal file madi, it has been transferred to Bangalore, my lord. I have made inquiry.
Lordship, it has been received and after verification from both the receipt by next date of hearing, WH will argue, Mr. Mallarao.
My lord, 2 days back, my lord, I made inquiry in the pending branch, my lord. They stated that.
No, not disputing. It is received by the AG office. Once again.
Bangalore creation.
ನಮ್ಮ record ಅಲ್ಲಿ ಬಂದಿಲ್ಲ. I'll direct them to put it up. It is stated that memo of calculations is filed by the petitioner. However, the same has not been put up. Registered director put up the same and released on
24th.
Please.
Serial number 2. Shri Bantanu. Serial number 2.
Madam.
Sir, I have filed my affidavit and along with one IA for allowing the executive chief engineer to file the affidavit. Since on that day, the secretary was out of station. He was
ಯಾವತ್ತು ಹಾಕಿದ್ದೀರಾ?
December only, the IA and the affidavit together I have filed.
Date.
ಮತ್ತು ಹಾಕಿದೆ.
ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ?
ಅದ್ ಸ್ವಲ್ಪ ಕನ್ಫರ್ಮ್. I will just, it has been served and also intimated in the registry to send the copy to the Bangalore bench.
Please verify, relist.
Please, sir. Yes, Lord.
24th. Seal number 3. Shri Ravi B. Patil.
Ravi B. Patil.
Seal number 4. Shri S.G. Mad.
Lordship, in these matters, I have filed the affidavit with regard to the tenure of all the petitioners.
Copy
And
ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
ಅವ್ರಿಗೆ ಕಾಪೀಸ್ ನೀವು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಈ ಕಡೆ. And in 4.9, I have filed the objections also. It may be treated as a common objection for all the matters, since all of them have appointed through outsourcing agencies. Only I need to serve.
Ask him if he's ready to argue.
Yes, sir. My lord, one more case may be clubbed in this case, madam. One more case, madam.
ಏನ್ ಮೇಡಮ್ ಇನ್ನೊಂದು ಕೇಸ್?
Along with this list, the same set of facts that he want to connect with the present
ಎಷ್ಟು ನಂಬರ್
petition.
ಎಷ್ಟದ?
202274 of
23. Fresh file.
Ready, madam, number?
WP number?
202 274. 202274 bar 23.
2.
Yes, sir. 20
22
74.
23.
202274
of 23.
Yes, Lordship.
Post WP 202274 by 23 along with these petitions.
Seal number 5. Shri Jaga Shetty.
What is annexure R? Page number?
The whole thing lies on the last page. 152 ನಲ್ಲಿ ಅವರು ಹೇಳ್ತಾರೆ. Page 152 one sentence. Page 152 last page. ಅದರಲ್ಲಿ what they say is, ಅದೇ ಇಂಥ WP number 14612 19 332 ಹಲವಾಗಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
And ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ಏನಂದ್ರೆ ಯೂನಿವರ್ಸಿಟಿ ಇನ್ಕಮ್ just for sanction is 8% ನಾವು ಹೇಳ್ತಿದ್ದಾರೆ 90 CA was page 4 of this graph. What did you say, this writ appeal? What has happened in the writ appeal? Where is the order in WP 51432? 51342. Page number? The judgments are complete. Item number 2. All the aspects have been considered, including the number of years of service, regulation, position of them. Direction of not so long as 2 decades from the year of June. Petitioner said, last question you are getting. There are 60 hours. 60 hours. Very good. Against this, there's an appeal pending is what you're saying. The other side also filed for chat saying one post of associate professor who page 1 of the chat is synopsis with the actual issue. Page 4, item 10. Item 10 working for duplicate is a sanction waiting the regular court to do or pro date. They are entered for regulation. So item 11 is very important. The report is already submitted and already this permission where there is one post of associate professor and 2 posts of associate professor as against the department. Sanction working and vacant teaching posts as of 1/7/2024, which has been filed by the University on 16/10, and it was also confirmed 24/10 in the application of the appeal. Therefore, there are 2 things. Therefore, kindly come for us to kindly take your last judgment about item 1 of the judgment preparation. Item for your last is all about the recent judgment. The rest will not dated 20 September 2024. That will be the last one. Item 1. Either judgment by Ola, either on his case. And the page 42. Page 42. But the questions are gone in the entire aspect of the matter regarding one sanction and all that. Page 77 onwards. Page 41. Very I think it's not the whole issue. Page 41. Para 77. 78 Adjournment to the state in the issue of the regulation of petitioners and basically to put the reason that since there are no sanction board, regulation would not to intervention of the judgment of constitution. So constitution is the initial appointment irregular, safe to the regularized upon completion of career. So constitution is very clear. The chief Lastly, let's say, petitioners get it applied. Also, it is open advertisement, and only thereafter they are here also saying they applied and got it. It's not nothing for came back or back door. Therefore, when they say that, nothing.
Yes, Sudarshan. In which case are you referring to? Which case are you referring to? Idil objections ಹಾಕಿದರಾ?
Page 114. Start from page and 114 is a reproduction of some communication. Yes, 115. Petitioner in all the petitions are raised in the question for consideration and raised in the common of the madam to respond to the document and regularize the responses. Or to extend the benefit of capacity, Mysore, as well as to the petition. Therefore, the petitions are under and together with the previous. Petitioners contend that they have been serving their yes, lecturers, the respondent university are associated for letters after the respondent university for more than 10 years. And some of them have to be Mysore than 24 years without any except artificial text of their view. That further ordering were ensured. Two, the respondent university shall be to regularize and organic other over apartment and the section 1973 our section we are putting 10 years three, the respondent shall in motion the process of regularization and complete the same within a period of 6 months from today. 4, the respondent to the condition and regularization are not considered the qualifications such as NED and SLED that required under existing rules. They shall acquire the qualification within a reasonable time from the date of their regularization as was provided in statutes 2000. 5. The petitioner shall not be relieved or discontinued from certificates if they are considered activities that are to be formulated as 6. The respondent university shall follow the rules of reservation by regularizing the services that are responsible. In the
of the disposal of the main matter or pending. That in the instant case, right, so it is clearly reflected that like court of Karnataka has not been allowed to relying on the statutes of the Mysore University. That further under the ILO was pleased to pass the order that are based upon statutes of Mysore University and statutes of Mysore University has received the assent of His Excellency Governor of Karnataka and Chancellor of University in 2004. Also, Lord, coming to Lord, next page, that is Lord, section 40 of the KSU Act 2000. Lord, the subject to the third of the section, Lord, kindly come to next page. The institution, suspension, and abolition of posts of professors, leaders, lecturers, and creation of the method of recruitment of teachers in the university and provided that scales of pay of the employees excluding those who are trying university grants commission. Pay shall be commensurate with the scales of pay applicable to state government. This is now the subject to the providence of this statute being provided for all extra possible. Lord, coming to Lord 2, bold the letters. The statute shall come into force only from the date of the assent of the chancellor or on such other date as the chancellor. So far as Lord Mysore is concerned, there was some Lord assent of the statute that we were and Lord here in our case, Lord, there is no such Lord statute.
Who did you recruit them?
Lord, it is only guest lecturers.
Which is a statute which permits you to appoint guest lecturers?
Lord, that Lord regard on the basis of UGC Lord.
So if the statutes don't provide for you to recruit, how did you recruit them and continue for 20 years?
20 years, they continue only for 5, 6, 7 years sometimes. But that will not after giving breaks only for 4 months.
When was the first petitioner appointed?
First petitioner appointment. Even as they go. Page number 40, the service certificate. Yeah.
You tell me the date of appointment and which portion of the objections. You see only 5, 6 years. So it is not in dispute that they've been working for 20 years with breaks.
20.
You tell me then. For how long? For how long are they working? When is their first appointment? For how long have they worked? They have service certificate in them? Other. Page 43. 2003, 2004. You have for every year itara kottidara? Where have you denied that they have been working only for 5, 6 years? Which portion of your objections have you stated that they work only for 4, 5 years? Where? Page number 18, page number. Page 23, na?
23. So they can base this and moreover as maintained in traditional share for only 8 to 16 hours.
Where have you denied that they worked only for 6 years and not for 20 years? Why is the university acting like this, at least on facts? For how many years? For how many years have they been working as guest lecturers? ಯಾವತ್ತಿಂದ ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ? You are not being straight. ಎಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ರೆ ಹೇಳಿ? Where have you said that? I will consider that. Tell me whether they work for every year for the past 20 years or there have been 5-6 years gap in between. You have not made any submission there. You are making submissions contrary to your pleading.
It is also denied to state it is there is sufficient workload in the Department of Studies and further it is also denied state that traditional amendment to our working as full-time legislation from 2003 as state traditions are completed 14 years and further it is also denied to state that traditionally is also working as.
So if you have denied this, for how many years have they worked? Sudarshan will impose cost on the university if this is the argument. Can't you at least be straightforward to the court?
After denial of this, Lord, I is just coming to Lord the point which Lord is.
Show me that enough. Show me that point. Please, please.
Your 11 is 16.
16. Yes.
Responded 2 to 5 other services that we have to, they are also, they have to also follow government or related so 360-90. Then parameters for the selection of teaching staff to university has to be mentioned and for recruitment of teaching staff in the university of the college. It is a selection board constituted under the procedure benefits this subsection 7 of this section shall obtain the acceptance of conduct examination of the he shall develop the software to provide application hardware by the respondent.
All of this is lecture. Where have you said from when they work, for how long they work? All along, all these days, you were arguing that that was not in dispute. Now you are raising this contention that.
That is for the denial paragraph.
So if there's a denial, I have to accept the denial blindly.
Subject to documents.
So what is the document that you have produced to indicate that they worked intermittently for, let us say, 1 month, 2 months, not for the complete year? On what basis do you say that? You are the person who appointed them under appointment orders. You are the one who paid them per hour. So you should be able to tell as to how many hours they worked, for how many months in a year, an academic year they worked. If you have not said that, I'll take it as an admission.
For respondent, submits that amendment of establishment is made with hope of the additional teaching work of the academic year. The guest lecturers are appointed to take class on particular subject and continuation which depends on the year of the department for the particular academic year. The petitioner has not been taxed as to discontinuation.
That means you admit that they're working continuously as continued with them. ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ ಸುದರ್ಶನ್?
According to the 18 months. Finally, I would land regard to Lord and swear there are certain parameters for this university even other side for their submission. There is a one bracket post even then also the university has to look into the aspects of other aspects like category and reservation and other aspects. And can't be simply
So, but for a guest lecturer, you don't require anything. You can do whatever you want.
Guest lecturer is not appointment as per the UGC norms are as per the government notification 2019, which I am just referring to annexure R1. And that is and moreover, this vice chancellor has only 1 year can engage in any employee. Not more than that. Even if you go by the statute that is the provisions of the Act, can you come to section 56?
Yes. So,
55 just on my watch. Section 53 says about appointment of teachers and lecturers.
Section 53,
appointment of teachers and lecturers. And I just directly to kindly say appointment in accordance with the promotion. This is not not actually. Kindly come to section 55.
yes.
Appointment to part-time posts. Subsection 1, there shall be a board of appointment for selecting purpose of appointment as part-time. The board shall consist of, these are the bodies that should be taken to appointed, and then declaration to be completed. And this is not kindly come to subsection 2. Every part-time post shall be widely advertised with all necessary particulars and shall be filled by selection of interviewing the candidates. Subsection 3, quorum for meeting of the board shall be 3. And 4, the board shall prepare a list of persons selected and forward the syndicate which shall make the appointment. 5, no part-time appointment shall be made for any period exceeding 1 year. This is to be indicated on both sides. This is one part. And 56 and finally come to the section. Temporary appointment. Subsection was notwithstanding anything in sections 53, 54, 55, and 57. The vice chancellor may make temporary appointments of not more than 1 year duration to course of etc. And such modification shall, as may be specified in this year statutes, where such courts are either temporary or appointments to such courts cannot be made in accordance with section 53. Subsection 2, the appointments under subsection 1 shall be made only against sanctioned courts. That is Lord appointing teacher courts and in the manner prescribed by the statutes. 57 word is against.
So you tell me, how did you appoint them, under which statute you appointed them?
Lord, the burden and
So you can ignore the Universities Act if it suits you.
That sound Lord is Lord any of Lord the vice chancellor is Lord granted empowered to Lord engage Lord teaching service Lord his capacity to investigation. In such situations, Lord below 1 year, they will not even Lord consider their appointment but up to 1 year. Lord taking into consideration of all these parameters. They engage Lord 4 months, 6 months, like that Lord they engage and Lord again they review.
You have not, I'm repeating, in your objections, you have never stated anything like this.
Lord, it is there, but not in a regular routine. But academic year, this is how Lord even my Lord lecture.
Already, you file an affidavit.
Kindly. Lord, my compilation law dated 29/11/2024.
Yes.
For this compilation, I draw my attention to, may I request you more page note 145 and 126.
Yes.
126, para 45, Lord, while directing that appointments temporary or casual be regularized or made permanent, the courts are swayed by the fact that person concerned has worked for some time and in some cases are considered length of time. It is not as if the person who accepts an engagement either temporary or casual in nature is not aware of the nature of his employment. He accepts the employment with open hands. It may be true that he is not in position to bargain, not at arm's length, since he might have been searching for some employment so as to become his livelihood and accept whatever he gets. But on that ground alone, it would not be appropriate to jettison the constitutional scheme of appointment and to take view that a person who has temporarily or casually not employed should be directed to be continued permanent. By doing so, it will create another mode of public appointment which is not permissible. The court to avoid unfactual experiments of this nature on the ground that parties were not having equal bargaining power, that would not enable the court to grant any relief to that employer. A total amount of such casual and temporary employment is not possible. Given the exigencies of administration and its import, would only mean that some people who at least their employment temporarily contractually are casual would not be getting even that employment and securing of such employment beings. That is some succor to them. After all, innumerable citizens of vast country are in such an employment, and one is not compelled to accept a casual or temporary employment if one is not inclined to go for such an employment. It is in the context that one has to proceed on the basis that the employment was accepted fully knowing the nature of it and the consequences going from it. In other words, even while accepting the employment, the person concerned knows the nature of his employment. It is not an appointment to post in the real sense of that acquired by him to the post in which he is temporarily employed or in the interest that post cannot be considered to be of such a magnitude as to enable the giving of the procedure for making regular appointments to available for in the services of this state. Argument that since Apna has been working for some time before, it will not be just discontinued. Even though you are aware of the nature of the development, you first pick it up is not one that would enable that testimony of the procedure established by law of how to pay when tested on the stone of constitutional and equally and to para 47, when a person enters a temporary employment or gets engagement as a contractual or casual worker, the engagement is not based on proper selection and recognized by the relevant rules or procedure. He is aware of the consequences of appointment being temporary, casual or contractual in nature. Such person cannot.
Right, you rely upon Umadevi's case.
Umadevi.
Then next.
Just coming to 52.
But I Umadevi's case and I don't have to read this.
After that, kindly come to page 134.
Yes.
The data entry and another versus Dharamveer. Service law, promotion vacancy, difference of adopt promotion data against the newly created post continue for about a decade. Process for making regular promotion initiated and coming into the course of recruitment rules. And the post will upon adopt basis rightly treated as attendant.
Which paragraph?
First is that you are the old that line that no line. Well, that post filler on adopt basis rightly treated as vacant for the purpose of promotion, service recruitment rules, so and service. B. Service law. Appointment nature of appointment does not change with one passage of time. Adopt appointment which continuing for about a decade and continue to be the adopt even after the last passage of time. Not I just draw my last the last statement that is your 155.
Yes.
Getting the page number 3, page 157. A perusal of record indicates that traditional staff is working their guest faculty and they are still in service. Guest teachers are contractual employees and they are being appointed for an academic session. In terms of the series of judgments passed by the Honorable Supreme Court as well as by this court, the guest faculty cannot be replaced by another set of guest faculty. The practitioners are being permitted to continue on the course of their faculty. But as far as claiming benefits equivalent to that of the regular employees concerned, there cannot be any similarity between guest teacher and that of regularly appointed teacher. Counsel for practitioner has failed to demonstrate opposite aspects of the matter. Therefore, equivalent to that of regular employees not permissible. Both the categories of employees, that is just that the guest teacher and regular teacher cannot be equalized. Regularization cannot be claimed as a matter of fact. Practitioners are only working as guest faculties on contract basis for an academic session to continuation of their service, looking to their performance. Therefore, as far as rights of contractual employees are concerned, they do not have any right asking for regularization of their service. Law with respect to contractual employees settled by the Honorable Supreme Court in the case of Statement of India versus itself, so and so, where it is held as under where the relationship of master and servant is purely contractual. It is well settled that contract of personal service is not specifically enforced. And regard to the law contained in section 40 of the specific fact, even if the termination of the contract of employment by dismissal or otherwise is found to be illegal or in breach, the remedy of the employee is only to seek damages, not specific performance. Courts will either declare such termination in a negative or declare that contract of employment subsists or grant the consequential relief of the state. Three will recognize exception to this rule law, where a civil servant is removed from service in contravention of the product of the 3 years of the Constitution. 2, where workmen having the protection of industrial inputs Act is wrongly terminated from service. Three, where an employee of a statutory body is terminated from service, which violation of the current mandate and any mandated provision of the statute or statutory. There is thus a clear distinction between public employment law rights, statutory rules and private employment law and with contracts. The test for deciding the nature of these transactions and consequences will be whether employment is done previously by contract or by statute or statutory. Even when employed in statutory body, where the relationship is purely governed by contract, there is no element of statutory governance. The contract of personal service will not be statutory. Number three, where the employer is not statutory body, but the employment is governed by statute and statutory rules. The declaration that the termination and what that the employee should be restricted and be granted by whom. So you can coming to the only distinguishing feature of this faculty and corporate employee is that they be teaching teachers in the department and being appointed after placing appointment procedure cannot be replaced by another discipline. Other conditional contract employees are saying probably for this reason for valid faculty who has taught in the organization cannot be replaced by another. In absence of any rules, regulations or circular for regulation of best practices, no matter issue for other regularization of the faculty. We are continuous working for some time on contract does not entitle under this and both we can be independent. However, conditions are always included to pursue their pending. Not this
I would want you to file an affidavit of the registrar regarding the amount of years that they worked.
that also
No, I'll reserve the judgment, you file the affidavit.
service rendered at the earliest point of time.
ಬಿಡಿ affidavit ಹಾಕ್ಲಿ ಬಿಡಿ ಅವರು affidavit ಹಾಕ್ಲಿ ಬಿಡಿ ಅವರು page page
Earliest point of time, page 106 judgment they had appeared. Next real. Page 106. 687.
page 107.
Page 106 to 7. Page 108 and you are narrated. 2003, 2003, or 2005, or they will.
Now, where is the finding?
I think page 111. Page 111. Master gets that having heard the counsel from the petitioners and the respondents, it is clear that the petitioners are appointed against a clear evidence in the fact that they conclude from date of appointment to mitigate that there is sufficient workload in the university. But the finding is ultimately in the direction of the they go to the university, ask for opinion from the university opinion given at page 117. But the university advisor opines page 116 ಅಲ್ಲಿ opinion regarding judgment dated showing the past part of the court claim. Next page ನಲ್ಲಿ everything is narrated here. It is further verified judgment influence and not been challenged hence it is finally therefore the opinion that case the petition above case shall be considered as a regulation service.
ಹಾಕ್ಲಿ ಬಿಡಿ ಒಂದ್ಸಲ affidavit ಹಾಕ್ಲಿ
Government weddings ನೀವು ಕೊಟ್ಟಿದ್ದಾರೆ ಆಮೇಲೆ each year is certificate.
Now Sudarshan is trying to make out an altogether new ground. So let him file an affidavit, let him commit himself. ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡ ಇರ್ರಿ ಅವರು are they prepared to go and to the extent of saying that you worked only for free? At the learned counsel. Completely. Matter is reserved. The university is directed to file an affidavit. ಯಾರು ಮಾಡ್ತೀರಾ VC ನೇ ಹಾಕ್ತಾರಾ VC ನೇ ಹಾಕ್ಲಿ ಬಿಡಿ ಆದ್ರೆ ನಾನು You should file an affidavit specifically indicating as to when the petitioners herein were appointed as guest lecturers and for how many years they have worked as guest lecturers. The affidavit shall also indicate the dates of their appointment, and if there are different appointment orders issued for different academic years, the same shall also be narrated in a tabular column. The affidavit shall be filed within a period of 1 week from today. It will be uploaded immediately. No, I'm reserving it. You upload it within a file it within a week.
Serial number 6.
My lord, appearing for petitioner, my lord, filed amended writ petition and copy has been served to the AG's office.
Sir, one ನಿಮಿಷ ಇರಿ.
I will consider your certificates after I look at their affidavit. ಅವ್ರು ಏನಾಗ್ತಾರೆ ಹಾಕ್ಲಿ ಇರ್ರಿ ನಾನು. Without them, why should I? Yes, 6.
My lord, filed amended writ petition copy on 6th January. And the copy has been served also on the AG's office for respondent number 1. But
Where is the counsel? Prashant.
Judge Prashant.
Madam, this is that case regarding that medical reimbursement, alva?
Yes,
Please, my
Lord.
lord. Please, my lord.
That list of hospitals to be, the hospitals which are not there in the list, they are also to be considered for the treatment. That was
Who will argue this case?
no, with regard to the addition of the hospital, we have communicated to the government.
Last time, Banu Prakash had argued this matter.
Yes, yes, yes.
Banu Prakash or the AG?
Both, even Mallarao sir has appeared, Lord.
No, here I think, Madam, ask the AG what exactly is happening.
Yes.
The list.
Much of it.
Standing counsel for that Suraksha, the second respondent is Mr.
No, I
Banu Prakash.
remember AG had come on the last occasion. He had said he'll talk to them and come back.
I will also convey the message.
24th.
Much of it.
Still number 7.
Sri Ravindra Reddy. Sri Ravindra Reddy.
Ravindra Reddy. ಇವೆಲ್ಲ ಒಂದೇ ಅಲ್ವಾ ಮೇಡಮ್?
Yes, howdo, sir. Regularizations. CMC
7, 8, 9.
contesting respondent. Since the petitioner was working there in the office of the R4.
ಇಲ್ಲ ಅವ್ರು ರೆಡ್ಡಿ ಅವ್ರು ಬಂದಿಲ್ವಾ?
Illa, sir.
ಮಾಡ್ತೀರಾ ಆರ್ಗ್ಯುಮೆಂಟ್ ನೀವು?
No, petitioner side, and
ನೀವು
no,
ಮಾಡ್ತೀರಾ?
service details has to be submitted through the 4th respondent, CMC Shabad, wherein the Mr. Kashampur appears, Lord, when he is not there.
ಇಲ್ಲ ಅವ್ರ ಹೆಸರಿಲ್ಲ ಇಲ್ಲಿ.
For Gaurish Kashampur appears for Shabad CMC, City Municipal Corporation.
7th ಅಲ್ಲಿ office to show the name of Sri Gaurish S. Shamapur is appearing for R4 TMC Shabad. ಇದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಇದಾರ ಅವರು? ಗೌರೀಶ್.
ಇಲ್ಲ ಸರ್.
ಏನಾಯ್ತು ಮೇಡಮ್? ಇವ್ರು ವಿಜಯ್ ಕುಮಾರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಸರ್, ಅವ್ರಿಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಕಮ್ಯುನಿಕೇಶನ್ ಮಾಡಕ್ ಲೇಟ್ ಆಯ್ತು. ಈಸ್ ಅಕ್ಯುಪೈಡ್ ವಿತ್ ಸಮ್ ಅದರ್ ವರ್ಕ್. ಬಟ್ Lordship, all the petitions are with regard to the compassionate appointment, where the father of these petitioners' services were regularized after the death of their father.
That
Now,
is serial number 9 ತಾನೆ? That is that Geeta Sajan Shetty's matter.
Yes, but this provision is with regard to the regularization of the local candidates. The prayer in all the common petitioner is for the compassionate appointment.
ಇಲ್ಲ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಇಲ್ವಾ ಈಗ?
Since Vijay Kumar sir appeared, if the petitioner advocate is very insisting for argument, if lordship insist, I will argue, otherwise I seek one adjournment.
ನಮಗೆ
My
case
lord, sir,
ಸುಮ್ನೆ-
this has been delayed for.
No, I'm not denying for argument. I will submit my reply. Our action ಕೋಪ ಕಷ್ಟ ತಗೊಳ್ಳೋದು ಬೇಡ.
ಅಲ್ಲ ಪೂರ್ತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳ್ಬಿಡ್ತೀರಿ, ಇನ್ನೊಂದ್ಸಲ ಟೈಮ್ ಕೇಳಬಾರ್ದು. ಅದಕ್ಕೆ ಹೇಳ್ತಿರೋದು ನಾನು.
But let her clarify this ground, sir, whether she is seeking for a compassionate appointment or for the regularization of the service.
No.
My lord's first two matters are only for
If I remember
regularization.
correctly, in her case, there was an order of regularization, but that was withdrawn the moment the claim for compassionate appointment was made. Therefore, they are
Okay.
before the court.
In
Chances are
only
withdrawn.
lordship that is pertaining to be the district matter, which she has not challenged withdrawal order. And one more matter wherein the withdrawal is being challenged. Other than those three cases,
No, what she said was in you're selective. In some cases where the regulation order is passed, you have not considered the claim for compassionate appointment. In some cases, whenever the moment a claim is made, you have chosen to withdraw the order of regularization.
it is not a selective order, lordship. It is the appointing authority is deputy commissioner. Though it is the order withdrawn by the concerned deputy commissioner of the districts. Only the deputy commissioner of Bidar has withdrawn the order, and since the Kalburgi deputy commissioner has not passed any order against the regularization.
So serial number 9, I can consider independently. You're ready?
Yes, lordship. 1675. Yes, lordship. Yeah, in this I'm ready. Yes, sir. Lordship, in the serial number 9, already the petitioner's father's services was considered under the Welfare Act. Welfare Act, there is an administrative order. The name of the petitioner's father appeared, and his father has admitted the order, and he till his death he continually worked and under the Welfare Act only. He never objected for his service, considering his services under the Welfare Act. Now, where is the jurisdiction for the petitioner to challenge that order now?
Got it, 9. Serial number 9.
Yes, lordship.
Madam
And
Geeta.
the
My
petitioner.
lords, in these cases, the first two cases are pertaining to regularization, my lords. And in this matter, the first matter, my lords, wherein the son has filed seeking regularization, but I have filed a compilation in spiral binding, in which shows that the father had approached the Honorable High Court twice for regularization, and twice the court has said to consider the representation. However, the Bidar DC has not taken any steps in this regard. And thereafter, there was also communication made by DMA that you have not done anything regarding this, kindly consider. And even before they considered, the workman expired, my lords. And he has put in 25 years of service, my lords. Despite that, there is no regularization of services.
So both the petitions are dead, 9 and 9.1.
Yes, my lords. And both have put 25 and 28 years of continuous service, my lords.
No, the petition is filed by whom? By the son?
By the son. But even before that, the workman himself had filed before the Honorable High Court. At that point of time, it was in Bangalore, my lords. That time, the Kalburgi bench had not yet started. He had filed it in 1997. My lords, there is a green spiral binding compilation.
Yes.
In that, my lords, his name appears on page number 18, ink page number 9, and serial number 19.
Page number?
Page number 9, ink page number 9, and serial number 19. Dilip Kumar, son of Premnath.
It is admitted that your father worked for 25 years?
Yes, my lords. And I have also produced my service book, my lords. My father's service book has also been produced in the court.
Madam, have you filed objections?
Yes, sir,
They
in this,
filed objections, my lords. My lords, he had approached twice, once in the year 1997 and once in the year 2006, my lords.
as per the direction, the respondents have considered his representation and his name was considered under the Welfare Act. And the petitioner's father himself has not disputed at any point of the time.
My lords, if in the same compilation, if my lords look at page number 25, there is a letter from the DMA citing this petition saying that what have you done and you are the authority to consider for D group employees. And this order was actually
What about 9.2 and 9.3?
9.2, my lords, they are pertaining to compassionate appointment, my lords.
Lordship, in 9.1, the petitioner, as on the date of appointment, he was not qualified. For that post, the SSLC is the required qualification. After the date of appointment, he has acquired the SSLC.
9.1 ಅಲ್ಲ.
9.1 ಅಲ್ಲಿ.
But my lords, when the state committee has considered his regularization of services, they've only said that ಮಂಜೂರಾದ ಹುದ್ದೆ ಖಾಲಿ ಇದ್ದಿದ್ದಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ ಒಂದು ಗ್ರೌಂಡ್ ಮೇಲೆ ಅವರು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ನಾನು ಮಂಜೂರಾದ ಹುದ್ದೆ ಇತ್ತು ಖಾಲಿ ಇತ್ತು ಅಂತ annexure C ನಲ್ಲಿ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದೀನಿ my lords. Annexure C shows the number of vacancies that were available. And he has cleared his exams during his services, my lords. He was only one subject he had failed, which he cleared is later on, my lords.
What about 9.2 and 9.3? All of them are compassionate appointments?
Yes, rest all are compassionate appointment, in which only two matters compassionate, the regularization order has not been withdrawn. Rest all they have withdrawn, my lord. During the pendency of these cases.
Which is the one that is withdrawn?
My lords have filed one list wherein I've provided which are the cases that have been withdrawn, my lord. That list is there.
Serial number ಹೇಳಿ ಸಾಕಿರಲಿ, which have the withdrawn?
My lords, if I may point out the WP numbers, WP number 200213 has they have withdrawn, my lords. While this petition was pending. And 200558 has also been withdrawn, my lords. 200558.
Yes.
200592 also they have withdrawn, my lords.
The other cases they have not withdrawn.
Yes, my lords. And also 200737 they have withdrawn.
These four cases pertaining to the Bidar district's lordship. And those withdrawal also not challenged by the petition.
Okay. That's all?
Yes, my lords.
Anything else, madam?
Lordship, since she was insisting on this rule 13C of 371 Act.
You have not argued, so I'll take it that you have no argument.
No, lordship, on that point, WH will argue.
File your written arguments, that is all.
Lordship, it is, my submission would be, this is in a directory nature. I'll just go through the rule 13C, regularization of local candidate. Shall I read, lordship?
Yes.
Local candidates who have worked on daily or contractual wages in the government for more than 10 years prior to 1/1/2013 and fulfill the condition as prescribed may be given certain condition in appointment and other benefit as prescribed by the government.
Yes.
It is in a directory nature. It says only during the appointment, as per the appointments are as per the rules. Only it says about some concession to that appointment.
So what is the concession you are giving? Refusal to regularize?
Concession in the sense that the C and D group, the 75% reserved for the HK region candidates. Lordship. That is the,
No, that is not what is stated. Why would they refer to regularization of local candidates? They are
while
saying-
regularization also the certain concessions to be given. It is,
What,
it is
is there any
direct
concession
in
prescribed?
nature.
Is there any concession prescribed? This indicates that everybody who's put in 10 years of service prior to 1/10/2013 in Hyderabad, Karnataka area are entered for regularization.
It is may be given certain concession. This is my
Now,
interpretation.
what is the marginal note? Regularization of local candidates.
Yeah, work
Local
for more than
candidates.
10 years. Yes, sir.
All of them are local candidates who have worked on daily or contract basis in government for more than 10 years prior to 1/1/2013 and fulfill the conditions as prescribed. If there are no conditions prescribed, that means you have.
Condition means service conditions, even the Uma Devi's judgment conditions also apply for this.
No.
There should
That's
be
why,
an-
that's why this Uma Devi's case was in 2006. This is subsequent of the year 2013. So Uma Devi's case will have no application for HK area.
No, Lordship.
That is
For
why-
any regularization, the Uma Devi case is a mandatory. For
No,
regularization, they have to follow those four
This
conditions.
is a constitutional order. It gives them a special right. So Uma Devi's case is general application. So whenever it relates to regularization of people from HK area, this clause 13C will come into operation. So you can't
Lordship,
fall back upon
my-
Uma Devi's case.
Yes, my submission would be, it is directory in nature and it says only with regard to the concession to the petitioners. Not
Yeah,
that they are completely entitled for the regularization. That is my submission.
My lords, I'll also file a brief submissions, my lords, final submissions. I'll serve a copy to them, my lords.
Lordship, kindly permit me to file one brief and along with the judgments.
Madi madam, when welcome.
Obliged.
Date may be given, my lords.
No date, I'm reserving it.
Obliged.
Within a week.
Obliged, my lords, obliged.
ಇಲ್ಲ, ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ. ಎರಡು ಇಲ್ಲ. ಮೇಡಮ್ 7 and 8 ಯಾವ್ದು ಇವಾಗ? ಮೇಡಮ್ ಗೀತಾ.
Madam, Kalburgi against matter. Arti Patil.
7 and 8 adjournment. 7 and 8 released ಅಂತ ಗೌರೀಶ್ ಕಾಶಂಪುರ ಬಂದು.
Forward bench matter, passed over matter.
ಮತ್ತೆ ಬಿಟ್ಕಿರ್ತಾನೆ.
ಪೂರ್ವಾನುಮತಿ ನೀಡಲಾಗಿದೆ ಎಂದು ನಿಮಗೆ ತಿಳಿಸಿ. Approve the product.
Former advocate places on record the sanction accorded by the government under section 16. The section 15 of the Karnataka Carbon Development Authorities Act for establishing a layout in 16 acres 9 guntas. The same is taken on record. Yes. What will you do now?
Now their authorities go through the matter, acquisition of the land and forming the layout. It will take some reasonable time because acquisition to be done. And
How much time? How much time?
1 year on
1 year ಬೇಕಾ?
for acquisition and forming the layout.
Land acquisition and development work ಮಾಡ್ತಾರೆ.
The commissioner. ನಿಮ್ಮ ಹೆಸರೇನು?
ಸಿದ್ದಪ್ಪ ಬೇವೂರು commissioner.
The commissioner of the Gadag Bedgeri Urban Development Authority, Shri so and so, is present with the court, submits that now that the government has accorded approval for the scheme, the process of acquiring the lands would begin and the layout would be completed within 1 year. 1 year tane? In the light of the above, release this matter. ಒಂದು ವರ್ಷದ ನಂತರ ಕೇಸ್ ಬರುತ್ತೆ, ನೀವು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಐ ವಿಲ್ ಹೋಲ್ಡ್ ಯು ರೆಸ್ಪಾನ್ಸಿಬಲ್.
Also our matter. Serial number 13.
No, there is no order of eviction passed, isn't it? So how can I in this petition pass an order of eviction?
Once the landlord and tenant relation, and from 2010, my instructions are now kept under lock-in. They not even being used.
That is besides the point. How can I pass an order of eviction when the petition that I was considering related to an order passed on of an intricate nature?
They had filed an application on 7 to 10 to return the thing. That was rejected, your lordship considered that. So your lordship has considered SRP 30 of 2019, where the eviction order was challenged by them.
He says that was a conditional order. So did he, has he completed the condition?
They have been being obligated, but that doesn't mean.
No, pursuant to the order, if he has complied with it, there is no order of eviction.
Because he has filed a petition for eviction now. 2025 January, the lordship has granted an equitable order. He is now wanting it for qualified.
It is an equitable order if it was not erroneous. That if he agrees. So my mistake, you can take. In extra time ಬೇಕಾ ನಿಮ್ಗೆ? ಬಿಡಿ ಅದಾಗಲ್ಲ ನೀವು.
Now the landlord is unable to make use of it, but he is that need of it, you want this land to put up a.
And I made this remark earlier also. He's from Mangalore. So they are not going to be very.
Sir, at the stage of arguments, the petition was right, responding to argument. Lordship may consider that aspect and some more time, but
I can't grant an order of eviction. You tell me there's a way out, I'll do it. No, I understand your submission, but tell me my answer also trade, isn't it? I can't go. You know, he gave a hint and we wanted to purchase the property, therefore. For what? I'll direct. This could.
Direction to dispose of the matter within 1 month, because in the stage of responding argument, unnecessary application is filed.
WP 7764/2022 was clubbed along with HRRP 30/2019 and HRRP 15/2022. And was disposed of on 24th of July 2024. While disposing of this petition, this court had affirmed the order of eviction that had been passed in HRRP 30/2019 and had gone on to grant time of 6 months for the petitioner tenant to vacate. Next. This order was based on the premise that an order of eviction had been passed and the same was being confirmed by dismissing HRRP 15/22, which was arising out of HRRP 30/2000, which was arising out of the order passed in RCA number 7/2010. However, this review petition is filed contending that RCA 7/2010, in which an order of eviction was passed, was a conditional order which would come into effect only if the tenant had failed to pay the arrears as determined. It is contended that the arrears of rent were in fact paid, therefore there was no order of eviction in force. Consequently, the subsequent order passed by this court granting 6 months time on the premise that there was an order of eviction would be erroneous. The court was considering 3 petitions that were pending before it. WP 7764/2022 had been filed challenging an interim order by which the jurisdiction between the parties was sought to be adjudicated in IDEA proceedings.
This is an eviction petition under section 27(2)(R).
Number 8.
RCA 3 of 2017. RA 12 of 81.
RCA 3/2017. The second petition was HRRP number 30/2019, which was in respect of the order of eviction that was passed in RCA 7/2010 and which was a conditional order. HRRP 15/22 arose out of an interim order regarding the jurisdiction of the rent court to determine, to entertain the petition, since it was contended by the tenant that the property was that they contended the tenant that it was only the commercial court which had jurisdiction. This HRRP arose out of RCA 3/2017. By the order of this court, the orders which were impugned in WP 7764/2022 and HRRP 15/2022 were affirmed and the petitions were dismissed. Since the further order passed by this court in HRRP 30/2019 on the premise that an order of eviction was in force, as stated above, would be erroneous, since the order of eviction was a conditional order and the condition was complied with. In that view of the matter, the order passed by this court will have to be reviewed insofar as it relates to the direction to hand over vacant possession pursuant to the order passed in HRRP 30/2019 That is pursuant to the order of eviction passed in RCA 7/2010. Then it's council submits that pursuant to this order, the rent court has closed the proceedings RCA 7/2010. Since it is held that the order of eviction is not substituting by virtue of the condition imposed in it, when complied with the tenant, the rent court is directed to take up RCA 7/2010 for consideration on merits 3/2017. RCA 3/2017 on merits and pass appropriate orders. In regard to the fact that the proceedings were initiated in the year 2017, would be appropriate to direct the trial court to dispose of RCA 3/17 within a period of 2 months from the date of receipt of a copy of this order. Since the parties are represented before this court through a counsel, they are directed to appear before the trial court in RCA 3/17 on
10th February.
I've said 2 months, isn't it? ನೀವು ಬರ್ತೀರಿ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ, can you prevent a lawyer from filing an application?
Hearing on IS, serial number 34, Srimati Yukta N. Serial number 34. For reporting compliance. Posting B. Serial number 35, Shri Vasant Kumar.
Island ತಾನೆ? Island.
Posting. Allotment.
Number 12. Then Basam. Yes.
On the east boundaries which is mentioned. 41/1 on the eastern side. On the western side, 41/1 and 46.
And 41/2.
That is 42 and 41/2. So let's produce the.
Where is the reference to the lake here?
7/46.
The entire 46.
I got that.
And the continuation cheating.
So this was abutting. So this was abutting the lake.
This is abutting. Now, plus and ending also produce the.
But according to this boundary, only on the western side there was a lake. So the plan that you showed me earlier indicated that even to the south you have formed a park. Plan that you showed to me last time indicates that the park was formed even to the south of the property, the north. No. Last time quoted in sketch alli, you showed the park to be to the north and to be on the south. Go back to the earlier plan. Next R1, isn't it? No, you told me that this triangular portion ABC is 41 bar 1 bar 1. Now let's assume it's 41 bar 1. Now, according to this notification, to the west was the lake. To the north of this property, there is no lake. To the south of the property, there is no lake according to the boundaries in the notification. Then how do you explain this park that is formed to the south of his property?
This is survey number 41 bar 2. This is a which one?
No, you simply say park. Park level.
The boundary of 41 bar 2.
That entire boundary is 41 bar 2. Till 41 bar 2 ಅಂತ ಬರ್ದಿದಾರಲ್ವಾ?
I wanted to show my acquisition record.
You acquired 41 bar 2. Where is your, where is?
Page 7.
Page 7.
Page 7.
This is for the purpose of
What's for the
surrender. Serial number?
Serial number 155. Page 7.
155. 41 bar 2.
41 bar.
The extent is 4 acres 32 guntas. What is the boundary here?
41 bar 1 made it. Serial number 12 by bar number 12.
Okay. So 41 bar 1 was not acquired according. So how?
41 bar 1 is not 46. 46 is there. As it is. As we couldn't acquire. As I submitted last occasion. But before I proceed further, I just want to also just have reference to annexure R4
Of
of my affidavit.
2 days after. Yes.
41 bar 105 would be there. Page 17. Page 17. If the sketch there not page 17.
This is for which survey number?
41 bar 1. Left hand side.
Yes.
Please. Once at the bottom, the sketch has been prepared where they have given the two number.
This was done when?
This is 6/2/2019.
After the notifications. 41-1 is in whose name now?
But that is the next one. But there are 3 portions which are not seen. Not will see 3 portions.
ನಿಮ್ಮ ಹೆಸರು ಶಂಕರೇಗೌಡ. That is 5. 41 bar 5 ಆಗಿರೋದು. Now where is 6 here? Okay, this is the corner triangle.
So 3 portions.
I saw.
But the number 1 and that is where the video the next word passes. It cuts across this particular survey number on both sides. There is this essentially an item which got created because of that acquisition.
You have this island of Yeshgunta and Aidgunta. And how does he have access to this?
He will have access to the pathway only. That's one more aspect.
So he can't get a vehicle, he can't do anything. But taking the vehicle will not be, because this is right now, not exactly according to the lane, exactly a buffer. So regulations will not prevent not seeing breaking up any kind of whatever and it is so much of a problem. Not now. Beforehand also. Even beforehand also, there was always a restriction on him in utilizing so far as the area which was from the buffer that existed in space. Secondly, since the 746 entire is a lake, it's not even in my name, it's not even the under the ownership of the units under the ownership of the state. Being as the media owners, we have been entrusted with the additional responsibility of maintaining these lakes and maintaining the lakes, the boundaries which are there, they have to be maintained like a park. So this has been maintained like a park. Otherwise, survey number 46 entirely is only lake. This land essentially avoids the lake. Next, I was trying to say that not something which having done. Because this main road works, the peripheral road of cuts across their land. On both sides, the land got left. And this land now they have a difficulty because essentially they should have had access where the road which is formed. But because of the very nature of the next road is that they don't provide you any kind of an access to one. That is where they have a problem in accessing. Which I could carry to Harvey as it is. When the acquisition takes place, they lost access which they otherwise would have had from the other side. But how do you say that he's got access now? Access. The park area which is being maintained on 46. Walkway, we can access it. Where is the walkway, which is not indicated in this sketch? There is a walkway which is available for all persons to use park. Not necessarily restricted to. Yes. Original extent ಎಷ್ಟು? ಆಯ್ತು ಹೇಳಿ. ಆಯ್ತು ಹೇಳಿ 26 meters.
Thereafter, I being available, I made a presentation on 15/5/2019. Stating that even without reaching the acquisition of 6.5 meters that is realized for the park, hence he sought for updating that. Thereafter, the invention of the again one more made on 3/12/2020. For which now the joint survey has been conducted. Another get update, another page what has been conducted, which has been prepared very clearly identified my particular company where we have their intent saying that 500 can utilize even without this addition for the purpose of park.
But now they are saying it is not utilized. You are free to use it for any purpose that you want. Now they are saying it is not utilized. So. Who had constructed? What did they construct there?
The workers are getting rest and other doing the exercise and all. They say it's structure they construct by website only. Since they are the collections 2003. Subsequently they
Did the BDA construct anything there?
But it is not in their lands. No, it is not in their lands. At Uttar Nuts, because it is the area where nuts lake and park of the nuts, they had to be. I'm not making any assumption that there is not been any. There was a structure there.
You're saying now you are now coming down to this fact that you had used it temporarily.
That's been
not used their lands. We have not used their lands. There was a structure, this structure had to be removed, it's been removed. It is not in their lands. But now they're saying that they've done a resurvey. They are identifying 5 gundas for you to use it in any manner that you want. They have now identified 5 gundas of land, which they say is yours, and you're free to use it for any purpose that you want. So why do you want their alternative state when you're getting back your own land? I will record the statement that there's a pathway that you can go and utilize. I'll ask them to file an affidavit indicating the pathway to you so that you'll have access to that 5 gundas of land. Aktira? ಬಿಡಿ ಅವ್ರು ಇಲ್ಲ ಅಂತಾರಲ್ಲ ನಿಮ್ ಜಾಗ ಬಿಟ್ಕೊಡ್ತಿದಾರಲ್ಲ, enjoy that. This petition was filed seeking for washing of. What is the next area? 35. Page. On the ground that the petitioner would not be entitled to allotment of an alternative site in respect of the 5 guntas of his land, which had been utilized for the purposes of formation of a park. In the pendency of this writ petition, submissions had been made on behalf of the BDA that the request of the petitioner for allotment of an alternate site was under its active consideration, and that alternative sites would be handed over to the petitioner. However, thereafter, the BDA has filed affidavits stating that as a matter of fact, the land of the petitioner measuring 5 guntas, which was formerly survey number 41/1 and presently survey number 41/6, have not been utilized. The sketch is also produced indicating that 6 guntas of land, 5 guntas of land has not been utilized, and the said extent is also demarcated. The BDA has also stated that it has not utilized the land for any purpose, and in the affidavit of the commissioner at para 6, it is stated that the land of the petitioner is a vacant land and is not a part of the park developed by BDA. It is also stated in the affidavit that the petitioner would have access to this extent of 5 guntas, the walkway made in the said park. You have no objection for it to be used. You said anywhere that you can use it for any purpose that he wants. In the light of the above affidavit, it is clear that the petitioner would be entitled to utilize the extent of 5 guntas, which is owned by her, since the same has not been acquired in a manner known to law. The petitioner shall, as undertaken by the commissioner, have access to this extent of 5 guntas through the walkway in the park. The affidavit, the concerned official of the BDA shall file an affidavit within a week indicating the pathway, and also state in the affidavit that the petitioner would have an unhindered right to access his property through the pathway that would be indicated in a sketch along with the affidavit. The petition is accordingly disposed of. The said affidavit to be filed within a period of 1 week. You are permitted to utilize an animal that you I've said you are at liberty to utilize it in any manner that you want. I should actually impose cost on your, you made him come to the court and you gave him the illusion that you will give him 5 gundas of land. Yes. I really got annoyed at your client because of the way the case was dealt with. And what action you would taken against him? You said you would take action against that. That is all. The last, ನಿಮ್ಗೆ ಯಾಕ್ರಿ ನನ್ಗೆ ಅವ್ರು ಬಿಟ್ಟು ನೀವ್ ಸುಮ್ನೆ ಇರಿ. On the last occasion, the commissioner was present before the court, stated that the official who was responsible for issuance of the impugned endorsement to the effect that the land measuring 5 guntas of the petitioner had been utilized would be proceeded against with on the department side. The commissioner shall place on record the copy of the proceedings that have been initiated against the concerned officer who misled the petitioner as well as this court to the effect that the extent of 5 gundas of land of the petitioner had been utilized by the BD. This shall be done within a period of, Sir. 2 weeks. We shall file that.
233 matter, serial number 1.
What's your designation? The SLA was present. Is ordered.
233 matter, serial number 1, Shri Mohammed Tahir.
But liberty was granted to initiate fresh proceedings. And fresh notice is given. What is wrong? No, the interim order itself said, hence interim order is granted staying further proceedings pursuant to the notice dated 4/12/2024, but without prejudice to any further proceedings that could be permissible in accordance with the act and the rules. So there's no need to seek for vacating. Only that meeting pursuant to 4/12/24 could not have gone through. This order itself is clear. ಇಲ್ಲ ಬಿಡಿ ಕಾನ್ಫಿಡೆನ್ಸ್ ಇಲ್ಲ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ. You had sufficient time ನಿಮ್ ಕಡೆ ಬರ್ಮಾಡ್ಕೋಬೇಕಿತ್ತು ಅವ್ರನ್ನ. You had ample time. That's all. The petitioner is challenging a special meeting convened by the Assistant Commissioner for consideration of the motion of no confidence that had been moved against the petitioner. This special meeting is convened pursuant to a requisition given by 17 members on 23/12/2024. It is a case of the petitioner that the earlier notice dated 4/12/2024 had been challenged with the petitioner in WP 34231/2024, and this court had granted an interim stay of further proceedings pursuant to the said notice, and hence it was impermissible for the Assistant Commissioner to entertain a fresh notice of no confidence. Next one. This court, while granting an interim order in WP 34231/2024, has stated as follows, para 26. As could be seen from the above, this court had granted an interim order only in respect to further proceedings pursuant to the notice dated 4/12/2024. But at the same time, this court had granted liberty for initiation of fresh proceedings as is permissible under the Act and the rules. It is therefore clear that the court did not bar the initiation of a fresh proceeding regarding no confidence against the petitioner. Since the members of the Gram Panchayat have initiated a fresh requisition calling for a special meeting in accordance with law, the Assistant Commissioner was justified in convening a special meeting. I find no reason to entertain the petition. Petition is therefore dismissed.
Seal number 2, Shri Ajay Prabhu.
This petition is filed challenging an order of demolition under section 356 of clause 2 of the BB Act 2020. It is a case of the petitioner that as against the order of confirmation, the petitioner had preferred an appeal to the Chief Commissioner, and the petitioner has also been granted an interim order of status quo. And despite this interim order, the demolition order is passed. The copy of the interim order is also produced as annexure F. In my view, since the order of confirmation is the subject matter of an appeal and this interim order to maintain status quo, it is obvious that the demolition order, the second respondent could not have issued the impugned order of demolition as per annexure A. Consequently, annexure A is quashed. Liberties are reserved to the second respondent to initiate, to pass an order of demolition, depending on the result of the appeal that has been filed by the petitioner in appeal number 204/2024. Thank you, please accommodate Shri Sonachi to take notice.
For order, seal number 3, Shri T. N. Vishwanatha.
You are challenging the meeting notice.
Without issuance of notice, as prescribed in Rule 4, to all the members, elected members, they have directly issued the calendar of events for the election on 13th.
Where is the calendar?
It's number 19. Page number 19. No notice is issued to the petitioner or many other members who are elected. And the first meeting is not called at all, my lords, for fixing the date of election.
Now, why was the vacancy created?
Because he has resigned from the post.
Who resigned? The earlier president. When was that resignation?
18/12/2024, he submitted his resignation. And then on 30/12/2024 at 11 o'clock, he was called to attend an inquiry before the assistant. Page number 18 is the notice. Next, let's see.
To him.
Please.
Then what happened?
Then ultimately his resignation was accepted.
Where?
And Derek, the acceptance is not shown in the notice, but annexure D, 13/1/2025, they make a reference to the letter dated 3/1/25, which is issued by the commissioner. 13/1, they issue a notice. No notice is issued to the petitioners here or elected member. On 20th, the election is fixed along with the calendar of events. Rule 4 mandates the issuance of notice to all the elected members, and the date of the election was to be fixed by way of first meeting.
3/1/25 is the
Order of the deputy, the letter issued by the deputy commissioner to the concerned authority who has been nominated.
what is this Sayaka Commissioner Kolar dated 31/12/2024. Read the Sabha Suchana Patra. Karali Grama Panchayat Saviri ಈ ಮೂಲಕ ತಿಳಿಸಿ.
Look, that there is a vacancy that 3012, my lords, that is when the resignation was accepted. The assistant commissioner, my lords, has issued a notice of annexure C, my lords.
What is that rule 3?
Rule 4,
Election of.
my lord. Copy.
తీసుకోండి.
Okay.
Yes.
ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸದಸ್ಯರು ಪ್ರತಿಯೊಂದು ಸಾರ್ವಜನಿಕ ಚುನಾವಣೆಯ ತರುವಾಯ ಅಥವಾ ಈ ಅಧಿನಿಯಮದ ಅಡಿ ಅದರ ರಚನೆ ಪುನರ್ರಚನೆ ಅಥವಾ ಸ್ಥಾಪನೆ ಆದ ಮೇಲೆ ಅಥವಾ ಯಾವುದೇ ಸಂದರ್ಭದಲ್ಲಿ ಅಧಿನಿಯಮದ 5ನೇ ಪ್ರಕರಣ 8ನೇ ಉಪಪ್ರಕರಣದ ಅಡಿ ಚುನಾಯಿತ ಸದಸ್ಯರುಗಳ ಹೆಸರುಗಳು ಪ್ರಕಟಿಸಿದ ದಿನಾಂಕದಿಂದ 1 ತಿಂಗಳಿನೊಳಗೆ ಉಪಾಧ್ಯಕ್ಷರ ಹುದ್ದೆಯಲ್ಲಿ ಯಾವುದೇ ಆಕಸ್ಮಿಕ ಖಾಲಿ ಸ್ಥಾನ ಉಂಟಾದಾಗಲೆಲ್ಲ ಮೊದಲ ಸಭೆಯಲ್ಲಿ ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿಯು ನಿಗದಿಪಡಿಸಬಹುದಾದಂತಹ ದಿನಾಂಕದಂದು ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷ ಚುನಾವಣೆಯು ನಡೆಯತಕ್ಕದ್ದು ಮತ್ತು ಅದನ್ನು ಹಾಗೆ ನಿಗದಿಪಡಿಸಿದ ಬಗ್ಗೆ ನೋಟಿಸ್ ಅನ್ನು ಪ್ರತಿಯೊಬ್ಬ ಸದಸ್ಯರಿಗೆ ಕಳುಹಿಸತಕ್ಕದ್ದು. So the first meeting was to be conducted, the date of election was to be fixed, and the notice was to be fixed to all the members.
How is the prejudice caused to you?
But I have not been issued a notice. No, in the first meeting itself, if all the members nominate somebody as the president, they can do so without election further. Under section 45 of the Gram.
The same thing can be done if you were to go contest also.
No, my lords, they have directly called for the nominating papers and everything. The calendar of events is published. That is in violation of rule 4.
No, what is the prejudice? You can still go and participate, isn't it?
No, my lords, even to decide as to who has to be nominated as the president, there is no time given. My lords. In 7 days, they have declared.
Who should nominate?
Lords,
Who should nominate?
the elected members. Even for us to.
The elected members will elect.
Please, my lords, we are all members, but we have to elect one of the president.
You go and elect. If you want to stand on the 20th.
No,
Because
no, my lords, even has to decide who has to contest the election. Before that, there has to be a meeting which has to be held. That is the Modala Sabha. On that day, he has to decide as to when the election is to be conducted. Without that, my lords, once the date of election is decided on the Modala Sabha, then a notice has to be issued to all the members. This entire process is circumvented here.
they refer to rule 3. What is rule 3?
Rule 3 is ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿ. He has been nominated as the election officer for this purpose. He only refers to that rule 3, not compliance of rule 4.
No, it's rule 4 only says the ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿ under rule 3. ಇನ್ನೊಂದ್ಸಲ ಓದಿ. ಉಪಾಧ್ಯಕ್ಷರ ಹುದ್ದೆಯಲ್ಲಿ ಯಾವುದೇ ಆಕಸ್ಮಿಕ ಖಾಲಿ ಸ್ಥಾನ ಉಂಟಾಗದಾಗಲೆಲ್ಲ ಮೊದಲ ಸಭೆಯಲ್ಲಿ ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿಯು ನಿಗದಿಪಡಿಸಬಹುದಾದ ದಿನಾಂಕದಂದು ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷ ಚುನಾವಣೆ ನಡೆಯತಕ್ಕದ್ದು ಮತ್ತು ಅದನ್ನು ಹಾಗೆ ನಿಗದಿಪಡಿಸುವ ಬಗ್ಗೆ ನೋಟಿಸ್ನ ಪ್ರತಿಯೊಬ್ಬ ಸದಸ್ಯನಿಗೆ ಕಳುಹಿಸತಕ್ಕದ್ದು. He has the power to decide the date of the meeting, and after he fixes the meeting, he is to notify everybody about the date. This is what is the first paragraph. Karali Grama Panchayat Sadrige.
Not issued to me. That notice is not issued to me, my lords.
Please read the first 2 lines. This is addressed to you only, Narayan Swami.
No, my lord, he is not the petitioner. It is addressed to the ex-president, my lord.
Read the first 2 lines. It's not addressed to him.
Lord,
This is a general notice. You have secured a copy of the notice issued to Narayan Swami. It is issued to everybody.
No, my lord. Lordship, I kindly see the representation which I have made.
Read the first 2 lines of this Suchana Patra.
Karali ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸದಸ್ಯರಿಗೆ ಈ ಮೂಲಕ ತಿಳಿಸುತ್ತೇನೆ.
Panchayat Sadisarige.
ಹೌದು.
This is to all the members.
ಹೌದು. And ಕೆಳಗಡೆ they have addressed it to ಶ್ರೀಮತಿ ಶ್ರೀ ಎಂ
So,
ನಾರಾಯಣ ಸ್ವಾಮಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Identical notice will be sent to everybody, including you.
They have not sent it. They have only chosen whom they have to issue this notice.
Where have you said you have not been given a notice?
Representation itself, but annexure.
But anyhow, now that you know that the election is there, what is the prejudice?
Well, the members, that's what they are trying to do here is, they have sent this notice. On that day, if there are few members that are absent, the majority of their people will be present. And the president will be elected.
Jai Kumar.
No, my lords, if the notice is issued to all the members.
What
and if
happened?
the- my lord,
What will happen?
No, then my lords, there may be few people who have not been issued notice. Now,
Let them
the
come.
next one majority they're doing this. but
No.
let it be issued.
The fact that you have come to this court indicates you have notice of the meeting.
Only we both know about this.
So let them come. Those who have not been notified, let them come.
But we are not notified here. This is issue to Narayan Swami.
Suppose they come and say that you have been notified.
My lord,
If they produce material to show that it is notified.
my lord,
If the Gottupadisida Adhikari comes and produce material to show that he has sent it by RPAD.
my lords, we have not received it. Even on 15th, we have made a representation asking for an authorized this thing from the concerned officer to give it to us. He has not, the annexure E, my lords, page number 20. We have made a representation on 15th. We waited till today. There is no answer at all.
This is only a request to issue a notice to you.
But we have also asked.
And you have notice of the meeting.
Notice issued to somebody else.
I don't understand what is the harm in you going and facing whatever.
But my only difficulty is, the notice is not served to everybody. If they've chosen, say, 5 people to whom the notice has to be served, and we both have.
Raise this subject in the meeting, saying that notice is not served to anybody, to everybody.
Entire writ petition become interested.
I'll say it will be subject to the result of the writ petition then. If they establish that the meeting notice was issued to everybody.
But the elections are conducted.
Type reserve.
Under 45, I'll have to file an election. I cannot-
No, I'll make it clear it is subject to the result of the writ petition.
Hello. Hello, we are not, there is no.
Your only argument is that you have not been notified.
No.
Tomorrow the Gottupadisida Adhikari comes and produces material to show that you have been notified and all of members have been notified. Then what should happen?
No, but we have, I've made a representation, Lord, and I've also stated in the affidavit that I've not been served. Even in my writ petition, I've stated that I've not.
That's already calendar of events has been issued, my lords.
No, that may be so, but have you notified everybody?
So I have to ascertain regarding it.
When is the election?
Monday.
What time?
13th, they issue them at 10 o'clock. And this notice is issued on 13th, Lord. Not even a week.
There's no time limit, isn't it? The discussions with the officer.
No, my lord, there's no time limit prescribed in the rules that I agree with. But so far as
I still don't know what is the prejudice cost you.
Lord, the entire effort here is, Lord, to see to that,
To scuttle the elections on that particular day.
conduct the elections on that particular. No, Lord, that is not the, Lord, let the elections go on. Let them issue notice, Lord. Let all the members be notified, let the election go on. As per, however, the election has to be conducted, what the prescribed officer has to do, let him do it. But let everybody be notified. That is the only issue.
How many members are there?
ಇದು ಕಾರಡಿ
I'm not prepared to-
ಒಂದು ಹಳ್ಳಿಗಳು ಬರುತ್ತೆ ಇವರು ಇಬ್ರು ಬಂದು ಒಬ್ರು ಯಲಬುರ್ಗಿ ಮತ್ತೆ ಇನ್ನೊಂದು ತಿಮ್ಮಾಪುರ ಅಂತ ಇವ್ರು 2 ಹಳ್ಳಿಯವರು ಇಲ್ಲಿ ಬಂದಿರೋದು ಬೇರೆಯವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗಿದ್ರು ಇವರು ಏನು
If by chance he produced material to show that all of you have been notified, there will be heavy costs on you.
as of today, my lord, there is-
I'm putting you on notice. If by chance they produce material to show that you have been notified of this meeting and you made a statement incorrectly,
I'll again verify. Right,
make sure or else you'll be in trouble.
I don't want to. ಇಲ್ಲ ಬಂದಿಲ್ಲ ಸರ್.
Tell him if the information is found to be incorrect. It is the case of the petitioner that as required under the rules, the nominated officer under rule 3 has not issued notice to all the members of the panchayat and is proceeding to conduct an election in violation of rule 4, which mandates notice to all the members whenever a date is fixed for conduct of election to the Adhyaksha. In view of the said statement, the AGA is directed to secure instructions as to whether notices of the proposed election were indeed served on all the members of the panchayat. Relist on so on. The election scheduled to be conducted on 20th of January 2025 shall accordingly stand adjourned until further orders by this court in that regard. Relist on 21 Tuesday. 21st. Now the other members will come running saying that we got this notice. If by chance they have got he put him on notice that
Twenty-first. Seal number 4.
and will be permitted.
Seal number 4, Shri Venkatesh Soma Reddy.
Number 2. They have made certain demands for the amount. Payment G, my lord. You are required to pay 1 crore 19 lakhs. Not pay and short for some time, my lord. Now, my lord, installment. Why were you required to pay 1 crore? They have given in the request letter, my lord, that they are ready to pay. Please permit us to make the payment, my lord, next year, page 63. They are not replied to this. Now, in the meanwhile, my lord, I only pray, my lord, to permit us to make payments in installments, my lord, from reading time. No, what is the demand for 1 crore net? 1 crore for the completion certificate, issue completion certificate of the building. Then the issue, my lord, page 55, you are to pay this. They issued the demand for 1 crore 19 lakhs on 21/8/2017. Building had been constructed and completed. Please read annexure G. Apartment. Pardon me, my lord. Please read annexure G, my lord. ದಿನಾಂಕ 7/4/2018 ಅಬ್ದುಲ್ ಅಜೀಜ್ ಫ್ಯಾಟ್ಸ್ ಫಿಕ್ಷನರ್ ಮೈ ಲಾರ್ಡ್ ಕೋಟಾ ಸರ್ವೆ ನಂಬರ್ ಡ್ಯಾಶ್ ವಾಣಿಜ್ಯ ಮತ್ತು ವಾಸನ ಕಟ್ಟಡಗಳಲ್ಲಿ ಪರವಾನಗಿ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿ ಮೇಲಿನ ವಿವರ ಈ ಕೆಳಗಿನ ಕಟ್ಟಡ ಪರವಾನಗಿ ಶುಲ್ಕ ಮತ್ತು ಇತರ ಶುಲ್ಕಗಳನ್ನು ಪಾವತಿಸುವುದು. ಟೋಟಲ್ ಅಮೌಂಟ್ is so and so, my lord. It is actually for complete certificate. Thereafterwards, they said, my lord, that the authorization have to be made, page 58. So from 2017 for the past 8 years, you have not paid by them. And then after some years, my lord, COVID came and they had also raised some objections. COVID came in 2020. So from 17. My lord, they had also, corporation issued some objections, my lord. Page 58, my lord. 58. ಅರ್ಜಿದಾರರಿಗೆ ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಿದ್ದು ಏನೆಂದರೆ 28/3/2000 ನಗರಾಜ್ಯ ಪಂಚಾಯತ್ ತಾಂತ್ರಿಕ ಅನುಮತಿ ನಡೆಸಿದ್ದು ಹಾಲಿ ನಿರ್ಮಿಸಿದ ಕಟ್ಟಡದ ಲೋವರ್ ಗ್ರೌಂಡ್ ನಲ್ಲಿ ವ್ಯತ್ಯಾಸ. So constructed the building? My lord, it's constructed, sold and occupied, my lord. Occupied. They said this some objection that has been complied with, my lord. What? No. This has been complied with. Immediately complied with. Strictly speaking, the license would operate only if you had paid that money. But without paying the money, you have constructed, you have already sold. My lord, sir, I do whatever it's submitted. So, my lord, only thing is, my lord, that this was complied with within 23. Now, my lord, and we said now we are ready to pay. Please issue the challans. The directives to be there is a challenge for payment, my lord. That's at page 63. And it's a my lord. So you're agreeable to pay interest also? That aspect is, that's what the plea, my lord. Not able to pay the, my lord, sir. We are ready to pay this amount, my lord. Subject whatever my lord lays down, lord. We are ready to pay the amount. Please issue the challenge for payment. The challenge, my lord, they are not issued. In the meanwhile, what has happened is, my lord, some of the buyers, apartment buyers, they approach the consumer courts and consumer district forum and obtained order and execution petitions are filed, but so corporation is not a party. You are basically challenging the order of the consumer forum here. No, my only prayer is, my lord, I am consumer forum directed that I should obtain complete certificate. I can obtain a complete certificate from the corporation. I have. Where is the order of the consumer forum? Order that one of the orders, SFP, page 65, my lord. Operating portion, you have to kindly see, my lords, page 81. Opposite party directed to provide completion and occupation certificate, page 81, please, my lord. Operating portion of one of the orders. Obtain the completion and occupation certificate within 6 months. Now, my lord,
we have been approaching the corporation, my lord, as of this amount is concerned, initially we short time. Now we are ready to pay this in installments, my lord. The corporation has not said,
No installments, with interest immediately.
my lord,
You enjoyed 8 years. You already sold the property.
was sold, everything was sold, man. I am a developer. Everything was sold, man. And then, of course, there was problem, there is some variations were there, everything was complied with now. Now, only thing is to get a payment, my lord, I do.
Entire money immediately along with interest.
We have made out, we have submitted, my lord, that our difficulty was because of COVID, etc.
You had the benefit now for 8 years.
We go down.
But then they'll take appropriate action. Why are you worried? The purchasers will suffer.
We do not purchase. But of course, it's our liability to pay, my lord, of course, then there was problem. It was not intense.
When will you pay 1 crore 19 lakhs?
My lord, may kindly fix, my lord, for part payment within a month we make, my lord.
No part payment, immediate.
So may kindly fix it in a phased manner, we will pay, my lord, as my lord.
ನೀವು ಮಾಡಲ್ಲ ನೀವು.
To show bona fides immediately, like 25% payment immediately.
No, not 25%. 1 crore you deposit, then let us see. As regards interest, I'll keep it open. You cannot play around with somebody's life like this. And you waited till the last moment, till it came.
I have no.
So you are.
Moral liability and legal liability we go down.
ಹೇಳಿ ನೋಡಿ 1 ಕೋಟಿ ಇಮಿಡಿಯೇಟ್ ಕೊಡಂಗಿದ್ರೆ ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ಸಮ್ ಇಂಟರ್ ಮೋಡ್.
1 month 50%
then no interim order, let the notices go and come, we will hear it later.
Immediate mobilize it, shall come in, my kindly grant some breathing time, that's all.
ಇಲ್ಲ ಹೆಗ್ಡೆ ಅವರೇ ಇದು
We will go down, my lord.
I'll have it on Monday, get instructions that the entire money will be paid, I'll consider. You have been playing around with everybody. In corporation, they said in 17 you pay, you ignore them, construct, sell. Then you put the purchaser in jeopardy. They have to go to the consumer forum. They have to secure an order in 21. They have to fill an execution. So you have tried every trick in the book to protect and delay the payment. Time has now come. You pay, I'll do something. You don't pay.
Monday's execution case, my lord, and warrant will be issued on that day.
Madli budi adenu warrant I can always stay the warrant if you agree to deposit 1 crore. ಇಂಥ ಟೈಮಲ್ಲಿ ಅದನ್ನ ಕೊಡ್ಸಕ್ಕಾಗತ್ತೆ ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ you won't give.
Kindly direct us within the time, whichever your lordship fixes, my lord, and other.
You will get 20 lakhs concession if you agree to pay 1 crore by Monday. Monday you get instructions. 1 crore 19 lakhs alway iradu. Interest aspect I am not going into. 1 crore you agree to deposit on Monday, then let us release on Monday. Yeah, ಅವರೆಲ್ಲ ಏನ್ಬೇಡ ನೀ ಫಸ್ಟ್ ಕೊಡಿ, ನಾನು ಐ ವಿಲ್ ಪ್ರೊಟೆಕ್ಟ್ ಯು ಇಫ್ ಯು ಆರ್ ಫೇರ್. ಮಾಡಿ ಆಗುತ್ತೆ. ಬಿಲ್ಡರ್ ಎಷ್ಟು ವರ್ಷ ಕಟ್ಟಿರೋದು ನೀವು? ಅವರು ಹೆಗ್ಡೆ ಹತ್ರ ಬರಬೇಕು ಅಂತಾನೆ ಅವ್ರ ಕೆಪಾಸಿಟಿ ಇದ್ರೇನೆ ಬರೋದು ಅವ್ರು. ಮಂಡೇ I'll take up only Ms. Rajgopal's matter and 2 430 matters. The other matters will be relisted.
37.
We'll extend interim orders in all the cases.
No progress, my lord, none of the.
Get Murugesh then. Get Murugesh. Murugesh Nahuman, I'll pass him.
What's your date? Our what?
That's serial number. That's with. Same thing.
Who appears for 70?
Subramani.
Subramani.
I have taken action yesterday.
What, 1 minute, I'll finish.
Lord, they have taken some action yesterday, my lord.
Madam.
Some functions also which they are doing paid functions 5,000 rupees per day collect ಮಾಡ್ತಿದ್ದಾರೆ 20 stalls ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. If ನೆನ್ನೆ clear ಮಾಡ್ಬಿಟ್ಟು as soon as they got to know the matter is not reaching, ವಾಪಸ್ stalls ಹಾಕಿದ್ದಾರೆ. You can see the first page your lordship. They are telling that PBF has given permission.
What is?
The especially the AE Somsekhar ಯಾರೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ they are reporting this matter to the other side with the phone numbers. They are leaking all the information.
Kindly see this, my lord, they have taken action yesterday. Lord, I am told that, my lord, they have removed all the street vendors. My lord, I am producing photographs also.
The lordship have produced with the GI tagging also.
The last me kindly take the photographs, my lord. No.
In fact, yesterday, the last second page for me, accident ಆಗಿದೆ because of the stalls. I put those photos also.
You give him a copy of this?
I'll give. I am furnishing a copy, my lord.
Lordship, in fact, because of the vendors, there was an accident which happened yesterday. ನಾಳೆ 2 ದಿವಸಕ್ಕೆ
How many, how many stalls are there even now?
Exact numbers, my lord, they have not mentioned, but whoever is, my lord, on this,
The Suruni, that is pretty vague. It's neither here nor there.
they have, my lord, drawn a measure. They'll ask me kindly see that, my lord.
Paper mirror better, as a matter of fact, because there's no affidavit.
There is no affidavit. Because I received today morning, this report I received today morning in the court. Therefore,
Appoint a court commissioner at the cost of the corporation. If they were to give a report that there are still stalls in existence, somebody is in trouble.
I understand, my lord, I know the consequences. My lord, even I have told them that, my lord, they have to monitor that. I have told them.
If what he says is correct, if what he says is correct, there are still stalls there.
No, he says today they have come. I like to verify. Today afternoon, he says, my learned friend says, today afternoon they have come again. I really.
This will not work.
I don't think so, my lord, because not once. My lord, these officials have taken action, my lord, on several times.
They cannot come.
We have also returned to the police authorities.
You know, I know they cannot come there unless there is active connivance of the persons in charge on the ground.
My lord, may I just, you will ask me kindly direct. My lord, we have returned to the jurisdictional police. My lord, also to take action. May I request your lordships to direct the police authorities?
Pass on the buck to somebody.
No, not, in my lord, along with it.
Footpath belongs to you.
Yes, ma'am.
How can you allow somebody to occupy the footpath?
No, my lord, we are not allowing, my lord, we are clearing it, my lord. Suddenly, on the next start, after 2 days, my lord, again they are coming back. That is the difficulty. My lord.
What is your responsibility as the corporation?
No, we are supposed to do it.
Act
My lord.
sporadically
My lord,
whenever-
we are only seeking the cooperation, my lord, of the police authorities also.
Like the police saying, ತುಂಬಾ ಜನ ಕಳ್ಳರು ಇದ್ದಾರೆ, ಅವರಷ್ಟು ಬಂದು ಜೈಲೊಳಗೆ ಬರ್ಲಿ
ಅಲ್ಲ, ಆ ಥರ we,
What is it that you
my
are
lord,
saying?
for our action, my lord, I seek the cooperation of the police authorities, my lord, to, my lord, ensure that they don't come back again. We have returned, my lord, complaints to the police also. I can place it on record.
You, this again passing the buck won't do until you.
No, we will not, we will also, my lord, cooperate. There is no difficulty.
Not cooperation, it's your obligation.
Yes,
to
we
take care
will perform the obligation.
When you are acting as if superficially, ಏನೋ ನೀವು ಕೇಳ್ತಿದ್ರೆ ಅದಕ್ಕೆ ನಾವು
No,
ಮಾಡ್ತೇವೆ.
we will perform the obligation, my lord. Let the police help us for that.
Is it your case that they're not helping you?
Yes, my lord, we have written letters, my lord. They have not helped us. They have not helped us.
If they come back and say that, no, whenever they've called us, we have come.
Yes.
If you are going to play this game, I can also play this game.
No, I'm not playing. I'm sorry, my lord. I'm not playing anything.
Say your officers.
Yes.
I'll have this on Monday. I want an affidavit of the person in charge as to what is the actual position on the ground. Let it be known that I'll appoint a commissioner. If If that affidavit is doubted
Yes,
by the other side,
yes. Tuesday.
Tuesday.
Yes.
Memos are filed by- ನೀವು ಮೆಮೊ ಹಾಕ್ತೀರಾ ಏನ್ ಮಾಡ್ತೀರಾ ಹಾಕಿದಿರಾ
Memo ಹಾಕಿಲ್ಲ. ಇಲ್ಲ court ಅಲ್ಲಿ ಇದ್ದಾಗ ಸಿಕ್ತು. I can place it along with the memo, my lord, on Tuesday.
Council has filed a memo closing certain photographs. And Sri Subramani, also applying for the BVMP, has also put a major copy, certain documents and photographs. It contents that action has been taken to clear the footpath. So, ಯಾರ ಜಾಯಿಂಟ್ ಕಮಿಷನರ್ ಫೋಟೋ ಹಾಕ್ತೀರಾ?
Third respondent, my lord, is the executive. Joint commissioner is a party. I can ask him to.
The joint commissioner of the corporation, that is respond number
2, my lord.
2 na,
Yes.
is directed to file an affidavit indicating the action taken to remove the persons from who have occupied the footpath for vending. And he shall also state whether there are any vendors still operating on the footpath and what action he proposes to ensure that there's a permanent solution to the problem on at hand, released on Tuesday.
Yes. And that this order be uploaded, my lord. Okay, good, Lord.
Where is Mr. Rolla?
Monday, no.
Monday evening, 4:30 again. Monday. I think we can report that. Okay.
That's serial number 43, my lords. My lords, it's a matter, my lords, of I appear for the State Pollution Control Board. This is a matter, my lords had heard yesterday with regard to the crematorium being there.
Take it up.
You take it up now.
I'm taking up only two matters, yours and Chandrakant Patil's.
Grateful, my lords.
Serial number 39. That they deposited my share amount in OS instead of LAC.
Number 7.
ಏನಂತ?
Affidavit and a report.
ಏನಂತ?
ಅಲ್ಲ ಸರ್ಕಾರ ಕೇಳಿದ್ದು
Allocation memo ಕೊಟ್ಟ ಇದರಲ್ಲಿ.
Where is Banu Prakash?
39. ಔಟ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಔಟ್ ಡ್ಯೂ BMRCL ಕಡೆಯಿಂದ ಮತ್ತೆ NGF ಕಡೆಯಿಂದ ಡ್ಯೂ ಇದೆ ಅನ್ನೋದಕ್ಕೆ.
ನಿಮ್ಮಲ್ಲಿ ಇವಾಗ ಕೆಲಸ ಮಾಡ್ತೀರಾ ನೀವು?
Yes, my lord. I am respondent number 7, land acquisition officer.
You will furnish a copy to them.
Yes.
Furnish a copy, I have it on Tuesday.
Please,
Furnish a copy.
kindly taken now. They deposited, let they.
ನನಗೇನಾಗ್ತಿದೆ ಗೊತ್ತಾ ಶಿವಪ್ರಕಾಶ್, ಎಲ್ಲ ಬರೀ ಆರ್ಡರ್ಸ್ ಅಡ್ಮಿಷನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ರ. ನಾನು ಬಿ ಗ್ರೂಪ್ ಹಳೆದಕ್ಕೆ ಹೋಗಕ್ತಿಲ್ಲ, ಇಯರಿಂಗ್ ಹೋಗಕ್ಕಾಗ್ತಿಲ್ಲ. ಸರಿ, ನಾನ್ ಕಷ್ಟ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನಾನು ಬರೀ ಹೊಸ ಮ್ಯಾಟ್ರ್ ತಗೊಳ್ತಾ ಇದ್ದೀನಿ, ಹಳೆ ಮ್ಯಾಟ್ರ್ ಮುಟ್ತಾನೆ ಇಲ್ಲ ನಾನು.
My lord, this affidavit is taken on record.
ಸರ್ವೆ ಕಾಪಿ on them first.
Served, my lord.
ಕೊಟ್ರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ. ನಾನು ಕೊಟ್ಟಿದ್ದಾರೆ.
The council
Amount deposited ಮೇಲೆ
files and
maybe transfer to the my lord, any nationalized bank. My lord, since from 10 months, no interest.
taken on record. ಮಾಡ್ತೀನಿ ರೀ, ಟ್ಯೂಸ್ಡೇ ವೆಡ್ನೆಸ್ಡೇ ಹೋಗಿರ್ರಿ ದಯವಿಟ್ಟು.
Tuesday.
Wednesday. Wednesday.
That's 41, my lord.
Not make this submission. You are in the High Court. You want to say that you want to go to. No, if you.
That's 41, my lords. That's a
The respondent 4 number.
41 is further consideration PTCL matter, my lordships may remain, recollect, my lords.
I came on record.
Date ಕೊಡ್ತಾರೆ.
Please.
Serial number 39, my lord.
ಕೊಡ್ತಾರೆ.
My lord, 39, instead of 21, it may be taken 22, my lord.
ಯಾವ್ದು?
39, serial number 39. Instead of 21, 22, my lord, it may be taken.
39.
Oh, 39.
Just now they filed a memo calculation.
22nd.
22nd.
Serial number 43. Serial number 43.
Read it as.
Are there any regulations of yours,
Oh my God, they don't fall under, in place a memo on record. So my lords, the entire consent mechanism is regulated between red category, orange category and green category notes, where the consent mechanism would apply, where they have to take a consent from us either under the Air Act, Water Act, depending on the. There's a fourth category called white category melons, which melons does not require consent. In any of these four categories, melons, unfortunately, the crematorium as a activity is not mentioned. Melons. That's also because it cannot be constituted as a industrial activity. Now, melons, what we do is that melons.
So that letter that is given is wrong. It's based on the opinion of that particular officer. It's not with reference to any regulations or rules that you have framed for yourself.
Yes, melons, can I just place this so far as the. Sir.
Can I have a copy? Can I have a copy?
So, but your officer went on a big correspondence with the corporation advising them to shift the crematorium and that you would not grant them consent. On what basis?
In fact, I have paid 25,000 rupees to them.
When I'm asking them.
That's what has happened is the letter which my lords are referring to is at annexure AF, my lords, letter dated 26 March 2014. My lords, our time tanka, my lords, we were like trying to bring it under the consent mechanism. And thereafter, my lords, CPCB categorically made a statement that my lords, crematorium cannot basically excluded the activity of crematorium, my lords. Having said that, my lords, so far as this case is concerned, my lords, from 2013, BBMP has not been using that particular premises for electric cremation. Now, my lords, in fact, they have dismantled. My instructions are that, my lords, even today morning, we have photos to substantiate that as of today morning. It's locked insofar as the electric crematorium or cremation is concerned. Now, the burial ground, my lords, is not used by one community as such. It is being used by three different religions, my lords, people belonging to three different religious sects. Before even the developer purchased the land, BDA went ahead and started the entire construction by the petition started the construction. So that's my submission is that as of today, the law as it stands today, there's no consent mechanism. As of today,
I should impose cost on your officer for having written the letter and given them the impression that the installation was completely illegal and which would violate the pollution norms.
That's it. The letter dated 26 March 2014,
There are two letters, isn't it?
No, one inspection report.
There is an
There's
inspection.
one
The
inspection.
environment officer on the basis of his inspection wrote to the member secretary. Member secretary has issued the letter to this one.
There is an
BBM.
inspection report on 23/12/2013.
That's annexure AE, melons may turn to that annexure AE. In that melons, we have not said that melons that they have the they can go ahead with it. Melons may look at it. Melons, I would convince melons to say melons, the entire concept of melons, what is happening.
You should not give me an impression that you're dancing to the tune of a developer.
No, we are not melons. We are not melons. In fact,
I'm
melons,
getting that distinct impression, given the tone of the letter that is written there and the submission that you're now making.
that subsequently melons, subsequently also.
Annexure?
Annexure AE melons, it's an inspection melons.
Thereafter, there is one more letter, isn't it?
Melons, that letter melons is written to the commissioner at annexure AF.
Annexure?
AF at page 60 of my rejoinder.
And
the
my document does not have
43.1
Rejoinder.
rejoinder. 43.1.
the rejoinder statement, melons, annexure AF. Keep one more. Why are you keeping both?
Actually, that was issued on the complaint of residents, not on my letter. AE page 58 is the inspection report. There it refers to PIL petitioners. And
But
60 is the
sir, I think that only.
letter they wrote. to
They did. Let's may pass this, my lords, if my lords are.
Page 60, madam. AF. Page 60.
Can I pass this, my lords? if
That
my
was to the
lords-
commissioner, I said, yeah.
Yes, my lords.
This is on the basis of this inspection report of the environment officer.
Yes, my lords, which is dated, my lords, 23rd December 2013. And in that, my lords, we have clearly told that, my lords, that they could not have carried on this activity. My lords, having, my lords, I would only want to make one submission, my lords. It's not, I am trying to, even my officer, my lords, trying to get a solution. It's not a case of the petitioner, is that there was no such cremation activity qua the burial was not happening.
Read para 2 of your letter addressed to the commissioner.
The board has received complaint after the next paragraph. As
The first paragraph itself.
the board has received the complaint from public on the establishment of electric crematorium at survey number 7/2, Hegde Nagar, so and so, stating that construction work has already been taken up at the said site by BBMP, which is adjacent to residential areas and apartment.
Then.
That's as you already aware of Air Prevention and Control of Pollution Act 1981, which stipulates the prior consent of KSPCB is necessary for establishment of such units. Therefore, it is an obligation on the part of BBMP to obtain prior consent under both acts before starting the construction activities.
What basis was the statement made?
That's the statement was made, Malads, on the aspect that Malads, they should have got a consent from us. But Malads, as on that day, there was no such mechanism which existed in the board.
Is a deliberately false statement.
Malads, even otherwise, Malads,
And this is issued by no less an authority than the member secretary. It's not by
based on the report, Malads, based on the report,
even if that environmental officer had no knowledge of the law. The member
member
secretary
secretary should have it. That's, we are, Malads, if I may just submit in this fashion. Malads. The aspect about electric crematorium, Malads, qua the pollutants being released from their stack emission pipes was the issue, Malads. But otherwise, Malads, the developer or the petitioner here, Malads, is looking at a larger aspect of not having the crematorium or the burial ground itself. The entire claim on the petition is that, Malads, so the burial ground.
Then you must have taken a decision saying that around a residence, around a crematorium, around a burial ground, no activity of any kind. You grant consent for establishing the apartment, all that you do.
That's respectfully.
You allow this thing to happen, right?
Respectfully, Malads, so far as I am concerned.
You also are involved in grant of consent and granting it for the apartment complexes?
That's only in terms of setting up of STP. That's in there, the consent which we have granted.
So you as a pollution board,
yes,
you're of the view that there's pollution because of crematorium. You should refuse to grant permission for all the construction around the crematorium or around the burial ground.
That's prospectively.
There are, I think, about 10 or 15 crematoriums here in Bangalore. And if we have to accept your argument, then all the crematoriums will have to shut down.
That's insofar as the argument or the statement, Malads, which I'm making, that consent, my statement is that, Malads, consent is not required. But Malads, monitoring is not barred from our perspective. That is because, Malads, section 2A of the Air
Monitoring
Pollution
will
Act.
come in after the establishment, right?
Yes, yes.
If it can be established, there is pollution.
Yes, they have to establish that there is pollution to it. For that, Malads, we would, if any complaint is received, Malads, we would have, in any event, Malads, our vans would be going around the Bangalore city. They would monitor the air pollution level. And in case we get to know that, Malads, we would advise them or give them the remedial measures as to what could they be doing to ensure that, Malads, there is no pollution at all, or basically the smoke emitted should not be carrying any pollutants with them. Now, Malads, dehouse this letter, if I may submit. Pollution Control Board does not, or rather, Malads, grants permission so far as the four corners of their plot or their project is concerned and nothing beyond. We do not have any such, my lords, I can say that, my lords, before my lords, that we do not have any condition that, my lords, we should not be, there's no such, BBMP should clarify that, my lords, if there's an apartment which is coming up or an housing complex which is coming up next to a crematorium or burial ground, my lords, until and unless, my lords, they bring it to our knowledge that, in so and so aspect, there is a burial ground or there's an electric crematorium. And the permissions when we issued, my lords, was prior, it antedates even the starting of the construction of the electric crematorium. Now, my lords, on that day, we could not have reasonably anticipated that, my lords, BBMP would start electric crematorium. That is my number one submission. Number two, my lords, because these letters also, we would not have, we can only monitor them in terms of telling them how to go ahead with this particular crematorium activity and nothing beyond. And that, my lords, we keep doing it with multiple in different parts of Bangalore also, where we have issued, and in case we have understood that BBMP is not complying with it or not following it, we should show cause notice to them, calling up saying that why we should not initiate action against you, or why we can't file any complaint.
Want to Chamarajpet burial cemetery, the crematorium?
Yes. I have, my lords.
So if this argument of yours, this pious argument, sanctimonious argument, that you're doing a great job.
No, my lords. we are, for a moment, my lords, we are not taking any, we are not making anything that, my lords, we are doing a pious. We are just saying that, my lords, we do not control the construction of an electric crematorium in any event, whether in this presence of this letter or otherwise. The BBMP at the foresight my lords, should have gone ahead and probably, my lords, issued a public notice. My lords, we can only, my lords, I only submit, my lords, what is the solution forward, my lords, in not only in this matter, because we understand, my lords, as residents of Bangalore, because we have seen Wilson Garden, my lords, Wilson Garden crematorium till date, my lords, we have not received a single complaint. Like that, my lords, Harishchandra Ghat. Like that, my lords, even the crematorium near the Binnipet, where there are residential complexes. There are not in such a big complex. We are taking as and when we get to know that my lords, there's some kind of a pollution activity, or the crematorium is not working in the right fashion or the right manner in which ideally it should be working with, having scrubbers, making sure that, the entire furnace should be running between 800 degrees to 1200 degrees, so that, my lords, the components of hydrogen, oxygen, nitrogen, whatever is there, including, my lords, the 6 mg of mercury, which the petitioner is trying to say is causing, everything would be exhausted, my lords, if the body or the entire furnace could go at 1200 degrees. So we monitor this as a part of our duty. And, my lords, at no point, my lords, I'm trying to give an impression that we're doing some pious obligation. I'm sorry, my lords, if I've come across that way. My only request is that, my lords, my only submission is we are trying to do as much as possible in terms of this crematoriums, which, my lords, otherwise.
So you would be okay if I were to pass an order that you will monitor this, all the crematoriums regularly on a monthly basis, to ensure that they're being operated at a particular standards that you set.
Absolutely, my lords.
So
Lords, we are doing so. We are doing so, my lords. If we receive a complaint.
Complaint Allah. This is not a question of complaint.
Yes.
You know, this activity goes on a day-to-day basis.
Yes.
So monthly or whatever is feasible.
Yes.
You will review the air quality around that particular crematorium. And ensure that whatever is the apprehension of the petitioners or similar apprehensions are allayed, and so that this pollution is not there as far as they are concerned.
Absolutely.
We are ultimately saying that this causes health hazard to us. So you will file an affidavit indicating what steps you will take periodically to ensure that the crematorium functions within the permissible parameters.
That's the difficulty, my lords. We do not have a permissible parameters, my lords, except saying that air quality.
Whatever is,
that is the only thing, my lords.
I don't know about the technical.
No,
he said something about, you said that mercury would be there.
Yes, my lords.
How do you prevent any harmful pollutants to come out in this process of burning a body?
That is the only contention, my lords. They're only looking at the one component, my lords.
So you are the expert. You tell us how you will ensure that can be solved by the corporation.
Yes.
I'll put them on terms saying that they will obtain a certificate from you every week, every month, whatever. And you can also collect your money for doing that.
Please, my lords.
Put whatever sensors you want to, whatever you want to do. ensure that the residents are also not affected by this crematorium.
May I request, my lords, insofar as this is concerned, if my lords may give me about 2 weeks' time, and I'll tell you why. No, I'll tell you the reason, my lords. We would want to give my lords suggestions, my lords, which can be actually implementable than my lords going back and just filing an affidavit in a couple of days. My lords, I would want to take this matter to our technical advisory committee, my lords, and ensure that, my lords, it's shared by member secretary, because such mistakes should not happen.
I'll reserve this. You give me your affidavit. On that basis, I'll prepare an order.
Grateful, my lords.
May I make one submission? The learned friend may not be entirely right in saying that consent is not required, because industrial plant is defined under section 2K of the Air Pollution Act to mean any plant used for industrial or trade purposes and emitting or trade purposes and emitting any air pollutant into the atmosphere. Then air pollutant is also defined. Then my lord, section 21 says that subject to the provisions, no person shall without the previous consent of the state board establish or operate any industry in any industrial plant in any air pollution control area. Then what I gather is, my lords, of course, he is an expert. I cannot say that. The national policy has laid down certain norms regarding the air pollution levels, the emissions, and particularly, my lord, this what yesterday I read out a research paper, the nitric oxide, carbon monoxide, and carbon dioxide, I don't think is harmful to the human life. But carbon monoxide and nitric oxide, they are definitely let them come out with a proper affidavit is all the time. That is one thing.
That will take.
Just to clarify.
Second is, my lords, I only one submission. Yesterday I submitted about the extent of land in survey number 1999 and all that. I have filed an affidavit stating yesterday whatever I have stated. I have produced records to show that the extent is 99 acres and it is still 46 acres is available. ಅದಕ್ಕೆ ಎನ್ಕ್ಲೋಜರ್ಸ್ ಇರೋದೆಲ್ಲ ನಾನು ನಿನ್ನೆನೆ ಕೊಟ್ಟಿದ್ದೀನಿ ತಮಗೆ.
That was the exact difficulty, my lords. Crematorium cannot be assessed as an industrial activity.
Insofar as
And pollution control board was a party in the PIL.
Yes, we were. In fact, we were implemented only last year. I can say.
Illalla. In the PIL from which all this arose, you were a respondent number 4.
We stopped them.
May I make a submission? Insofar as today's affidavit, what learned senior counsel has produced before your lordships, to contend that in survey number 99, 87 acres of land ide anta heladakke, this is not rectified. Just now I received instructions. This RTC is not rectified. Lot ODs have happened. Omar extent is only 57. Adikke naan report kottidini. In fact, at page 14, my lords may kindly see of this RTC.
When did you file?
ಇವತ್ತೇನೋ ಫೈಲ್ ಮಾಡಿ ನನಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದಾರೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ.
ನೀವೇನ್ ಹಾಕಿದ್ರು?
ನಾನೇನು ಹಾಕಿಲ್ಲ. ನಾನು ಮೊನ್ನೆ ತಮ್ಗೆ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟೆ. ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ 57 ಎಕರೆ ಹೆಂಗೆ ಡಿವೈಡ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, ಹೆಂಗೆ ಅಲಾಟ್ ಆಗಿದೆ, ಇಂಟ್ರೆಸ್ಟ್ ಆಗಿದೆ,
80 ಚಿಲ್ಲರೆ ಇದೆ.
ಇವ್ರು 87 ಇದೆ ಅಂತ ಇವಾಗ ಇದು RTC ಕೊಡ್ತಾ ಇದ್ದಾರೆ. RTC 87, definitely, my lord, it says 87, but it is not rectified. ODs have already happened. My lord, page 14 may kindly be seen. 46 acres of land is Gomala Kallubande.
Want to file an affidavit? You file an affidavit in response to his.
Yes, I'll do that.
Order is reserved. The pollution control board as well as the BBMP. Pollution control board is directed to file an affidavit regarding the establishment of crematorium and the manner in which their performance are to be monitored. BBMP is also permitted to file an affidavit in response to the memo that is filed by the petitioners regarding the extent of land available in survey number 99.
Okay, so that's affidavit suggesting, my lords, the measures to be taken. That
You say whatever you want to say.
Order
I said establishment of crematorium and maintenance of standards there.
in the coming, not only this.
Whatever.
Generally,
If you give a general order, I'll issue direction to all of them. Because not only just this
No,
particular.
this
criminal-
method is not working only today.
It will be a problem that will be
Not working
recurring.
because of the intermodal grant
Yes,
by this
yes,
court.
I'm saying, in fact, they've dismantled everything.
No, no, no. It is
Except
not
the
dismantled.
stacks, pipes which are there. Today
But I
morning
did not
also.
appreciate the fact
It is
that
locked and kept and
your client was so over anxious to support without there being any basis. You basically, we rely upon you as the expert. If you address a letter at the level of member secretary about this, what is the impression that we carry? We accept your statement blindly.
That's why we.
in fact, they threaten us to initiate appropriate proceedings under the relevant law. Offense ಗೆ
Was not in.
criminal case ಆಗ್ತೀವಿ ಅಂತಾನು threaten ಮಾಡಿದ್ದಾರೆ letter ಅಲ್ಲಿ.
Now, Majads, if even one of our suggestions is going to be also, morning we were discussing, yesterday in the evening, that Majads, in case we find them not being compliant, Majads, we should be taking action in accordance either with Water Act, Majads, or Air Act, or we should go under the IPC for causing any other nuisance. So we
Whatever
have
you
to do
want,
that.
ultimately, all of you are working in public interest.
Absolutely.
They can't be saying, I'll work against public interest. But you seem to be threatening them, saying that I'll do this, I'll do that to them.
To get
That was
the work.
definitely not in good taste. And that they were not building a palatial bungalow for themselves. For establishing crematorium, you should at least aid them in coming to the right decision. You are threatening them and you're saying it is illegal, it is impermissible. Are you being pragmatic? What do you do with the dead? We don't have burial grounds for them. Then what do you want to do with them? Store them forever?
That's, I understand that. That's, we would rectify that.
So many religions have changed their customs also. Earlier they used to bury, now they want to.
But I would
Burn it.
suggest them to go to Chamarajpet and then look at what can be done there.
ಇದು ಅಷ್ಟೇ ಇಲ್ಲಿ
That's-
ಹೆಬ್ಬಾಳದಲ್ಲಿ
we
ಒಂದಿದೆ.
request that.
At any given point of time, there are about 12 or 13 bodies being burnt in the open. There's no nothing, whatever you call that, stacked something.
ಅಲ್ಲಿ
Nothing is there.
ಚಿಮ್ನಿನೂ ಇಲ್ಲ.
ಅಲ್ಲೇನು ಇಲ್ಲ.
It goes
ಅದೇ-
directly into the houses which are virtually built on the compound of that Chamarajpet burial ground.
ಇಲ್ಲ ಹೈ ಚಿಮ್ನೀಸ್ ಹಾಕಿದ್ದಾರೆ.
ಬರೀ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Sheet ಹಾಕ್ಬಿಟ್ಟಿದೆ.
Sheet ಆಗ್ಬಿಟ್ಟಿದೆ. I mean, ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ರೆ,
That's it.
if you are that interested in the quality of air in Bangalore, you should take steps voluntarily without waiting for an order from the court or a complaint from somebody. All of us have gone there and none of us do anything about it. And so addressing such lovely letters to the commissioner, I think it's better that
That's where take some ground action.
Number 76.
So my only request is that, that's within, I may need at least 2 weeks time to,
I'll wait for 2 weeks.
yes, Majads.
Chandrakant Party.
Appearing for this petition.
That's, the other side, directed the EO to be present. She's present, I just.
Please ask her to take steps in Chamarajpet. That is beyond the scope of this court, but I'm requesting her to go do something.
No, that's why I'm taking it to the member secretary level so that the entire Karnataka can be covered if we can do so.
Yes.
I am for the petitioner. Lordship may kindly see the evidence. ನಾನೊಂದು evidence ಕೊಟ್ಟಿದ್ದೀನಿ. Previous occasion. The matter was heard before the other bench of this court. ಅಲ್ಲ ಅದಲ್ಲ, ಇನ್ನೊಂದು ನಾನು ಈ ತರ ಕಂಪೈಲೇಷನ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
Exhibit ಏನು?
ಅಲ್ಲ ಎಕ್ಸಿಬಿಟ್ ಮಿಲೋಡ್ T1 which is runs from ಮಿಲೋಡ್.
ಚುನಾವಣೆ ಸಭೆ ತಿಳುವಳಿಕೆ ಅಂತ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
ಹೌದು, ಅದು
1823.
ಪೇಜ್ ನಂಬರ್ 13 ಇಂದ. ಅಲ್ಲ, ನಮ್ಮ ಎವಿಡೆನ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದು. ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ. ಎಕ್ಸಿಬಿಟ್ PW1 ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 13 ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ಫಾರ್ ಎ ಮೂಮೆಂಟ್.
13.
ನಾವು ಅವ್ರಿಗೆ ಕ್ರಾಸ್ ಮಾಡಿದ್ವಿ ಬಾಟಮ್ ಅಲ್ಲಿ. ಚುನಾವಣೆ ಮಾಡುವುದಕ್ಕಿಂತ ಮೊದಲು ನನಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದರು ಎಂದರೆ ಸರಿ. ನಿಯಮಗಳಂತೆ ಅಭ್ಯರ್ಥಿಯ ಹೆಸರಿನ ಮುಂದೆ ಮತದ ಚಿಹ್ನೆ ಮಾಡಬೇಕೆಂದು ನಿಯಮ ಇದೆ ಎಂದರೆ ಸರಿ. ಚುನಾವಣಾಧಿಕಾರಿಗಳು ಕೊಟ್ಟ ಚಿಹ್ನೆಯಿಂದಲೇ ನಾನು ನನ್ನ ಮತವನ್ನು ಚಲಾಯಿಸಿದೆ. ಅದೇ ಸಲಕರಣೆಯಿಂದ ಎಲ್ಲಾ ಸದಸ್ಯರು ತಮ್ಮ ಮತವನ್ನು ಚಲಾಯಿಸಿದರು. ನಿಶಾನೆ R2 ರಲ್ಲಿ ಚಿಹ್ನೆ ಅಭ್ಯರ್ಥಿಯ ಹೆಸರಿನ ಮುಂದೆ ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ಹೆಸರಿನ ಮುಂದೆ ಚಿಹ್ನೆ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಚುನಾವಣಾಧಿಕಾರಿಗಳು ನಿಯಮಗಳಂತೆ ಅದನ್ನು ಅನೂರ್ಜಿತ ಮತ ಎಂದು ಘೋಷಿಸಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ಚುನಾವಣಾಧಿಕಾರಿ ಯಾವುದೇ ತಪ್ಪು ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ.
This is the opinion of the witness.
This is, we cross the respondent number 3.
Respondent number 3 does not know where the seal is put.
Respondent
Yes, he puts his seal.
ಅಲ್ಲ ಇವ್ರು ಬಂದು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ಬಂದು ಡಿಫಿಟೆಡ್ ಕ್ಯಾಂಡಿಡೇಟ್.
ಅಲ್ಲ, he is talking about his casting of the vote.
ಹೌದು.
ಅವನದಲ್ಲಿ ಏನ್ ತಪ್ಪು ಮಾಡಿಲ್ವಲ್ಲ.
ಅಲ್ಲ ಅವನದ್ರಲ್ಲ ತಪ್ಪು. ಇದ್ರಲ್ಲಿ ಏನಂತ ಅಂದ್ರೆ,
You don't know which member has made that mistake.
ಅಲ್ಲ ಹಂಗಲ್ಲ, ನಾನು ನನ್ನ ಮತವನ್ನು ಚಲಾಯಿಸಿದೆ.
ಗೊತ್ತಾ ಯಾರು ಮಾಡಿರೋದಂತ? ಗೊತ್ತಿರುತ್ತಲ್ಲ, ಅನ್ಅಫಿಷಿಯಲಿ ಗೊತ್ತಿರುತ್ತಲ್ಲ ಯಾರು ಅಂತ. ಎಸ್,
ನಿಯಮಗಳಂತೆ ಅಭ್ಯರ್ಥಿ ಹೆಸರಿನ ಮುಂದೆ ಮತ ಚಿಹ್ನೆ ಮಾಡಬೇಕೆಂದು ನಿಯಮ ಇದ್ದರೆ ಎಂದರೆ ಸರಿ. ಚುನಾವಣಾಧಿಕಾರಿ ಕೊಟ್ಟ ಚಿಹ್ನೆಯಿಂದಲೇ ನಾನು ನನ್ನ ಮತವನ್ನು ಚಲಾಯಿಸಿದೆ. ಅವ್ರದನ್ನ ಹೇಳಿದ್ರು. ಅದೇ ಸಲಕರಣೆಯಿಂದ ಎಲ್ಲಾ ಸದಸ್ಯರು ತಮ್ಮ ಮತವನ್ನು.
ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತು?
ಅಲ್ಲ, ಅವ್ರು ಅಲ್ಲೇ ಇರ್ತಾರೆ.
ಇಟ್ ಇಸ್ ಎ ಸೀಕ್ರೆಟ್ ಬ್ಯಾಲೆಟ್.
ಅಲ್ಲ, ಸೀಕ್ರೆಟ್ ಬ್ಯಾಲೆಟ್ ಅಂತಂದ್ರೆ ಒಂದು ರೂಮ್ ಅಲ್ಲಿ ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷರು.
ಸರಿ, how will you know where person is voting or not? It's a secret ballot. Whatever he says.
ನಾವು ವೋಟ್ ಆಗಕ್ಕೆ ವಿ ಎಂಟರ್ ದಿ ಪ್ರಿಮಿಸಸ್. ಪ್ರಿಮಿಸಸ್ ಹೋದಾಗ ಅಲ್ಲ, ಪ್ರಿಮಿಸಸ್ ಎಂಟರ್ ಆದಾಗ ನಮ್ಗೆ ಬ್ಯಾಲೆಟ್ ಪೇಪರ್ ಅಲಾಂಗ್ ವಿತ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಕೊಡ್ತಾರೆ. ಫಸ್ಟ್ ಏನ್ ಮಾಡ್ತೀವಿ, ಹೋದ ತಕ್ಷಣ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಲ್ಲ ನೋಡಿ ಸಿಗ್ನೇಚರ್ ಮಾಡಿಸ್ಕೊಡ್ತಾರೆ. ಸಿಗ್ನೇಚರ್ ಮಾಡಿಸ್ಕೊಂಡಾದ್ಮೇಲೆ ನಮಗೊಂದು ಮಾರ್ಕ್ ಹಾಕ್ತಾರೆ. ಮಾರ್ಕ್ ಹಾಕಿದ್ಮೇಲೆ ನಮಗೊಂದು ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಕೊಡ್ತಾರೆ. ಇದ್ರಲ್ಲಿ ನೀವು ವೋಟ್ ಹಾಕ್ಬೇಕು ಅಂತೇಳಿ. ಹಂಗ ಆ ವೋಟ್ ಅನ್ನ ನಮ್ದೊಂದು ಸೀಕ್ರೆಟ್ ಬಾಕ್ಸ್ ಇರೋ ಒಂದು ಕವರ್ಡ್ ಸ್ಪೇಸ್ ಇರುತ್ತೆ. ಅಲ್ಲಿಗೆ ಹೋಗಿ ನಾವು ಅದೇ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಇಂದ ವೋಟ್ ಹಾಕಿದ್ ನಾನು ಹಾಕಿದ್ದೀನಿ, ಉಳಿದವ್ರು ಎಲ್ಲರೂ ಕೂಡ ಅದೇ ಸಲಕರಣೆ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಅನ್ನು ಉಪಯೋಗಿಸಿ ವೋಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ. ನೆಕ್ಸ್ಟ್, ನಿಶಾನೆ R2 ರಲ್ಲಿ ಚಿಹ್ನೆ ಅಭ್ಯರ್ಥಿಯ ಹೆಸರಿನ ಮುಂದೆ ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ಅವ್ರದ್ದು ಏನು ಎಕ್ಸಿಬಿಟ್ P2 ಏನಿದೆಯಲ್ಲ, ಇದ್ರಲ್ಲಿ ಅಧ್ಯಕ್ಷರ ಚುನಾವಣೆ 2013 ಕ್ರಮ ಸಂಖ್ಯೆ ಅಭ್ಯರ್ಥಿ ಹೆಸರು ಮತದಾರನು ಹಾಕುವ ಗುರುತು ಅಂದ್ರೆ ಇಲ್ಲಿ ಇನ್ ಫ್ರಂಟ್ ಆಫ್ ದಿ ಅಂದ್ರೆ ಹೆಸರಿನ ಮುಂಭಾಗದಲ್ಲಿ ಅಂತ ಹೇಳಿ. ಅದಕ್ಕೆ ಹೆಸರಿನ ಮುಂದೆ ಚಿಹ್ನೆ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಚುನಾವಣಾಧಿಕಾರಿಗಳು ನಿಯಮಗಳಂತೆ ಅದನ್ನು ಅನೂರ್ಜಿತ ಮತ ಎಂದು ಘೋಷಿಸಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ನೌ ಮೈ ಲಾರ್ಡ್, ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಮೈ ಲಾರ್ಡ್ ರೂಲ್ಸ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂಡ್ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್. ನಾನು ಇದನ್ನು ಸೀನಿಯರ್ಗೂ ಕೇಳಿದೆ. ಜನರಲ್ ಎಲೆಕ್ಷನ್ಗೆ ಅದು ಬೇರೆ ಬರುತ್ತೆ. ಈ ಎಲೆಕ್ಷನ್ ಗಳಿಗೆ ಮಾತ್ರ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂಡ್ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್
we are bound by these rules only.
ಪ್ಲೀಸ್ ಇದರಲ್ಲಿ ಕರ್ನಾಟಕ ಪಂಚಾಯತ್ ರಾಜ್ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷರು ಚುನಾವಣೆ ನಿಯಮ 1995 ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 731 ಅನ್ಸುತ್ತೆ. ರೂಲ್ 8(9) ಅಲ್ಲಿ ಮತಪತ್ರವನ್ನು ಸ್ವೀಕರಿಸಿದ ಮೇಲೆ ಸದಸ್ಯನು ಮತಪೆಟ್ಟಿಗೆಯನ್ನಿಟ್ಟಿರುವ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ಮತ್ತು ಅವನು ಯಾರಿಗೆ ಮತ ನೀಡಲು ಇಚ್ಛಿಸುತ್ತಾನೋ ಅಂತಹ ಅಭ್ಯರ್ಥಿಯ ಹೆಸರಿನ ಮುಂದೆ ಕ್ರಾಸ್ ಮಾಡಿ ಮತ ನೀಡಿರುವುದರ ಗುರುತು ಕಾಣದಂತೆ ಮತಪತ್ರವನ್ನು ಮಡಿಸಿ ಸಭೆ ನಡೆಯುವ ಸ್ಥಳದಲ್ಲಿ ಈ ಉದ್ದೇಶಕ್ಕಾಗಿಯೇ ಇಟ್ಟಿರುವ ಮತಪೆಟ್ಟಿಗೆಯಲ್ಲಿ ಹಾಕುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ಫಸ್ಟ್ ಪಾರ್ಟ್. ಫಸ್ಟ್ ಪಾರ್ಟ್ is not complied.
Correct. So we have to come back to the second part to examine whether a violation of the first part renders the vote invalid.
ಫಸ್ಟ್ ಪಾರ್ಟ್ ಅಲ್ಲಿ ಹೆಸರಿನ ಮುಂಭಾಗದಲ್ಲಿ ವೋಟ್ ಇರಬೇಕು.
So if that is violated, there must be a consequence mentioned in the second part of the
ಸೆಕೆಂಡ್ ಪಾರ್ಟ್ ಅಲ್ಲಿ ಅವರು ಯಾವುದೇ ಸಿಗ್ನೇಚರ್ ಹಾಕಿಲ್ಲ ಅದನ್ನು ಓದ್ಬಿಡ್ತೀನಿ. ಮತದಾರನು ಮತಪತ್ರಕ್ಕೆ ಸಹಿ ಮಾಡತಕ್ಕದ್ದಲ್ಲ ಅಥವಾ ಆತನ ಗುರುತನ್ನು ತಿಳಿಯಪಡಿಸಬಹುದಾದಂತೆ ಯಾವುದೇ ಇತರ ರೀತಿಯಲ್ಲಿ ಗುರುತುಗಳನ್ನು ಮಾಡತಕ್ಕದ್ದಲ್ಲ.
This is the bar.
ಹೌದು.
You will not make any entry.
Yes.
Which indicates your identity.
ಹೌದು. ನೀವು
now next
ಸ್ಪೆಸಿಫೈಡ್ ಪ್ಲೇಸ್ ಎಲ್ಲಿ ಬಿಟ್ಟು
ಅದೆಲ್ಲ ನೀವು ಸೇರಿಸ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ನಾನು
ಸೇರಿಸಿಕೊಳ್ಳೋದು. ಮತದಾರನು ಮತಪತ್ರಕ್ಕೆ ಸಹಿ ಮಾಡತಕ್ಕದ್ದಲ್ಲ ಒಂದು ಬಾರ್.
ಹೌದು.
ಅಥವಾ ಆತನ ಗುರುತನ್ನು ತಿಳಿಯಪಡಿಸಬಹುದಂತೆ ಯಾವುದೇ ಇತರ ಇದನ್ನು ಗುರುತನ್ನು ಮಾಡತಕ್ಕದಲ್ಲ.
ಹೌದು.
This is a prohibition for the member that you shall not do anything to indicate your identity.
Please.
Now see the third part.
ಹಾಗೆ ಸಹಿ ಮಾಡಿದ ಅಥವಾ ಗುರುತು ಮಾಡಿದ ಅಥವಾ ಒಬ್ಬ ವ್ಯಕ್ತಿಗಿಂತ ಹೆಚ್ಚಿಗೆ ಹೆಸರುಗಳ ಮುಂದೆ ಗುರುತುಗಳಿದ್ದರೆ ಅಂತಹ ಮತಪತ್ರಗಳು ಅಸಿಂಧುವಾಗತಕ್ಕದ್ದು.
Two things will may render the vote invalid.
ಹೌದು.
One is if he indicates his identity or if he votes for more than one person.
ಪ್ಲೀಸ್. ಅಥವಾ ಸಿಗ್ನೇಚರ್ ಇದ್ರೆ.
They could have, the rule making authority could have said, whenever the symbol is affixed in a place other than the earmarked place, the vote will also be rendered invalid.
ಹೌದು.
It could have said that, right?
ಹೌದು. Kindly come to my lord. Karnataka Panchayat Raj Conduct of Election Rules 1993, Forum number 24.
How is it relevant here?
ಅಲ್ಲ, ನನ್ನ ಇಲ್ಲಿ established that this is with respect to the panchayats only. ಅದು
ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷ ಸ್ಪೆಸಿಫಿಕ್ ರೂಲ್ಸ್ ಇದ್ದಾಗ why should we look at the
ನಾನು ಅದನ್ನ ಸ್ವಲ್ಪ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಅದನ್ನ. ಐ ಥಿಂಕ್ ಆ ಬುಕ್ ಅಲ್ಲಿ 378 ಅನ್ಸುತ್ತೆ ಪೇಜ್ ನಂಬರ್ಸ್. ಫಾರಂ ನಂಬರ್ 24. Conduct of Election Rules 1993. ನನ್
ಯಾವ ವರ್ಷದ್ದು?
1993 ನಾನು ತಕ್ಕೊಡ್ತೀನಿ. Page number 570. Forum number 24.
Number?
Forum number 24.
Yes.
Instruction for the guidance of electors.
Hmm.
Election to the
What is rule 45?
Rule 45, my lord.
This is for issue of postal ballot paper.
Issue of postal ballot papers.
How can you look at this?
ಅಲ್ಲ, ನಾನು ಅದ್ರಲ್ಲಿ ತೋರಿಸ್ಬಿಡ್ತೀನಿ. Election to the Grama Panchayat, Taluk Panchayat, Zilla Panchayat from constituencies. The person whose names are printed on the ballot paper sent herewith are candidates at the above election. If you desire to vote, you should record your vote in accordance with the direction given in part 1 below, and then follow the instruction detailed in part 2. Part 1 nalli direction to the electors. The number of members to be elected is, you have only so and so votes. Third one, you must not vote for more than so and so candidates. If you do so, your ballot paper will be rejected. Fourth point is very important. Record the vote by placing clearly a mark opposite the name of the candidate to whom you wish to give that vote. It means, my lord, ಇಲ್ಲ ಹಂಗ್ ಬರೋದಿಲ್ಲ. ಏನಂದ್ರೆ ತಾವು ಬ್ಯಾಲೆಟ್ ಪೇಪರ್ ಅಲ್ಲಿ
24 will be applicable only to a postal ballot. So you can't borrow this rule to say that this has to be followed in respect of
how the legislatures, my lord, design these rules. ಇದರಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ, ಅಭ್ಯರ್ಥಿ ಹೆಸರು, ಮತದಾರನು ಹಾಕುವ ಗುರುತು. ಮತದಾರನು ಹಾಕುವ ಗುರುತು ಅಂದ್ರೆ ದಿಸ್ ಇಸ್ ಅ ಸ್ಪೆಸಿಫೈಡ್ ಪ್ಲೇಸ್.
ಅದಕ್ಕೆ ಹೇಳಿದ the second part indicated that if you vote in any other place other than the specified place, it will be rejected ಅಂತ ಬರ್ದಿದ್ರೆ ಈ ರೂಲ್ ಅಲ್ಲಿ ನೀವು ಓದ್ತಿರೋ ರೂಲ್ 38 ಅಲ್ಲಿ you have a wonderful case. If that is not there, that is a problem. If that particular, see, they were aware. They could have, they say if you vote for more than one candidate, it will be invalid.
ಆ ಗೈಡ್ಲೈನ್ಸ್ ಅಲ್ಲಿ kindly see, my lord.
Guidelines ಬಿಡಿ, ಅದು that is not applicable.
ಅಲ್ಲ,
I understand your anxiety. ಈ ತರ ಸೋಲೋದು ತುಂಬಾ ಬೇಜಾರಾಗಿ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಹಂಗಲ್ಲ, ಆ ಗೈಡ್ಲೈನ್ಸ್ ಅಲ್ಲಿ ಅಕಸ್ಮಾತ್ ಕಣ್ ಕಾಣ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ, ಬ್ಲೈಂಡ್ನೆಸ್ ಇದ್ರೆ, ಇಲ್ಲಿಟ್ರೇಟ್ಸ್ ಇದ್ರೆ, ಅವರಿಗೆ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಯಾರಿಗೆ ಅವ್ರು ವೋಟ್ ಹಾಕ್ಬೇಕು ಅಂತಾರೋ ಅವ್ರು ಅಲ್ಲಿಗೆ ಕರ್ಕೊಂಡೋಗಿ ವೋಟ್ ಹಾಕ್ಸ್ಬೇಕು. Ignorance of law is no excuse. ಅದು kindly see that rule, my lord. Kindly see annexure B, page number 18. Annexure B, page number 18. ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 19 ಅಲ್ಲಿ ಎಚ್
Yes.
ಮತದಾರನು ಅನಕ್ಷರಸ್ಥನಾಗಿದ್ದರೆ ಅಥವಾ ಕುರುಡನಾಗಿದ್ದು ಮತಪತ್ರದ ಮೇಲೆ ಕ್ರಾಸ್ ಮಾಡಲು ಸಾಧ್ಯವಾಗದಿದ್ದರೆ ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿಯು ಮತದಾರದ ಇಚ್ಛೆಗನುಸಾರ ಮತಪತ್ರದ ಮೇಲೆ ಮತವನ್ನು ದಾಖಲು ಮಾಡತಕ್ಕದ್ದು.
ಸೊ ಇದ್ರನ್ನ ಲೆಕ್ಕ ಹಾಕೊಂಡ್ಬಿಟ್ರೆ ಮತಪತ್ರದ ಮೇಲೆ ಮತವನ್ನು ದಾಖಲು ಎಲ್ಲಿ ಅಂತ ಹೆಸರು ಮುಂಭಾಗ ಹಿಂಭಾಗ
ಅಲ್ಲ, ಅದನ್ನ ಮೇಲ್ ಹೇಳಿದ್ರು, ಅದನ್ನ ಜೀನಲ್ಲಿ ಹೇಳಿದ್ರು, ಅದನ್ನ ಜೀನಲ್ಲಿ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಇಫ್ ಈಸ್ ಎ ಬ್ಲೈಂಡ್, ಇಫ್ ಈಸ್ ಅನ್ ಇಲ್ಲಿಟ್ರೇಟ್, ಅವಾಗ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್.
Either way, Chandrakant, you got elected by luck. It was a toss, draw of lots. That is all. Suppose he had won on the draw of lots, this argument of yours would disappear. Isn't it?
He has not raised any objection at the time of election also.
Maybe so. Suppose,
Which is all, my lord, in the evidence.
Suppose the draw of lots was in his favor. Let's assume he had not challenged the election. And 4-4, one was invalid. He did not challenge it. The toss was in his favor. You were out.
ಅಲ್ಲ, ಲಾಟ್ರಿ ಮಾಡ್ಬೇಕಷ್ಟು.
ಲಾಟ್ರಿಲಿ ತನಕ ಗೆದ್ದಿದ್ದು ನೀವು.
ಹೌದು.
ಲಾಟ್ರಿ ಅವ್ರು ಗೆದ್ದಿದ್ರೆ ಮುಗಿತಲ್ಲ ನಿಮ್ದೇನು ಅಂತದೇನು.
ಅಲ್ಲ,
ಪ್ಯೂರ್ ಲಕ್ ನಿಮ್ದು. ಅವ್ರು
this is all election petitions. My lordship is very well known, my lord. All election petitions on technical grounds. ಅದು ನಾನು.
This is not a technicality which would vitiate the elections, is what I am thinking.
ಅವ್ರದ್ದು PW1 ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 9 ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೂಡ ನಾವು ಮಾಡಿದೀವಿ.
Page number
9. 19/6/2024.
Yes.
ನಮ್ಮ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯಲ್ಲಿ 9 ಜನ ಸದಸ್ಯರಿದ್ದಾರೆ. ಅವರ ಎಲ್ಲಾ ಪರಿಚಯ ನನಗೆ ಇದೆ. 11ನೇ ಎದುರುದಾರರು ಅಧ್ಯಕ್ಷರನ್ನು ಆಯ್ಕೆ ಮಾಡಲು ಚುನಾವಣಾಧಿಕಾರಿಯಾಗಿ ಆಯ್ಕೆಯಾಗಿದ್ದರು. ದಿನಾಂಕ 14/8/2023 2ನೇ ಅವಧಿಗೆ ಅಧ್ಯಕ್ಷರ ಚುನಾವಣೆಗೆಂದು ಸರ್ಕಾರವು ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿದ್ದರು. 11ನೇ ಎದುರುದಾರರು ಚುನಾವಣಾಧಿಕಾರಿಗಳು ಚುನಾವಣಾಧಿಕಾರಿಯನ್ನಾಗಿ ನೇಮಕ ಮಾಡಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. 11ನೇ ಎದುರುದಾರರ ಚುನಾವಣೆ ಮಾಡುವ ಬಗ್ಗೆ ನನಗೆ ಒಂದು ಪೂರ್ವಭಾವಿ ನೋಟಿಸ್ ಅನ್ನು ಕೊಟ್ಟಿದ್ದರು ಎಂದರೆ ಸರಿ. ಅದೇ ರೀತಿ ನಮ್ಮ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಆಯ್ಕೆಯಾದ ಎಲ್ಲ ಸದಸ್ಯರಿಗೆ ಚುನಾವಣಾಧಿಕಾರಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಿಶಾನೆ P1 ಬರೆದಿರುವ ಅಂಶಗಳನ್ನು ನನಗೆ ಕೊಟ್ಟ ನೋಟಿಸಿನಲ್ಲಿ ಚುನಾವಣಾಧಿಕಾರಿ ಹೇಳಿದ್ದರು ಎಂದರೆ ಸರಿ. ನಿಶಾನೆ P1 ಕಾಣಿಸಿರುವ ವೇಳಾಪಟ್ಟಿ ಪ್ರಕಾರ ಚುನಾವಣಾಧಿಕಾರಿ ಚುನಾವಣೆಯನ್ನು ನಡೆಸಿದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ದಿನಾಂಕ 14/8/2023 11ನೇ ಎದುರುದಾರರು ನಮ್ಮ ಗ್ರಾಮಕ್ಕೆ ಬೆಳಿಗ್ಗೆ 10 ಗಂಟೆಗೆ ಬಂದರು. 11ನೇ ಎದುರುದಾರರ ಜೊತೆ ಅವರ ಕಾರ್ ಚಾಲಕ ಮಾತ್ರ ಬಂದಿದ್ದರು. ಸದರಿ ಕಾರ್ ಇಲಾಖಾ ಜೀಪ್ ಆಗಿತ್ತು. ಚುನಾವಣೆಯು ಚುನಾವಣಾ ವೇಳಾಪಟ್ಟಿ ಪ್ರಕಾರ ಮಾಡುತ್ತಿಲ್ಲವೆಂದು 11ನೇ ಎದುರುದಾರಿಗೆ ನಾನು ಮೌಖಿಕವಾಗಿ ಹೇಳಿದೆ. ಲಿಖಿತ ರೂಪದಲ್ಲಿ ನಾನು ಯಾವುದೇ ದೂರು ಕೊಟ್ಟಿಲ್ಲ. ನಾನು ಮತ್ತು ನನ್ನ ಲಿಂಗರಾಜ್ ತಕರಾರನ್ನು ಸಲ್ಲಿಸಿದೆವು. ಬರವಣಿಗೆಯಲ್ಲಿ ತಕರಾರನ್ನು ಕೊಡಲು ನನಗೆ ತೊಂದರೆ ಇರಲಿಲ್ಲ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ಚುನಾವಣಾಧಿಕಾರಿ ನಮ್ಮ ಮತವನ್ನು ಕೇಳಲೇ ಇಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ಪಟ್ಟಿಗೆ ಸರಿಯಾಗಿ ನೀವು ಚುನಾವಣೆ ಮಾಡುತ್ತಿಲ್ಲವೆಂದು ನಾನು ನನ್ನ ನಾಮಪತ್ರವನ್ನು ಸಲ್ಲಿಸದೆ ಹಿಂದೆ ಹೋಗಲಿಲ್ಲ. ನಾನು ಅಧ್ಯಕ್ಷರ ಹುದ್ದೆಗೆ ಬೆಳಿಗ್ಗೆ 11:30 ಗಂಟೆಗೆ ನನ್ನ ನಾಮಪತ್ರವನ್ನು ಸಲ್ಲಿಸಿದ್ದೆ. ಅಧ್ಯಕ್ಷರ ಸ್ಥಾನಕ್ಕೆ ನಾನು ಮಂಚಪ್ಪ ಮತ್ತು ಲಿಂಗರಾಜ್ ಸಲ್ಲಿಸಿದ್ದೆವು. ಮೊದಲು 3ನೇ ಎದುರುದಾರರು ತಮ್ಮ ನಾಮಪತ್ರವನ್ನು ಸಲ್ಲಿಸಿದರು. ನಂತರ ನಾನು ಮತ್ತು ಲಿಂಗರಾಜ್ ನಾಮಪತ್ರವನ್ನು ಸಲ್ಲಿಸಿದೆವು. ನಂತರ ಚುನಾವಣಾಧಿಕಾರಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಸದಸ್ಯರನ್ನು ಕೂರಿಸಿಕೊಂಡು ಈ ಸಭೆ ಮಾಡಿದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಸಭೆಯಲ್ಲಿ ನಿಶಾನೆ P1 ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಓದಿ ಹೇಳಿದ್ದರು ಎಂದರೆ ಸಾಕ್ಷಿಯು ಸಭೆ ಮಾಡಲಿಲ್ಲ ಮತ್ತು ಓದಿ ಹೇಳಲಿಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ಸಭೆ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಎಲೆಕ್ಷನ್ನೇ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ನನಗೆ ಚುನಾವಣಾಧಿಕಾರಿಯವರು ಕೊಟ್ಟ ನೋಟಿಸ್ ಅನ್ನು ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. ನಾನು PUC ವರೆಗೆ ಓದಿದ್ದೇನೆ. ನಾನು ನೋಟಿಸಿನಲ್ಲಿರುವ ಸಂಗತಿಗಳನ್ನು ಓದಿದ್ದೇನೆ. ನಿಶಾನೆ ಪಿ 1ರಲ್ಲಿ ಬರೆದಿರುವ ನಿಯಮ 5G ಮತ್ತು 6 ಮತ್ತು 9, 8ರ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿದೆ. ನನ್ನ ಅರ್ಜಿಯಲ್ಲಿ ಅವುಗಳ ಬಗ್ಗೆ ನಾನು ಹೇಳಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಿಶಾನೆ ಪಿ 1 ನನ್ನ ಅರ್ಜಿಯಲ್ಲಿ ಅವುಗಳ ಬಗ್ಗೆ ನಾನು ಹೇಳಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಿಶಾನೆ 1ರಲ್ಲಿರುವ ಸಂಗತಿಗಳು ಚುನಾವಣಾಧಿಕಾರಿ 11ನೇ ಎದುರುದಾರರು ಓದಿ ಸದಸ್ಯರಿಗೆ ಹೇಳಿ ನಂತರ ಚುನಾವಣಾಧಿಕಾರಿಯನ್ನು ಮಾಡಿದರು ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸಭೆ ನಡೆಸಿದ ಬಗ್ಗೆ 11ನೇ ಎದುರುದಾರರು ಎಲ್ಲಾ ಸದಸ್ಯರ ಸಹಿಗಳನ್ನು ನಿಶಾನೆ 3ರಲ್ಲಿ ಪಡೆದಿದ್ದಾರೆ ಎಂದರೆ ಸಾಕ್ಷಿ ಸಭೆ ನಡೆಸಲು ಮೊದಲೇ ಪಡೆದಿದ್ದರು ಎನ್ನುತ್ತಾರೆ. ನಿಶಾನೆ 3ರಲ್ಲಿ ನನ್ನ ಹಾಗೂ ಉಳಿದ ಸದಸ್ಯರ ಸಹಿಗಳಿವೆ. ಸಮಯ ಮಧ್ಯಾಹ್ನ 1ರಿಂದ 1:15ರವರೆಗೆ ನಾಮಪತ್ರಗಳನ್ನು ಪರಿಶೀಲಿಸಿದರು ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಾನು ಲಿಂಗರಾಜ್ ಅವರ ಹಾಗೂ 3ನೇ ಎದುರುದಾರ ನಾಮಪತ್ರಗಳು ಸರಿ ಇದ್ದ ಕಾರಣ ನನ್ನ ಲಿಂಗರಾಜ್ ಅವರ ಹಾಗೂ 3ನೇ ಎದುರುದಾರ ನಾಮಪತ್ರಗಳು ಸರಿ ಇದ್ದ ಕಾರಣ ಅವುಗಳನ್ನು ಅಧ್ಯಕ್ಷರೇ ಅಂಗೀಕರಿಸಿದ್ದಾರೆ ಎಂದರೆ ಸಾಕ್ಷಿ ಅವುಗಳನ್ನು ಅರ್ಜಿಗಳನ್ನು ಸ್ವೀಕರಿಸಿದರು ಆದರೆ ಅವುಗಳನ್ನು ಪರಿಶೀಲಿಸಲಿಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ಪರಿಶೀಲಿಸಿ ಅಂಗೀಕರಿಸಿರುವುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸಹ 11ನೇ ಎದುರುದಾರರ ಮೇಲೆ ಸುಳ್ಳು ಸಾಕ್ಷಿ ನುಡಿಯುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಜೆಎಮ್ಮನವರು ವಿರೋಧವಾಗಿ ಉಪಾಧ್ಯಕ್ಷರ ಸ್ಥಾನಕ್ಕೆ ಆಯ್ಕೆಯಾಗಿದ್ದರು. 4ನೇ ಎದುರುದಾರರು ವೇಳಾಪಟ್ಟಿಯಲ್ಲಿ ನಮೂದಿಸಿದ ಸಮಯಕ್ಕೆ ತಮ್ಮ ನಾಮಪತ್ರಗಳನ್ನು ಹಿಂಪಡೆದರು ಎಂದರೆ ಸಾಕ್ಷಿ ಆ ಸಮಯದಲ್ಲಿ ಹಿಂಪಡೆಯಲಿಲ್ಲ ಎನ್ನುತ್ತಾರೆ. 4ನೇ ಎದುರುದಾರರು ಆ ದಿನ ಬೆಳಗ್ಗೆ 11:30 ಗಂಟೆಗೆ ತಮ್ಮ ನಾಮಪತ್ರವನ್ನು ಹಿಂಪಡೆದರು. ಅವರು 11:30ಕ್ಕೆ ಹಿಂಪಡೆದರು ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. 4ನೇ ಎದುರಾರು ತಮ್ಮ ನಾಮಪತ್ರವನ್ನು ಹಿಂಪಡೆದ ನಂತರ ನಾನು ಹಾಗೂ 3ನೇ ಎದುರುದಾರರು ಅಧ್ಯಕ್ಷರ ಹುದ್ದೆಗೆ ಸ್ಪರ್ಧಿಸಿದೆವು ಎಂದರೆ ಸರಿ. ಸಮಯಕ್ಕೆ ಸರಿಯಾಗಿ ನಾನು ಎಲ್ಲಾ ಸದಸ್ಯರು ನಮ್ಮ ಮತದಾನ ಮಾಡಿದೆವು ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಮತದಾನವನ್ನು ಮಧ್ಯಾಹ್ನ 1ರಿಂದ 1:15ರವರೆಗೆ ಮಾಡಿದ್ದರು ಎನ್ನುತ್ತಾರೆ. ನೀವು ಸುಳ್ಳು ಸಾಕ್ಷಿ ನುಡಿಯುತ್ತಿದ್ದೀರಿ ಎಂದರೆ ಸರಿಯಲ್ಲ. ವೇಳಾಪಟ್ಟಿಯಂತೆ ಚುನಾವಣಾಧಿಕಾರಿ ಮತಗಳನ್ನು ಎಣಿಸಿದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸರಿಯಾದ ಸಮಯಕ್ಕೆ ಚುನಾವಣಾ ಪ್ರಕ್ರಿಯೆಯನ್ನು 11ನೇ ಎದುರುದಾರರು ಮುಗಿಸಿದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಚುನಾವಣಾಧಿಕಾರಿ ನನ್ನ ಎಲ್ಲಾ ಕರ್ತವ್ಯಗಳನ್ನು ಚಾಚೂ ತಪ್ಪದೆ ಸರಿಯಾದ ಸಮಯಕ್ಕೆ ವೇಳಾಪಟ್ಟಿಯಂತೆ ಮಾಡಿದರೂ ಸಹ ನಾನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸುಳ್ಳು ಹೇಳಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಚುನಾವಣಾಧಿಕಾರಿ ಮತಗಳನ್ನು ಎಣಿಕೆ ಮಾಡಿದಾಗ ಎದುರುದಾರಿಗೆ 4 ನನಗೆ 4 ಮತಗಳು ಬಂದಿದ್ದವು ಎಂದರೆ ಸಾಕ್ಷಿ ನನಗೆ 5 ಮತಗಳು ಬಂದಿದ್ದರು ಎದುರುದಾರಿಗೆ 4 ಮತಗಳು ಬಂದಿದ್ದವು ಎನ್ನುತ್ತಾರೆ. 1 ಮತ್ತು ನಿಶಾನೆ 1ರ ನಿಯಮಗಳಂತೆ ಮತ ಚಲಾಯಿಸದೆ ಕ್ರಮ ಸಂಖ್ಯೆ ಬಳಿ ಹಾಕಿದ್ದಾರೆ. ಆದುದರಿಂದ ಅದನ್ನು ಚುನಾವಣಾಧಿಕಾರಿಗಳು ಅಸಿಂಧು ಮತ ಎಂದು ಘೋಷಿಸಿದರು ಎಂದರೆ ಸರಿ. ಕೈಂಡ್ಲಿ ಅಬ್ಸರ್ವ್ ದಿಸ್. ನನಗೆ 4 ಮತ್ತು 3ನೇ ಎದುರುದಾರಿಗೆ 4 ಮತಗಳು ಸಮವಾಗಿ ಬಂದವು ಎಂದರೆ ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ನಿಶಾನೆ R2 ನನಗೆ ಬಂದ ಮತ ಎಂದು ನಾನು ಚುನಾವಣಾಧಿಕಾರಿಗೆ ಹೇಳಿದೆ ಎನ್ನುತ್ತಾರೆ. ಚುನಾವಣಾಧಿಕಾರಿಯು ನನಗೆ ಮತ್ತು 3ನೇ ಎದುರುದಾರಿಗೆ ಸಮನಾದ ಮತ ಬಂದಿದ್ದರಿಂದ ಲಾಟರಿ ಎತ್ತುವ ಮೂಲಕ ಅಧ್ಯಕ್ಷರನ್ನು ಆಯ್ಕೆ ಮಾಡಲು ಪ್ರಕ್ರಿಯೆ ಮುಂದುವರೆಸಿದರು. ಎಲ್ಲಾ ಸದಸ್ಯರ ಅಭಿಪ್ರಾಯವನ್ನು ಪಡೆದಾಗ ನಾನು ಸಹ ನನ್ನ ಒಮ್ಮತವನ್ನು ಕೊಟ್ಟೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಿಶಾನೆ R2 ನನಗೆ ಬಂದ ಮತ ಎಂದು ಚುನಾವಣಾಧಿಕಾರಿ ನಾನು ಬರವಣಿಗೆಯಲ್ಲಿ ತಕರಾರು ಕೊಡಲಿಲ್ಲ. ಸದಸ್ಯರೆಲ್ಲರೂ ಒಪ್ಪಿಗೆ ಕೊಟ್ಟಿದ್ದರಿಂದ ಚುನಾವಣಾಧಿಕಾರಿ ಲಾಟರಿ ಎತ್ತುವ ಮೂಲಕ ಅಧ್ಯಕ್ಷರನ್ನು ಆಯ್ಕೆ ಮಾಡುವ ಪ್ರಕ್ರಿಯೆಯನ್ನು ವಿಡಿಯೋ ಮಾಡಿದ್ದಾರೆ ಎಂದರೆ ಸಾಕ್ಷಿ ವಿಡಿಯೋ ಯಾರು ಮಾಡಿದ್ದಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ಸದರಿ ವಿಡಿಯೋನಲ್ಲಿ ನಾನು ಕಾಣುತ್ತಿದ್ದೀರಾ ಎಂದರೆ ಸಾಕ್ಷಿ ಸಭೆಯಲ್ಲಿ ನಾನಿದ್ದೆ ಆದರೆ ಯಾರು ವಿಡಿಯೋ ಮಾಡಿದ್ದಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ನಮ್ಮ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯಲ್ಲಿರುವ ಅಲ್ಲ ನಾನು ಇದ್ದೆ, ನಾನು ಎಲ್ಲೂ ಕೂಡ ಎಲೆಕ್ಷನ್ ಮಾಡದ್ ಬೇಡ ಅಂತಾಗ್ಲಿ ಏನೋ ಆಗ್ಲಿ ಹೇಳಿಲ್ಲ ಅಲ್ಲಿ.
What difference is
He's admitted that.
What difference does it make in law? He is entitled to file an election petition challenging the rejection of one particular vote as
Houdu.
being invalid.
ಹೌದು.
The trial court has held that the rejection was invalid because it is a permissible way of voting. Against which you put- What is the point in whether a videograph was made, whether he was there, not there? Then what is the point that you're trying?
ಅಲ್ಲ, regarding invalidate vote is concerned, he has not raised any objection in the.
So is there any provision which says you're dissented to challenge the election if you have not raised an objection?
ಅಲ್ಲ, ಇದೆಲ್ಲದೂ ಕೂಡ proceedings ಅಲ್ಲಿ ಬಂದ್ಬಿಡುತ್ತೆ.
ಬರಲ್ಲ ಅದು. ಅಲ್ಲ, for election petition to succeed, there are set parameters. We can't go beyond that.
ಇದ್ರಲ್ಲಿ judgment may pass it on this. This is regarding election to Andhra Pradesh Assembly election matter. Para number 35. The first objection raised on behalf of Reddy relates to what happened, my lord. Reddy was the defeated candidate. Mr. Rao was the successful candidate. The first objection raised on behalf of Reddy relates to rejection of 338 votes apparently appearing to have been cast in his favor, but were rejected on the ground that the marks given on them were on the reverse side of the symbol and not on the observed side. Several such votes apparently cast in favor of Rao were also rejected. Mr. Sen.
That was a case where the seal was put behind the ballot paper.
Houdu.
So how is the judgment applicable?
Alla. Behind the paper, where illi one observe side ant heltare.
Because they make a mark on the ballot paper with the instrument supplied for the purpose on or near the symbol of the candidate for whom he intends to vote. But that gentleman had put the seal behind.
And not on the observe side.
Ulta ballot paper ಹಿಂದೆ ಹಾಕಿದ ನಾವು.
ಹೌದು ಹಿಂದೆ ಹಾಕಿರೋದು ಕೇಸ್.
That is invalid because he never put his ballot on the ballot paper. So therefore the Supreme Court said rejection was correct.
ಹೌದು. But ಒಂದೇನಂದ್ರೆ ಇದರಲ್ಲಿ ಅಬ್ಸರ್ವ್ ಸೈಡ್ ಮೀನ್ಸ್ ಮತದಾರನು ಹಾಕುವ ಗುರುತು ಅಂತಾನೆ ಹಾಕಿದಾರಲ್ಲಿ. ಅಲ್ಲಿ ಬಿಟ್ಟು ಅದರ್ ದೆನ್ ದಟ್ ಪ್ಲೇಸ್ ಅಬ್ಸರ್ವ್ ಸೈಡ್ ಆ ಪ್ಲೇಸ್ ಬಿಟ್ಟು ಬೇರೆ ಇನ್ ಯಾವ ಸೈಡು ದೇ ಕಾಂಟ್ ವೋಟ್. I put my sincere efforts, my lord.
I know I'm not saying anything. I'm just laughing because very strange case where with the skin of your teeth you got through and now.
ಇಲ್ಲ yesterday I went to the senior's office. ಇದು ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಮುಂದೆನೆ ಹಾಕ್ಬೇಕು, ಹಿಂದೆಲ್ಲೂ ಹಾಕಕ್ ಬರೋದಿಲ್ಲ. With respect to the president and vice president is concerned, this is all technical grounds. ಅಲ್ಲಿ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಕೂಡ ಹೇಳಿದ್ದಾರೆ ಹೆಸರಿನ ಮುಂಭಾಗದಲ್ಲಿ ಇಂಟು ಚಿಹ್ನೆಯಲ್ಲಿ ಮಾರ್ಕ್ ಹಾಕ್ಬೇಕು ಅಂತ. ಅದನ್ನ ಬಿಟ್ಟು ಅದಕ್ಕೆ ಅಂತಾನೆ ಜಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ಬಿಟ್ಟು ಬೇರೆ ಇನ್ ಎಲ್ಲ ಹಾಕಿದ್ರು ಕೂಡ
I would have been with you provided that rule stipulation. If the rule contained stipulation that a ballot cast on any place other than the place earmarked would render the vote invalid, you had an absolutely wonderful case.
That rule.
But since the invalidity is restricted to only 2 grounds in that rule 8.
Rule 8, my lord. First portion, my lord, is not complied by the voter.
Maybe so, even if they don't comply with it. Second part should have said, if you do not put the mark at the place earmarked, there are 2 conditions. Moorre condition, no? On ಹೆಸರು ಮುಂಭಾಗ ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ vote invalid ಅಂದ್ರೆ you automatically succeeded.
ಅಲ್ಲ, first portion of that provision, that rule is not complied ಅಂದ್ರೆ ನಾವು second portion ಇವಾಗ
there is an implied rejection. By implication you are saying it is invalid. Rendering a ballot invalid is a statutory rule. It can't be inferred. The degree of invalidity depends on the rule making authority to decide. They say only under these conditions the ballot paper would be invalid. I cannot add one more condition. That's why I kept telling you, if the rule was clear that you cast your vote at any place other than the earmarked place, it's invalid, then there was no argument at all. Because they chose to specify. Suppose the second portion of the order was not at all mentioned in the rule and simply said, ಹೆಸರು ಮುಂಭಾಗ ಹಾಕಬೇಕು ಅಂದಿದ್ರೆ, if it is not done, then I could say there is no vote at all. But the second part explains the invalid votes. I can't go beyond that.
ಈ ಪ್ಲೇಸ್ ಮಾಡಿರೋದು ವೋಟ್ ಹಾಕಕ್ಕಂತಾನೆ.
Correct, ನಾನು ಒಪ್ಕೊಳ್ತೀನಿ. But second part ಅಲ್ಲಿ they should have simply said, if a vote is cast in some other place, it is invalid, matter ends.
If first portion of that provision, rule, my lord, is not complied ಅಂತಂದ್ರೆ ನಾವು second portion ಗೆ ಹೋಗ ಇದೇ ಬರೋದಿಲ್ಲ. ಫಸ್ಟ್ ಪಾರ್ಟ್ ಇಸ್ ನಾಟ್ ಕಂಪ್ಲೈಡ್. ಹೆಸರಿನ ಮುಂಭಾಗದಲ್ಲಿ ವೋಟ್ ಹಾಕಿಲ್ಲ. ವೋಟ್ ಹಾಕಿದ್ರೆ ಹೆಸರಿನ ಮುಂಭಾಗದಲ್ಲಿ ವೋಟ್ ಹಾಕಿ ಅದನ್ನ ಕಾಣದೇ ರೀತಿ ಮಡಿಸಿ ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿರ್ತಾರೆ ಆ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳಿ ಫಸ್ಟ್ ಪಾರ್ಟ್ ಸೇಸ್. ಸೆಕೆಂಡ್ ಪಾರ್ಟ್ ಸಹಿ ಮಾಡಿದ್ರೆ ಈ ತರ. ಫಸ್ಟ್ ಪಾರ್ಟ್ ಹೆಸರಿನ ಮುಂಭಾಗದಲ್ಲಿ ಸಿಗ್ನೇಚರೇ ಹಾಕಿಲ್ಲ, ಆ ಹೆಸರಿನ ಮುಂಭಾಗದಲ್ಲಿ ಮಾರ್ಕೇ ಇಲ್ಲ.
That is the only ground. What is the other one that you said about,
Regarding nomination. With respect to my lord, yesterday,
only this will be sufficient, isn't it?
allala. First thing, my lord, while applying caste certificate for the purpose of contesting election is concerned, procedure ಏನಿದೆ ಅಂತಂದ್ರೆ, we have procedure ಅಂದ್ರೆ, first in a rural side, I am from rural side, we have to apply before the Nemadi Kendra. Nemadi Kendra,
I will say that in the light of this finding of mine, the other ground need not be gone into at all. Why should I go into that unnecessary? Whether you obtained it through Nemdi Kendra or you should obtain it directly, I'll skip that, saying that that is unnecessary. In the light of the finding that I want to
leave it on to my lordship. I put my sincere efforts, my lord.
No, I appreciate it. I just thought that this was such a funny case that one small mistake. Ultimately, in democracy, the guy with the most number of votes should win, not the person who wants to get in through technicality, isn't it?
Alla, electional technicalities.
The technicalities, election petition dismiss.
ಆ judgment ಅಲ್ಲಿ what happened, my lord? Election was set aside. Against which, my lord? Set aside and recounting order ಮಾಡಿದ್ರು. Then the ಎರಡು side ನವರು, they went to the Supreme Court. Supreme Court ಅಲ್ಲಿ winning candidate ನಾವೇನಿದ್ವಲ್ಲ ಅವರಿಗೆ ಅಪೋಲ್ಡ್ ಮಾಡಿದ್ರು.
Number 61. What matter? If you fix a date, your honor, so that.
Put the date, give a date.
So serial number 60. 27.